Good morning, everybody. Welcome back. Happy Monday. Happy June. Happy June. Boy, those days just keep ticking right along. I can't believe we're already in the 7th week of this trial. Somehow it just doesn't feel like it's been that long that we've been sitting here, getting up in the morning, watching this. But here we are. Go back and count through it over the weekend. Week seven, and just now getting to the second day of the defense case. So when we left off on Friday, a couple of things were still lurking in the ether. We had Kelly Dever apparently had been waiting in court or waiting, in the hallway for most of the afternoon, was told to come back today. So that gives us potentially a little bit of an expectation of what we're going to see witness-wise. And then the other person who was on the stand, I want to make sure I get this person's name correct. We had a voir dire with this individual, Jonathan Diamandis. Jonathan Diamandis, who is a friend of Michael Proctor, was part of the group chat where Michael Proctor said all the highly inappropriate things about Karen and about, no shit on the homeowner and so forth. The day of the investigation, okay, January the 29th, he gets on this group chat with his friends and starts saying all these things. So we had a voir dire from this individual because he is being offered to authenticate the text messages. Brennan doesn't want them to be able to get the text messages in through another witness. He wants them to have to call Trooper Proctor. They want the messages in. And then, that opens the door for him to have Proctor on cross-examination to ask, pretty much whatever he wants. Normally, it would be limited to the scope of direct. But do we think Judge Cannone is going to limit Brennan to directing Michael Proctor on issues that exceed the scope of what the defense has raised? That seems somewhat unlikely to me. But so the $1 million question we're waiting for at this point is she going to let them use this guy to bring in the text messages? So I ran down some rabbit holes over the weekend, right? I had to read some Massachusetts cases about what do they have to do to get these in? What's the requirement? So I found a couple of things that I want to go ahead and share. It's a little obnoxious because it's kind of hard to read, but I'm going to go ahead and bring that in. So I found this one case in particular where it's from 2010. It's dealing with MySpace messages. This is a case where the messages were they did not clear the bar of authenticity, so they should not have been allowed in the first place. So let's just go ahead and spell this out. What are they doing here? Why does it matter? What does it tell us about whether these are likely to come in or not? So in this particular case, somebody had, one of the witnesses had been receiving MySpace messages from somebody that they thought was the defendant's brother. The messages were encouraging them, don't testify, don't show up to court, that type of thing. And so the question here was who actually sent the MySpace messages. Why is that the question? Because that's one of the things you have to prove if you're gonna try to admit a communication. You have to authenticate it. Normally, most communications, you're having them face to face with somebody. There's really no question about who they are and did they say it. A witness says they did. That's enough to get over the hurdle. Then the witness can get on the stand and deny it. And the jury will decide which one of these accounts do we think is more credible. But when it comes to a written communication, you have this extra step, right? Because we're not face to face. I don't actually know it's from you. And so what's my basis for thinking it's you? That's what authentication is getting at. So it's very straightforward. An item offered into evidence must be what its proponent represents it to be. That is the basic floor that has to be established for any type of evidence. This thing is what you say it is. And that's why, for example, with the photographs, they're always asking, is this a true and accurate depiction? That type of thing. It is what you say it is. You're not confused about it. You understand it enough to be able to say it is what what I'm saying it is. So authenticity is usually proved by the testimony of a witness, either one, that the thing is what its proponent represents it to be, or two, that circumstances exist which imply that the thing is what its proponent represents it to be. So either directly, I know this is what it is, or circumstantially, we can infer that this is what it is. So when it comes to the written communication, the text message, MySpace message, email, something like that, it's often going to be a combination of those two things. But what we're really trying to establish is that these are the words of the person that I'm attributing them to. So how do I know that? Well, with a text message, you're going to have a source, you're going to have an address or a number, text number or something like that. You're going to have any kind of self-identification that the account gives. The account claims to be a certain person. There may be a history of communicating with that person on the account and knowing, I know that this is the phone number. I know that this is this person's MySpace account. We've communicated that way before. It may be circumstantial based on just some of the things that are said. It's where special knowledge might come in. Hey, I know things that I would only know if I am the person that I'm claiming to be in this text message. So in this particular case, it was not enough. And I find that can be helpful to give us a little bit of a counterpoint of, when is it not met? Let's get that idea first. So in this particular situation, the witness testified that Williams was the defendant's brother, had a picture of himself on the MySpace account. The MySpace name was Do It For It. She testified she had received the messages at issue from Williams, and the document, which is just a printout of the communications, indicated that those messages were in fact sent by the user with the screen name Do It For It and bore a picture of Williams. Noyes testified that she responded to three of the messages and that he sent communications back to her. She did not respond to the fourth. The contents of the messages demonstrate that the sender was familiar with Noyes and the pending criminal cases against the defendant and desired to keep her from testifying. There is insufficient evidence to authenticate the messages, and they should not have been admitted. Let's talk about why. Although it appears that the sender of the messages was using Williams's MySpace page, there is no testimony from Noyes or another regarding how secure such a web page is, who can access a MySpace web page, whether codes are needed for such access, etc. Analogizing a MySpace web page to a telephone call, a witness's testimony that he or she has received an incoming call from a person claiming to be A without more is insufficient evidence to admit the call as a conversation with A. Anybody can pick up the phone and be like, I'm Greta Thunberg. Just to use an example. I'm Greta Thunberg. Tell me, Prince Harry, all about, the bad things that you think about Donald Trump with respect to global warming. Anybody can do that. Just because you say you're Greta Thunberg on the phone doesn't mean you are in fact Greta Thunberg. And so that's why, maybe do a little bit of verification before you go out on a limb, assuming that it's Greta Thunberg. So here, while the foundational testimony established that the messages were sent by someone with access to Williams's MySpace webpage, it did not identify the person who actually sent the communication, nor was there expert testimony that no one other than Williams could communicate from that web page. testimony regarding the contents of the messages should not have been admitted. There was a secondary reason that they shouldn't have brought it in because it tended to imply that the defendant had consciousness of guilt. But this is now a like third hand thing, right? This is the brother communicating. No idea if the defendant knows that the brother is communicating, agrees with what the brother is doing, and so forth. You would need that extra link to attribute the brother's conduct to the defendant. So that was a little bit of an add-on in that particular case. But so here's the problem. The only reason they have to think that this is Williams is just that it's coming from what looks like his MySpace page. But you know, they didn't get into like, could you just go set up a MySpace page under this guy's name? Presumably you can, like you could, you know, with Twitter or something like that. You could just impersonate somebody on the internet and then send messages from them. Here they assume it's his MySpace page, but they don't have any information about that access being private, that access being limited in any kind of way. So now let's compare this to a phone. Similar type of situation, right? Anybody can text from somebody else's phone, pretend to be somebody else through somebody else's phone. But then it gets into circumstantial questions about, well, you know, is there a reason to think that that's what happened here? Or is there a reason to think that's not what happened here? And so that's why in this case, they got into, you've texted with all of these people before, independently, you know, independent of this group chat. So you have a history of communication with these people through this number. So, you know, at the very least, you're able to get Michael Proctor through this number. Michael Proctor, the text communications themselves are going to be talking about information that, you know, you would expect to be limited to Michael Proctor. He's talking about the investigation. He's talking about what they learned. He's the lead investigator. It's logical that it's coming from him and not from like one of his kids, you know, trying to punk people or something like that. So unlike MySpace, I guess we know that the phone number is going to be secure to at least whoever is in possession of the phone. So the fact that Michael Proctor has been in possession of this phone before to be able to communicate with Mr. Diamandis, you know, through this number, is some evidence that it was also him doing it on this occasion. It's not just out of the blue. And then you have that reference to calling him Chip, calling him Chip, using a nickname, something that isn't commonly known about this guy. You know, we had to go through the first trial, I think, before we knew that people called him Chip. I didn't know that people called him Chip until we got into the first trial. So those are all going to be the circumstantial pieces that they're relying on to argue that everybody on the group chat, and particularly this guy who's kind of testifying as a representative of one of those people, they understood it to be Michael Proctor. Why? Because it came from his number, because it's telling information that's in Michael Proctor's exclusive possession, because they're referring to him as Michael Proctor, you know, as Michael Proctor in the way that they know how to do. And they're using nicknames for each other that are, you know, common nicknames that they know, but aren't necessarily publicly known. So there's inside knowledge, so to speak, that is unique to Michael Proctor, tends to confirm that these messages are coming from him. So that's what we're dealing with, guys, when we're talking about authenticity. So based on all that, you think the hurdles been cleared? To me, it's very crystal clear. This hurdle has been cleared. This is his phone number, the one you normally use to communicate with him. You received a communication that's consistent with the kinds of things that he talks about. It's got the kind of knowledge you expect him to have. He knows that he's Chip. You know that he's Chip. To me, this is a pretty done deal. But the $1 million question is Judge Bev going to see it that way? Is Judge Bev going to see it that way? So that's the first step that they have to clear to get these text messages into evidence. They have to authenticate them. So that's what Mr. Diamandis is being called to do. The second thing they have to do is they have to establish that they're relevant and admissible for some purpose. So that's getting into the hearsay argument. This is like the second hurdle that they have to overcome. They have to show that these text messages are not hearsay and are not being offered for a hearsay purpose. To me, that's, again, even easier than authentication. They are not offering these text messages because they want to prove what the text messages say. Okay, they don't want to prove anything about Karen's balloon knot. Okay, that's not what they're offering these text messages for. They're being offered to show that Michael Proctor was biased, that he was careless and unethical, unhonorable, dishonorable in his investigation. It lacked integrity, that there was never a chance he was going to meaningfully investigate alternative theories of what happened at 34 Fairview. So it's not offered for its truth. If it's not offered for its truth, it's not hearsay. It's not hearsay. To me, that bar is probably even easier to clear. And even Hank had to concede that when he was arguing it on Friday. I can't say these don't go to bias. That's good, because it's a fucking obvious they go to bias, okay? Extremely obvious that these text messages go to bias. So even Hank couldn't contest that. He just tried to say, well, Michael Proctor should have to explain it. And Mr. Diamandis, he doesn't remember this text communication. So first off, not remembering the text does not make them inauthentic. Sure, if he had an independent memory of the conversation, that would be helpful, but it's not necessary, because you're not expected to remember every single text message in your phone. And it's not a standard that you remember that text message for that text message to be able to be authentic. There's all kinds of authentication, authentic communications in our phone records and our emails and our text messages and so forth that we sitting here right now have no independent recollection of. But, because of the circumstances, we'd be able to go back and look at it and be like, oh, yeah, this was 6 months ago, but that is my email account. I remember communicating with this person. Seems like the kind of thing I would say. Yeah, that's what I was, talking about. You'd be able to go in and even if I don't remember saying these things or having this conversation with this person, at least recognize enough of the circumstances to be able to say, yeah, this is a thing that actually happened. So the lack of memory is not a good argument against authentication, but it's really all he's got. It's really all he's got. He knows this guy too well. He's communicated with him too many times. There's too much else here to suggest that it is, in fact, what it is. But even he couldn't argue with bias. Of course, there's a non-hearsay purpose for it. It's for bias. He just thinks that you should have to confront Michael Proctor with that. No, Michael Proctor is not the one on trial. He doesn't have a confrontation right. Karen can call him or not. If he thinks that Michael Proctor should have an opportunity to get into the text messages and explain them, then he should have the opportunity to be able to do that. So I don't think so. Let's start with the standpoint that, I do think Bev is working overtime trying to find a way to not allow them to do this. She wants them to have to call Proctor. This is an easy workaround. It's an easy workaround. And guys, another thing I saw a lot of comments and questions about, if they are able to authenticate the texts through this witness, this friend of Michael Proctor's, that does not mean that they need to make him read them. Okay, that does not mean they need to put this guy on the stand to read through all of the gross things that Michael Proctor said about Karen. That's not how they have to present it. If they can meet the burden to get the text into evidence, show they're authentic, show that they're relevant and admissible, then they can present them to the jury in whatever format that they want. We've seen several occasions where Hank Brennan has gotten a report into evidence and he's never shown it to the jury. It's just kind of there and we've never published it. He's never talked about it. It's just kind of been dumped in because those basic thresholds have been met. So that's an option. They can get the text message stream, the chain into evidence and never talk about it. Just bring it up in closing or something like that. Or if they have a witness who there's credible questions to ask them about the text messages, then they can ask that witness.
Please be seated. Court is in session.
Oops. Pardon me.
So, Mr. Alessi, I was told you wanted to see me?
Yes, can I just have a moment with Mr. Brennan?
Okay, sure.
With regard to the lawsuit.
Of course she wants to see them.
Dr. Russell.
Of course, we're going to start at sidebar.
You don't want to agree to.
Yes, no, they don't agree. Of course, Hank doesn't agree. So I did see, looks like there have been...
Resolve the matter with Mr. Brennan that would have been the subject of that.
Okay, great. Thank you very much. So I appreciate getting the redacted text messages over the weekend. Mr. Yanetti, this is yours, right? So, Mr. Brennan, I'm letting the text messages in over the Commonwealth's objection. I find that they're properly authenticated and that they do go to...
Can I turn the stand off?
Yes, can we turn...
And they do go to bias. She couldn't find a way, man. She couldn't find a way.
So I do find that they're properly authenticated, and I find that they come in as they go to the state of mind of Trooper Proctor, specifically as that goes to potentially reflecting any bias or omissions in the police investigation. So I'll give a limiting instruction at the time they come in. I understand that what was still remaining with disagreement are in orange. So I've got rulings on those. I don't think we need argument. We've heard plenty of argument on this. So regarding the first page with the numbers, I think we should do it the way I inquired about them last week, with just the last two numbers, not the last four. So those reductions will have to be made. I think the first page with disagreement is on page 02537. Is that right?
Correct.
Okay, so the first one from Bird saying something stinks, I'm going to allow that in. And then there's a message that you both agree to in yellow. And then for the orange, all I'm going to let in out of that is gotta be, and that's where it ends. So you'll have to redact out the rest of that, Mr. Yanetti. And the next page, and the only other one was 02539, is that right?
Correct.
So that comes out. All right, that's it. I don't know whose objections they were. Those are my rulings. All right, can we bring the jury in, please?
So a few limitations on, it sounds like, the messages from the friends. The messages from the friends have to fit their own context. They have to fit their own hearsay exception, right? And since the friends' state of minds, their states of mind are not at issue in the case, that's not relevant. It's not going to be the same exception that's going to work. And so the only way to really fit it, I think, is that the friends' statements are necessary context to understand what Proctor is talking about. So once again, they're not being offered for the truth. They're just being offered to put Proctor's statements in context so that we understand what he's talking about, what he's responding to, etc. So if there's more than is necessary for that, then it's not necessarily going to satisfy that that particular exception. Now, folks have Trooper Proctor's text messages out there. In fact, I think I saw over the weekend, Brandy Churchwell in particular might have put something out. Pretty sure it was Brandy. Yeah, it sure was. It sure was. She's got some of this written out. The whole something stinks. That is somebody saying, I assume you guys are out to make it cut and dry since it involves cops, and then something stinks. So sounds like all of that is going to come in. And then the gotta be statement, Proctor is saying, yeah, there'll be some serious charges brought on the girl. And this friend says, gotta be, I can only imagine what internal affairs at the BPD are trying to get out there. Internal affairs at the BPD, at the Boston Police Department, they're going to be trying to get something out there about John or about Brian Albert. I don't know. This isn't totally clear, but yeah, it doesn't necessarily go to anything, you know, that we need to hear in this particular case. The BPD, not really going to take issue with that. The last one, I'm not sure what that statement is. She's very vague about it. So I'm not sure what's not being allowed in. But by and large, I gotta say, sometimes Bev does impress me. Sometimes she gets it right. She got this one right. It's absolutely admissible.
Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable Beverly Cannone, the Justice of the Superior Court, holding in Dedham, within and for the County of Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is in session. Please be seated.
So good morning again, counsel. Good morning, Ms. Reed. Good morning, jurors. I hope you had a nice weekend. I do have those questions I need to ask you. Was everyone able to follow my instructions and refrain from discussing this case with anyone since we left on Friday? Yes. Everyone said yes or nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case? Everyone said yes and nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left last week? Everyone said no. All right, thank you very much. Mr. Yanetti?
Thank you very much, Your Honor. The defense calls Jonathan Diamandis.
All right. So we're going to just go ahead and get that taken care of right now. Get those text messages in.
Step up, face the court, raise your right hand.
You solemnly swear the evidence you give to the court and jury in the case now and herein should be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you.
Thank you.
Good morning.
Morning.
May I proceed, Your Honor?
Yes.
Good morning, sir. Would you please state your name and spell your last name?
Jonathan Diamandis, Diamandis.
Sir, do you know former Trooper Michael Proctor?
I do.
How do you know him?
We've been friends since middle school, approximately 30 years.
And in what town?
Canton, Massachusetts.
Did you graduate high school with Michael Proctor?
I did.
When was that?
2000.
Oh, no.
How close did you remain in contact with Michael Proctor after high school?
Very close.
Do you have his cell number?
I do.
How often have you texted him over the years?
Frequently.
And when you text him, is that a direct one-to-one or part of a group chat or both?
Both.
And I want to direct your attention to one particular group chat that had 9 people on it. Do you know the one I'm referring to?
I do.
And what one is that?
It's one that's been in existence for many years. We've been texting on that text chain for 10 plus years, I would suggest.
Okay. And over those 10 years, the members of that group chat, I'm not asking you for names, but if you could tell me, where are these people from? How do you know them?
We all grew up together and went to school together at some point.
All from Canton?
All from Canton.
And with regard to the 9 people on that group chat, you're one of them?
Correct.
And whether or not Michael Proctor is on that group chat with the rest of your high school friends as well?
He is, yes.
May I have the exhibit that was marked for identification, please? I apologize, I don't recall the triple letter. Would have been the last one from Friday.
10-year group chat.
It's triple N as in Nancy.
How many cases has he talked about on that group chat?
And Your Honor, may I approach the witness for the purpose of handling
Yes.
this? And I've handed you what has been marked triple N for identification. Do you recognize that, sir?
I do.
Have you seen that before?
Yes, I was shown it last Friday.
And what do you recognize it to be?
A portion of our text chain.
Okay, and when you say a portion, it's a limited time period within a much longer text chain. Is that fair to say?
That's correct.
And with regard to how you're able to recognize it, I'd like to just ask you a few questions. First of all, on the first page of that document, do you see a series of phone numbers?
I do.
And do you recognize your phone number on that text chain?
Yes.
And having reviewed that text chain on Friday, did you see that you had actually sent one text of the whole body of text that's included in what has been marked triple N for identification?
Yes.
In order to send that text message as of late January, early February of 2022, did your phone have a passcode on it?
Yes.
Have you had that for several years?
Yes.
In order to send a text chain, do you have to enter the passcode to your phone first to unlock it?
Correct.
And so it would have been you who sent that message.
Yes.
And having reviewed the content of that text chain, were you able to identify which entries were typed and sent by Michael Proctor?
Yes.
Who is he on that text chain?
He's listed as local user.
Okay, and it says local user, and there's a bunch of letters and numbers after that.
Correct.
Everybody else is identified by a phone number,
Yes, or a nickname.
and actually, even the ones with a nickname have a phone number, correct?
Correct. Yes.
So 3 of them have nicknames, correct?
Yeah, I see 2 on the first page here.
Do you see of the
Oh, third on the bottom. Yes, I see 3.
So you see 3 there?
Yes. Yes.
And so of the 9, we have 3 nicknames with phone numbers, right?
Mm-hmm. Yes.
We have 8 phone numbers total, right?
Yes.
And 1 local user.
Correct.
And you've testified the local user is Michael Proctor.
Correct.
And having known Michael Proctor for as long as you have, does he have any nicknames?
He does.
And what are his nicknames?
Chip and Bear.
Bear.
Chip, C-H-I-P,
Yes.
and Bear, B-E-A-R.
Correct.
And having reviewed that text chain, is that a true and accurate document documenting the texts that were sent in that chain for the time period that is listed on triple N for identification?
Yes.
Your Honor, I would offer that subject to our discussions outside the presence of the jury.
Okay.
Bear. That's almost
May
as
I
embarrassing
take
as
that notice?
Yes.
there's a lot of what's in these texts.
609. Thank you.
I have no further questions. Thank you, sir.
Thank you.
Brennan? Can I have exhibit 209 when it's ready, please? Thank you.
Oh, is
Good morning, sir.
Good morning.
Have we met before?
Brennan going to make him read the text?
On Friday, I saw you. We didn't meet.
You had been friends with Mr. Proctor for about 30 years.
Yes,
Are you still friends with him?
I am.
Are you still close with him?
I am.
You were on a text chain with Mr. Proctor over the years.
Correct.
Did that include other friends of yours and Mr. Proctor's?
Did.
The extent of that text chain, did it go back many, many years?
Yes.
Have you ever looked at any records that summarize some of that text chain?
Yes.
Did it note that there were over 38,000 texts in that group?
Ooh.
I did notice the number, but it sounds accurate.
When there is conversations in that group, do you always respond to the conversation?
No.
There's a particular section or segment of those 38,707 text messages that were shown to you. Did you see that document?
I did.
Are you familiar with it now that you've seen it?
Now that I've seen it, yes.
In that document, are there inappropriate comments that your friend Michael Proctor made about one of his investigations?
There are.
Was it about this case here?
It was.
In those inappropriate comments, did other people on that text chain, not you, comment or respond to Mr. Proctor?
Yes.
In that text chain where Mr. Proctor made inappropriate comments, you did not respond to any of those inappropriate comments, did you?
Correct.
You're on the text chain at a point later on in conversations, but not relevant to the inappropriate comments.
Correct.
Did you know that Mr. Proctor was fired by the Massachusetts State Police because of his inappropriate comments?
Objection.
I'm going to allow that.
May we approach, please?
Sure.
If he's going to be able to say why he was fired, get into the reason, then I would think this is opening the door for the defense to be able to point out all the other reasons, such as the bias. The bias, if you want to get into the findings, I think you're going to get all of them. I think you're going to get all the findings. Brennan wants it to sit with the jury and just leave the implication that this is the only reason why he was fired. That one, it was dealt with, and two, it was just because he used some bad words or some distasteful language or something like that. So if he wants to open that door, I think that needs to be broadly opened. Why was he fired? Well, there's a whole series of findings and a basis and so forth. So you want to get into some of it, you should be subject to all of it. It is also technically beyond the scope, but I don't know that in and of itself matters too much.
Last question and answer.
Oh, strike it. Take it back.
Sir, do you know if Mr. Proctor was fired from the Massachusetts State Police?
I do.
Did he tell you why?
It was in connection to this case. I believe it was based on his text messages that were sent to us.
Based on these comments that are an exhibit?
Correct.
Did you at any time ever defend or endorse these comments?
I did not.
Did you ever encourage him in his comments?
I did not.
May I approach?
Yes.
I'm handing you exhibit 209.
Thank you.
Brennan's going to make him read them. Okay.
On the first page, ending in the numbers 27, there's a fuller number, but I'll just use the last two numbers. Bottom right, 27. Is there a number of redacted phone numbers?
I'm sorry, on the first page on the bottom of the page?
If you look to the bottom right of the page, there's a number on it?
Oh, yes, and then it's blacked out next to it?
Yes.
Yes.
The last two numbers, is it 27?
Yes, it is.
When you look at that first page, does it have a number of redacted phone numbers of different people?
I don't see anything redacted.
The top box, are there numbers?
There are
Phone
numbers, yes.
Are they partially blacked out?
No, the display names, it just lists phone numbers.
Okay. Are those numbers you recognize as the group of friends, including Michael Proctor?
They are.
Someone needs to
As
get
you
up with
read
the
down that
Sharpie
first
and
box and go
take care
down
of
to
that.
number of messages, do you see that?
Oh, yes,
Is it 38,707?
yes,
Is that for a time period between October 18, 2021 and August 31st, 2022?
yes.
I'd like you to look at the third text message that begins with Chip. Without saying who it is, do you recognize that as one of the people in the group?
I do.
And what did the person write?
Chip, name of that BPD cop.
And at the time this conversation was happening, were you part of this immediate conversation?
I was not.
Turn the page. Bottom right number is ending in 28. Do you see that page?
Yes,
Okay. Instead of a name, there's a local user with an ID. Is that Mr. Proctor's?
yes, it is.
And does he respond to Chip, name of that BPD cop?
He does.
What does he say?
John O'Keefe.
What is the next question from somebody in the group?
How old?
And what does Mr. Proctor respond?
He took custody of his sister's kids.
The next one?
She died of cancer and the father overdosed on her grave.
And then one of the group sends a message. What do they say?
Oh man, that's rough.
And what's Mr. Proctor's response?
Mid-40s.
Does somebody in the group then post a Facebook posting?
Yes,
Do you know what that's about?
I do not.
You can turn the page ending bottom right 29.
Yes,
Somebody in the group ask another question.
yes.
What do they say?
What's that? Don't have the book anymore.
If you could just speak up just a little so it's hard to hear with the fan on, not your
Sure.
fault.
What's that? Don't have the book anymore.
How does Mr. Proctor respond?
This one is a nightmare. Forget about the kids. That's awful.
And then I'd like you to go down to Mr. Proctor's next comment.
But all the powers that be want answer ASAP.
And what does one of the group respond with?
Gotcha.
Mr. Proctor,
Couldn't open it either.
do you know what he was talking about when he said he couldn't open it?
I'm guessing the Facebook link.
I'd like you to turn forward to bottom right 3-1. Do you see what that is?
Yes, I do.
What is it?
John O'Keefe's Facebook page.
What does it tell us about John O'Keefe?
He went to Braintree High School, studied criminal justice at Northeastern, joined Facebook in 2008.
Turn the page, please. The first line from Bird, and I'll note this is January 29, 2022
From
at
Bird.
10:56:39 p.m. Did I read that accurately?
Yes,
And what does the person say?
I'm sure the owner of the house will receive some shit.
And could you read Mr. Proctor's two responses?
Nope. Homeowner is a Boston cop too.
If you could turn to the next page, ending on 33. This is January 29, 2022 at 10:57:21 p.m. Could you read Mr. Proctor's two comments?
She waffled him. I looked at his body at the hospital.
And one of the group asks a question.
She waffled him in quotation marks.
And how does he respond?
He was banged up.
Somebody in the group asks another question. What do they ask?
I thought he was drunk. Did he get beat up?
And Mr. Proctor's response?
Nope.
Turn to the next page, ending in 34. This is at around 10:58:06 p.m., running through 10:59 p.m. Another question from the group. What did they ask?
So the owner of the house was a woman cop that beat him.
And Mr. Proctor's two responses?
That's what I initially thought after talking to Canton paramedic. Then I saw the guy.
One of the group asks further down, what does... Sir, if you could either speak much louder or bring the microphone closer. We have a couple fans back here. It's just difficult to hear you.
Okay, sorry about that.
That's not your fault. If we can keep our voice up. So one of the group asks, what does, quote, she waffled him, quote, end quote, mean? And then asks, what's the story? Does Mr. Proctor return?
He does.
What does he say?
She hit him with her car.
Turn to the next page, please, ending in 3-5. And these texts are from 10:59:13 p.m. to 11:08 p.m. The person by the name of Bird asks a question. What does he ask? What does he say?
Okay, that's fucked up.
How does Mr. Proctor respond?
Intentional or not?
And somebody in the group again?
Gotcha. He was frozen in the driveway and she didn't see him.
And Mr. Proctor's two responses?
That's another animal we won't be able to prove.
And the next one?
They arrived at the house together, got into an argument. She was driving and left.
What does the friend say?
What's the name of the Canton cop living in Canton? The other one involved.
What does Mr. Proctor say?
Biffed him.
Turn to the next page, ending in 3-6. These run from January 29, 2022, 11 p.m. and 11 seconds to January 29, 2022, 11 p.m., 39 seconds. The first comment by somebody in the group.
The BPD have any jurisdiction here because it was their own?
And then if you could look where there's a comment from Whitey at 11 p.m., 27 seconds.
Whitey.
Liz has got the blueprint.
Liz has got the blueprint. Do you know who Liz is?
No.
Okay.
Liz Proctor?
And what's the next comment by Mr. Proctor?
Oh.
Knockhat. It's the total opposite. They have to rescue themselves.
What it's
Recuse themselves, excuse me.
Recuse themselves?
Yes.
And then a comment by somebody in the group?
Laughed at. Liz has got the blueprint.
On the next page, Mr. Proctor's comment?
Same with Canton.
At January 29, 2022, 11:02 p.m. and 15 seconds, there's a comment from one person in the group, number ending in 5051. Could you read that?
But I assume you guys are out to make it cut and dry since it involves cops.
Next comment by Bird.
Something stinks.
And the comment by Mr. Proctor.
Yeah, but there will be some serious charges brought on the girl.
And the beginning of the next sentence is gotta be. And finally, the last comment on that page.
She hot at least.
And that's a question mark.
Yes.
Turn the page, please. Ending in 3-8. These messages begin at 11:05:57 p.m., run through 11:06:39 p.m. on January 29, 2022. Does it begin with comments from Mr. Proctor?
It does.
Could you read all of them, please?
These are not my words. I'm not really comfortable reading these. Do I have to say these words out loud?
So I'm going to see you at sidebar.
Witness doesn't like that. He didn't say this stuff. Oof. So, why is this happening? Here's kind of how I see it. First, remember that sidebar? That sidebar came in response to the question about whether this witness knew that Michael Proctor was fired because of these messages. They had a whole conference because of that. Then they came back and he asked about Proctor saying he was fired in connection with the case based on the text messages. So they've set it up as this is how Proctor has spun why he was fired. That's his take on it. That should, at least in theory, open the door to, at least if Proctor ends up on the stand, potentially
Thank you. Sir, I'm
examining
appreciating that you're not comfortable with
why
these
he
words.
was
These are
fired.
not your words, are they?
No, they're not.
You didn't see them at the time?
I did not.
You've never condoned them or adopted them?
No,
In fact, you would denounce these, wouldn't you?
I would.
I don't want you to say words that are not yours. So I'll say the words, and I'm going to ask you if I'm reading accurately. Is that better?
Yes.
Is that a fairer way to do it?
Yes, it is. Thank you.
Okay. On January 29, 2022, 11 p.m., 5 minutes, 57 seconds. And this page ends at 11 p.m., 6 minutes, 39 seconds on January 29, 2022, ending in numbers 38. Did I read that correctly?
Yes.
Mr. Proctor says, from all accounts, he didn't do a thing wrong. She's a whack job, and then uses the C word to describe. Is that accurate?
That's accurate.
He then says, yeah, she's a babe. Weird Fall River accent, though. No ass. Are those the words that he wrote?
Those are the words.
And there's a response at the bottom from one member in the group stating, oh, she's skating.
Yes.
Let's turn the page, ending in 3-9. These begin in January 29, 2022, 11:06 p.m., 55 seconds. Is that accurate?
Yes, it is.
Mr. Proctor responds, zero chance she skated. She's effed. She's fucked.
Yes,
Is that what he said?
it is.
And then one person in the group says, no ass bitch. Accurate?
Yes, that's accurate.
Mr. Proctor, there's a response, laughed at, quote, no ass bitch.
Yes.
If you could turn to the page that ends in 4-3. You ready?
Yes.
Okay. Somebody in the group says, is that chick a smoke? And then the same person follows up with a question mark. Accurate?
Accurate.
Mr. Proctor responds, E-H,
Yes.
nut bag, as my chief would say.
Yes.
She's got a leaky balloon knot,
Yes.
leaks poo.
Yes.
Are those the words of Mr. Proctor?
They are.
Did I read those accurately?
You did.
And then a person in the group says, what are you guzzling on? And this is on, well, let me take a step back to be more clear. The comments I just read, those weren't on January 29th. Those were on February 2nd, 2022.
Correct.
And the time is 12:50 p.m. 12:50 and 5 seconds p.m. begin the
Oh,
page.
yes, yes. Beginning of the page. Yes.
These are different in time than the ones we read before, the series of text messages.
Correct.
Okay. And then at the bottom, one of the members of the group says, what are you guzzling on?
Correct.
And that's still February 2nd, 2022, and that's at 1:51:33 p.m.
Yes.
And then if you can turn to page that ends on with numbers 44.
So is he drunk at
Yes.
1:30 in the afternoon? What are you guzzling on?
And this is on February 2nd, 2022, 1:52:24. Mr. Proctor says, nothing, writing a warrant.
That's accurate.
There are no further text messages?
From Mr. Proctor?
Yes, or anybody in this group that you have as part of this exhibit?
That was not the last comment.
Okay, let me look. Okay. Is there another YouTube video?
There is.
You were not part of any of these conversations with Mr. Proctor?
No.
But you're still friends with him?
I am.
In your conversations with Mr. Proctor, has he ever suggested that he planted evidence in this case or any other case?
No,
In your conversations with Mr. Proctor, has he ever suggested framing a defendant, including this defendant?
absolutely not.
In all your conversations with Mr. Proctor, has he ever suggested tampering with evidence in this case or in any other case?
No, absolutely not.
And Mr. Proctor was fired?
He was.
Thank you. I have no further questions.
So this was cherry picking to try to substantiate Proctor's, hearsay assertion here that he was only fired because of these text messages, and then to imply that it's just because of his bad words.
The time Michael Proctor was revealing this information on this high school group chat, was this information public?
I have no memory one way or the other.
At the time Michael Proctor was texting these messages to you and your other high school friends, were Ms. Reed's medical conditions public? Did you know anything about Ms. Reed's medical conditions?
I didn't know anything about this case at all.
Michael Proctor was the one revealing those details about the case to you and anybody on the chat who cared to read them, correct?
Correct.
And you were asked questions about why Michael Proctor was fired, and I believe you answered in a shorthand way for these text messages. Were you aware he was fired for being biased?
I'm not aware of that.
Objection.
So the answer will stand. He's not aware.
Were you aware that he was fired for revealing confidential information about an investigation?
I was not aware of that.
And were you aware that he was also fired for conduct unbecoming a state trooper and a lead investigator in this case?
I was not aware of that.
I have no further questions.
Nope, that's the
You're
risk.
not aware that he was fired for conduct unbecoming because of these text messages?
My understanding was it was due to the text messages. I don't know the other details of the situation.
Do you know he was not fired for any accusations of planting or tampering with evidence?
I do not know that.
Do you know that he was not fired for doing anything to compromise the integrity of the evidence in this investigation?
I do not know that.
All right. So, sir, I am going to let you step down. And then, folks, I have an instruction for you that I should have read at the time the text messages came in. You can leave them right with Madam Court Reporter.
Thank you.
And you're all set. Thank you. All right, so I've told you folks previously, but I've got an additional instruction here. Before, and I think so you know this and you'll hear it at the end of the case as well. Before you consider any electronic communication in your deliberations, you must first find that it is more likely true than not that the person who authored or created or transmitted the communication was in fact the person alleged. And here we've heard it be Michael Proctor and high school friends, the testimony was, I believe. If you do not find it is more likely true than not that the person alleged to have created or sent these messages, then you may not consider the electronic communication in deciding this case. And also here, this text message chain was not being admitted for the truth of what's in the chain, but solely for the limited purpose of weighing the text as they go to Michael Proctor's state of mind. And more specifically, whether or not that state of mind reflects any bias or omissions in the police investigations. So, all right, is there another witness this morning? Okay.
We would ask Officer Kelly Dever to join us, please.
Okay.
Ellie Dever. Mr. Jackson is handling. That'll be interesting. So yeah, seems like it did then open the door to other reasons why Michael Proctor was fired. He's not aware of it, but they're going to be able to, if they have another witness, to be able to get that in. They'll be able to get that in. So that's what happens when you open the door.
You're going to step up, face the clerk, and raise your right hand, please.
You someone tell the others to give the court during the case down here, the truth, the whole truth, and nothing but the truth, so help you God.
I do. Good morning. Morning.
Morning, ma'am. May I inquire?
Yes.
Good morning. Could you state your name and spell your last name for the jurors, please?
Kelly Dever, last name Dever.
And what do you do for a living?
I'm a police officer,
Where are you employed?
Boston Police.
How long have you been so employed with the Boston Police Department?
2 years and a little over 2 months.
Where'd you work before that?
I worked for the Canton Police.
Were you a sworn officer at that time?
At what time?
When
I
you
was
worked for the
employed there?
When you were employed by the Canton Police Department?
Yes, I was.
As a sworn police officer?
Yes.
Okay. What was your duty assignment in January of 2022?
I was a patrol officer.
You're familiar with the case that's presently before the bench, correct?
In some capacity, yes.
Commonwealth versus Karen Reed.
Yes.
All right. Did you ever prepare any kind of report based on any of your conduct or your connection with this case, if there was any connection with this case, while you were a Canton police officer?
No.
Were you ever interviewed by any member of the Canton Police Department in furtherance of their investigation related to the death of John O'Keefe?
No.
Were you ever interviewed by the Massachusetts State Police?
No.
Let me finish the question. I got to finish the question, then you can answer it. It works a little better that way. Were you ever interviewed by any member of the Massachusetts State Police in furtherance of their investigation into the death of John O'Keefe?
No.
Were you ever interviewed by either the Canton Police Department or the Massachusetts State Police with regard to any of your observations on January 28th or January 29th, 2022?
No.
And you never wrote a report about your observations or any observations that you had on January 28th or January 29th, 2022, correct?
No.
That was a double negative. Let me try that a different way. Did you ever write a report about your observations related to January 28th, 2022, January 29th, 2022?
No.
Thank you. As a matter of fact, the first time you were ever interviewed in connection with anything having to do with this case or this investigation related to the death of John O'Keefe was by a separate law enforcement agency, not the Massachusetts State Police, not the Canton Police Department, correct?
Yes.
That was in August of 2023. Is that right?
Yes.
Do you remember the exact date?
No.
August 9th, 2023. Does that sound right? About right?
I know it was the summer of 2023. Okay. So.
Do you think it would refresh your recollection to take a look at a report of that interview?
Yes, because I've never seen it before.
You want to see the 302?
As far as the date is concerned, may I approach?
Yes.
She wants to see the 302.
Take a look at the bottom of that page. Just glance at that and tell me once you familiarize yourself with that face page of that report. Okay. May I approach?
Yes.
Thank you. Do you have that date in mind?
Yes.
Does that refresh your recollection that it was August 9th, 2023?
Yes.
Okay. I want to direct your attention, Officer Dever, to January 28th, 2022. Where were you working? What was your duty assignment on that day, January 28th, moving into January 29th?
Well, 3.5 years later, I remember I was on patrol. I don't remember anything further about this night.
Did you work overnight, like a late shift going into the morning of January 29th?
That was my assigned shift, so
okay.
Yes.
Okay. Who else was working with you on that particular day, if you recall?
Sergeant Good, Officer Mullaney, Officer Seraph, and Officer Pasquarelli.
And what generally was your assignment when you went into work that night on January 28th?
Patrol.
At some point, either that evening or the early morning hours of January 29th, did you note that a call came in related to a person found in the snow, unresponsive in the snow?
Yes.
Tell me about that, the nature of the call, and where were you?
I was in my cruiser. A call came in that said person in a snowbank, something along those lines. Immediately followed by that transmission, my sergeant requested that I come to take over dispatch.
Is that Sergeant Good?
Yes.
Okay. Did you, in fact, respond back to Canton PD to take over dispatch?
Yes, so I was already in the parking lot of the Canton Police while this took place, so I was already at the station.
Did you note whether or not Sergeant Good and or any of the others responded to the location while you stayed back to handle dispatch at the police department?
Yes, that's why I went inside so he could respond.
Were you aware that Sergeant Good, did you have any knowledge at that time that Sergeant Good was familiar with or knew who Brian Albert was?
Objection.
Sustained.
Did you know who Brian Albert was at
No.
that time?
No.
Do you now? At least
Because of
familiar
this
with the
case,
name?
yes.
I spoke over you. I'm so sorry. Based on this case, are you familiar with the name?
The name, yes.
Okay. Did you know Kevin Albert?
No. Oh, the detective Kevin Albert. Yes, I did.
Correct. How did you know Kevin Albert?
He was a detective for the Canton Police.
Were you aware of his relationship to Brian Albert at that time?
No.
Are you now aware of his relationship with Brian Albert?
Yes, from the media.
And what is that relationship as you know it?
Sustained.
Did you know Brian Higgins at that time?
Yes, in passing.
I'm not asking if you're social friends, asking if you knew who he was.
Yes.
How'd you know who Brian Higgins was?
He had an office in the Canton Police.
Was he a sworn police officer?
Not for us.
Was he a sworn federal agent?
Yes.
Worked for ATF?
Yes.
Okay. How long had you known and been familiar with Brian Higgins? Say, for instance, by sight, to be able to recognize who he was.
Sometime during 2020 is when I was probably first familiarized with him, because that's when I was employed with the Canton Police Department first.
Okay. Pass him in the hallways, hi, bye, things like that.
Yes.
Sustained is to form, Mr. Jackson.
Understood. Did you know him by sight?
Yes.
Could you recognize him if you saw him?
2.5 years later, no, but at the time, yes.
I'm not asking you about right now. I'm asking you back in January 2022. Could you recognize him by sight?
Yes.
Did you know who Kenneth Berkowitz was?
Yes.
Who is Kenneth Berkowitz?
He was the chief of the Canton Police.
Obviously very familiar with him. He was your boss, correct?
Yes.
When Sergeant Good instructed you to take over dispatch, explain what that meant.
It meant I walked inside and I sat down in a dispatch room.
Describe the dispatch room. What did that array look like?
There was chairs and computers.
Monitors?
Yes.
Does the dispatch area also have monitors of internal security camera footage?
I know there was camera screens, but I don't know if they were on TVs or computers or where in dispatch they were. I don't recollect where they were or how they would be accessed. They were in the room somewhere. I can't be more specific. I don't remember.
But you do recall seeing that there were monitors that were showing different views of internal security camera footage of Canton PD, correct?
The specifics, no. Were there? Yes.
I don't know what you mean by specifics. I'm asking you, were there monitors that you could look at that showed security camera footage from inside Canton PD, different areas, hallways, corridors, offices, the Sallyport, for instance?
So 2.5 years since I've...
You keep saying 2.5 years later.
So let her finish her answer and then ask a question.
Sure.
It's been years since I've been in that room. They were somewhere in the room. Where cameras were in the Canton Police Department, I don't recall. The media's provided me information since this case took place, and I can't speak on what's my recollection and what's been media provided. There are cameras. I don't know where on my memory where they are.
So has the media informed you that there were internal security monitors at the dispatch location?
So the objection is sustained. Next question.
It shouldn't be. It's a legitimate basis. She introduced it.
From the dispatch room, as you put it. What do you recall being there in terms of monitors?
I remember there was a computer screen that had information about current calls, and then there was a 911 screen next to that. Those are the two computers that I would have been positioned in front of during this time.
As a dispatch officer, by the way, you were a sworn officer at
Yes.
that time, correct? Uniform, badge, gun, the whole works, right?
Yes.
Had you ever been in Sallyport at Canton PD?
Yes.
What's the Sallyport?
A Sallyport is a garage, essentially.
Okay. You were aware that the Sallyport garage had a camera, a security camera?
It would make sense because that's where we bring prisoners to drop them off.
Well, more than just makes sense. I'm asking you, do you recall that it had cameras that serviced the Sallyport garage? Security cameras.
It's where we brought prisoners, so there would be cameras, yes.
Okay, you're saying there would be cameras. I'm asking you, were there cameras?
According to the media, yes. I've seen the footage, so yes, there were cameras.
All right, so hold on. So I'm going to strike that, officer. You have to answer the question based on your own independent knowledge, okay? And if you don't have them, tell us. But you can't reference what you know from the media.
All right. There were cameras in the Sallyport.
Thank you.
Wow. This is what a non-friendly witness looks like, guys.
Do you want to be here today?
I have no relation to this case, so.
I asked you that. I asked you if you want to be here today.
Objection, this isn't direct.
So it's your witness.
I understand.
She can, no comments, just questions, not I understand.
That is a
Do you
question.
want to be here today now?
I am put on the stand in a murder trial. I don't know why I'm here. I have no connection to this case.
You have no idea why you're here?
You've never talked to me. Nobody on the fence seems to talk to me since prior to the first trial. So I don't have any idea why I'm here.
No clue whatsoever, as you sit here, why you might have been called to the stand.
No.
Are you uncomfortable testifying?
No, it's part of my job.
You're a professional police officer, correct?
Correct.
That means you're a professional witness to a certain degree, correct?
In the crimes that I've gone on the stand before, yes, I have been.
And you understand the oath?
Yes, I do.
What is that oath?
The oath is to tell the truth.
The whole truth and nothing but the truth, correct?
Objection.
Sustained.
I'll refer to it. Is there more to that oath when you raise your right hand as a witness?
I'm objecting.
So when you see it, sidebar for just
Sure.
Yeah, honey. Why are you so uncomfortable? You're just a cop being here to do the job. Really? You have no idea what you're here to testify about, but the feds talked to you back in August. And it's never crossed your mind. It might have a little something to do with the conversation that you had with the feds back in August of 2023. Yeah, guys. So this is what an unfriendly witness looks like, and this is why you have to be careful about calling unfriendly witnesses, because they're not there to help you. They're not there to help you, and even if they don't deliberately obstruct, they're going to make you extract everything like you're in the freaking dentist office, okay? And the wisdom teeth are the facts that you need. Like, you're going to have to hold them down, get that little bar thing that they use crammed in there, and get that fact out. Whether you're happy to be there or not. I like this decision by Jackson to just call it out. Go ahead and lean into it. We can see her attitude with the sighs and the exasperation and so forth. So let's go ahead and draw attention to it because it doesn't seem like it fits, does it? It shouldn't be. You're a cop. You're a witness. Why should you be so hostile to coming in and telling a jury about what it is that you observed and know about? January 29th of 2022. No clue why she'd be called. No clue why she'd be called. Well, she was in dispatch, so she heard communications that were going through. If she's running dispatch, then she is doing the entries into the computer assisted dispatch, the CAD log. She's monitoring that. Radio traffic is coming in, chit-chatting about stuff. She's kind of at the center of all of that. Not sure why Ellen wasn't allowed to ask her about did the media tell you there were cameras inside the Canton Police Department Sallyport? If she's going to disclaim knowledge of stuff because she wants to act like she can't separate her own memory from what the media has told her, which frankly, in some respects, is probably true when it comes to details of what she knows about this case or doesn't know about the case. Sure, there's going to be quite a lot of overlap. But if you're going to try to blame that for what you know about the layout at the Canton Police Department, what sort of monitors are available to be able to see things in dispatch and so forth, then you're going to be able to be asked about it. So why is Mr. Jackson not allowed to ask her, did the media tell you that there were cameras inside the Sallyport? I'm not clear to me. Not clear to me at all. To me, that seems like a pretty legitimate line of inquiry for her basic knowledge.
Thank you, Your Honor. May I inquire?
Yes.
Thank you. One of the cameras, one of the monitors that you had access to back on January 29th did show the footage from, or did it show the footage from that one of the other Sallyport garage cameras?
Can you rephrase the question?
Sure, it was a little bit clunky on my part. Did one of the monitors that you looked at, that you had access to at the dispatch area, did it show the video footage or the video feed from the Sallyport garage?
So I already said I don't remember where in dispatch the screen with the cameras was.
Nobody asked that.
There was a camera in the Sallyport. So if I'm going to make the assumption, then yes, of course. But now that's an assumption.
I'm not asking you for an assumption now. I'm asking you, did one of the feeds, now we're talking about the camera, the other side of the camera is the feed. Do you recall whether or not there was footage that you could see on a monitor in the dispatch area that showed the Sallyport?
I'm going to go with yes.
Okay.
Going to go with yes.
How long?
So look, I don't know what that means. So what do you mean you're going to go with yes? Is your answer yes?
Yes.
Yes.
Thank you. What time about
Pulling
did you take
frickin'
over the
teeth.
dispatch desk that morning?
Immediately following when the 911 call came in.
Would have been 6-ish in the morning. Does that sound about right?
Sometime I would say towards the later of my shift, but it was the middle of winter and dark out. So I don't know if it was 4, 5, 6.
Understood. But it was still dark out.
Yes.
Once you took over the dispatch desk, did you stay there even past your normal shift ending to support the investigation that was ongoing?
Not to support the investigation. I was just on overtime.
Okay. So you stayed past your normal end time of your shift that day?
Yes, on overtime.
You stayed into the afternoon, correct?
I believe the shift ended at 3:45 p.m. for the Canton police.
But you stayed past your ending shift time, correct?
Correction.
I'm sorry, I'll rephrase it. Did you stay past your ending shift time?
For my regular shift, yes, because I was on overtime on the day shift.
Did you observe anything unusual that stood out in your mind that occurred, pardon me, in the Sallyport while you were on that shift?
So we've discussed this previously. I can't make that statement on the stand because I've been provided information released by the defense that it was not a memory, that it was a distorted memory. Therefore, I can't state it because at this point it would be a lie. I cannot make that statement that you're wanting me to make on the stand because I've advised that that would be a lie.
Ms. Dever, I've never asked you to make a statement one way or the other on the stand. I'm asking you an open-ended question.
Okay,
Did
so
you,
prior
let
to
me
the
ask
first,
the question. Did you observe something in the Sallyport garage on January 29th, 2022 that you found unusual, that stuck out in your mind?
given factual information that makes it so I know I did not, no.
So the answer is no.
Correct.
Do you remember being interviewed on August 9th, 2023?
I do.
That was by a separate law enforcement agency, correct?
Yes.
2 separate law enforcement agents, is that right?
Yes.
And you were advised during the course of that interview on August 29th of something, correct?
Can you rephrase that?
I'm sorry, August 9th.
So what was I advised of? Can you rephrase that?
Sure. Were you advised that lying to those officers would be a crime?
So it was a willing conversation. I've spoken with their legal team. Because of the fact I was provided factual information that showed a statement of mine was a false memory, it was not a lie. Therefore, I made it in good faith, and I retracted given information that it could not be accurate.
Ms. Dever, did you understand my question?
Yes, I did. You threatened to charge me with perjury during our phone call prior to the first trial if I didn't lie on the stand right now. I'm telling you, I did not see anything. Factually, I've been provided evidence by a timeline that it is not correct.
Ms. Dever, my question was this. Were you advised that it was a crime to lie to those law enforcement agents? Yes or no?
No.
They never told you, they never admonished you that it would be a crime to lie to them?
Objection.
Sustained as to form, Mr. Jackson.
Sure. Did they advise you of anything? Any consequences of lying to them?
So we had a willing conversation.
Yes or no?
I don't recall.
Okay, there's your answer.
You don't recall if they advised you of anything?
No, because it wasn't.
As a trained law enforcement agent.
Go ahead and ask a question, but both of
Just
you
ask
only one
one.
at a time, okay?
As a trained law enforcement officer, are you aware that it's a crime to lie to certain other law enforcement agents?
When you have intent to lie, yes.
Okay. So you knew that when you spoke to these law enforcement officers, correct?
Yes.
Did you tell these law enforcement officers that you, in fact, saw Brian Higgins and Chief Berkowitz go into the Sallyport with the
Objection.
SUV? May I finish my question?
You can finish this question. Go ahead.
Did you tell those law enforcement agents on August 9th, 2023, that you saw Brian Higgins and Chief Berkowitz go into the Sallyport together and alone with the SUV for a wildly long time?
That was my recollection at the time.
So you did say that?
At the time, that is what I recollected.
Okay. Did you indicate that you noted Let me have just a moment, Your Honor.
Sure.
Very defensive about that.
You and I spoke along with Mr. Yanetti and Ms. Little on a conference call last year sometime. You remember that?
Yes.
Between the time that you were interviewed on August 9th, 2023, and when we spoke sometime in maybe it was April or so of last year, does that sound about right?
Yes.
Did you have any conversation with any other party about your potential involvement in this case?
No.
Did you have a conversation with anybody in the commissioner's office at Boston Police Department?
Not about anything malicious.
I didn't use the
That
word
wasn't the
malicious.
question.
Why do you say malicious?
I had a conversation, but it was my department saying, regardless of what I need to say on the stand, they support me.
You were asked to go to the commissioner's office, correct?
Yes.
How long had you been on the Boston Police Department at the time that you were invited to go up to Commissioner Michael Cox's office?
Ooh.
It had to have been before the first trial, so. And I know it was when the agency released information to outside people.
That's not my question.
Okay, so I don't recall.
Okay. You don't recall how long you had been on the force, generally, at the time that you were called up to the commissioner's office, on the Boston Police Department?
No.
Was it 5 years, 2 years, 2 months? Give me a ballpark.
So I've been on the department for 2 years and 2 months. I would say somewhere in the range of a year.
Okay. Did you find it unusual for would you call yourself a rookie back then?
Yes.
Did you find it unusual that a rookie police officer would be called up to the commissioner's office personally to discuss a matter?
It was a reflection of how good of a leader he is. It was not anything that I found unusual, given the fact he is someone who wanted to show support for his officer.
So I'm guessing all of your training class or all of your entry classes at Boston PD, they've all gone up to the commissioner's office as well?
I don't know anyone else who's been in this particular circumstance.
Do you know anybody else who's been called up to the commissioner's office at your level at the Boston Police Department?
Objection.
Sustained.
Do you know of any of your colleagues with your level of experience that have been called up to the commissioner's office for a specific instance?
Objection.
That's sustained.
Now, when you went up to the commissioner's office, did you respond to his indication that he wanted to see you up in his office?
It wasn't a direct line of contact from him.
Okay. Did you respond? Did you ultimately go? That's what I mean by respond. Did you go to his office?
He's my boss, so yes.
Okay. And who else was in that office?
Me and him. The two of us.
General counsel for the Boston Police Department?
No, it's just me and him.
In the conversation that we had last year, did you say that general legal counsel for the Boston Police Department was also there?
Objection.
Not during that conversation.
Objection.
Next question.
Sure. Was there another time that you went to the commissioner's office where general legal counsel was there?
No.
Have you ever met general legal counsel for the Boston Police Department?
Yes.
Was he in the commissioner's office?
No.
When was it?
During my conversation with the agents.
You took a lawyer with you to talk to this other law enforcement agency?
I'm going to see you at Sidebar on this.
She took the Boston Police Department's lawyer with her to talk to the FBI. Oh my God. Okay, so just my impression, total 10,000 foot view here. It doesn't matter anything that she says right now. The hostility is all that you need from this witness. Why would you be so squirrely? Why would you be so defensive about any? Why are you anticipating? Why are you trying to fight Mr. Jackson? You threatened me with perjury if I didn't lie on the stand. You're the one who told the FBI what you saw. Apparently, well, Boston Police Department's lawyer was there with you. Why are you being so anticipating what you're being asked about and defensive about it? Oh, because you know it's a problem. You know it's a problem. Why would you even need reassurance from the commissioner that it would be okay for you to say what you know about other police officers and their activities that morning? Why would you even need that kind of reassurance from the commissioner? Exactly how does that make him a good leader? It should go without saying that, of course, you would do that. Of course you would do that. And it should be unremarkable. It doesn't matter if these are law enforcement officers involved or not. Should it? It shouldn't matter at all. You're there to provide information to investigators, and if that information happens to involve fellow police officers, that should be unremarkable, because it's certainly not like they're a special elect class of humans with impunity to do things that other non-police officer people can do. It's certainly not like there's some type of, I don't know, code of silence or something that would keep you from talking about police officers relative to what you might have to say about other kinds of witnesses. All of this is all that's coming out from her testimony. Like, at this point, I don't think the substance even matters. We are just seeing Thin Blue Line in action. She doesn't want to say anything because it involves other police officers. And boy, does that say a ton. Doesn't that say a ton? Thank you for demonstrating what the whole issue here is. That as soon as there is a law enforcement officer that's in the frame, you guys are going to act like this. Even this witness who, it isn't her case, nothing to do with it, don't know. You're going to come in and act like this instead of just being professional and answering the question and saying what you know, allowing the other side to redirect if there's, more context or whatever.
May I continue, Your Honor?
Yes.
Thank you. Ms. Dever, when we left off, I was asking you about the meeting at the commissioner's office. And I want to clear this up. Was general legal counsel in that office or not when you had a meeting with the commissioner, Michael Cox?
No, it was just me and the commissioner.
At some point, did the commissioner say to you that Boston Police Department, insofar as your connection to this case is concerned, Boston Police Department fully supports you?
Yes.
Did he also say, do the right thing?
That's a direct quote, so I can't recollect if he said a direct quote 2 years ago.
A year ago, when you talked to us, the defense, did you tell the defense that when you were called up to the commissioner's office, he told you two things? Commissioner Cox told you, number one, Boston Police Department supports you, and Officer Deaver, do the right thing.
So he said my name correctly. He said Dever, and
That's my mistake. Let's see, you want me to repeat the question so I get
So,
that right?
Mr. Jackson, let's go ahead and answer, please.
yes, and he said nothing with the intent of guiding me one way or the
I asked you
other.
what his intent was, madam. I asked you what he said to you. What were his words to you?
That he supports me.
And
Just wanted me to tell the truth up here.
his words were, do the right thing, correct?
I don't recall.
How many other times have you testified in a court of law? During the course of your job?
Two dozen, 3 dozen.
And
Actually testified probably ballpark a dozen times.
in any of those other cases, has Commissioner Michael Cox called you up to his office to discuss your testimony in any of those cases?
Great question.
Yes or no?
That's not a yes or a no answer.
Well, yes, it actually is, Ms. Deborah.
So no comments, okay? Just,
You understand the question?
The question, yes. The implication,
The question is.
Nobody's
in
asking
any of
you about
those-
the implication.
I'm asking you an open-ended question. In any of those cases.
If you're so
Officer Deborah,
sensitive about
not
implication,
including this one,
we just want to know why.
has Commissioner Michael Cox ordered you up to his office to discuss your testimony?
no.
Thank you.
all right, Mr. Brennan?
Oh my goodness.
Good
He's going to
morning.
ask you about the false
Good morning,
memory.
sir.
My name's Hank Brennan. We have never met before.
Correct.
Have you ever spoken to me before?
No.
The defense team, Attorney Jackson asked you some questions this morning.
Yes.
It sounds like you've met them before.
Only by phone call.
How many times have you spoken to Attorney Jackson or anybody on the defense team before today?
Prior to the first trial, it was one phone call where we discussed the case. Outside of that, there may have been one other phone call before the first trial, but it wasn't a discussion of the case. And
The
then
first
prior
what?
to this trial,
The first
I
what?
received a phone call that said, confirm you will be available for one of these days.
Other than confirming you'd be available, was there any discussion before this trial with anybody on the defense?
Not about this case, no.
So the conversation, the substantive conversation was before the past event last year?
Yes, a year and a few months ago.
You worked at the Canton Police Department?
Yes, I did.
You were a police officer?
Yes, I was.
And it sounds like on January 29, 2022, at some point you were asked to attend the desk?
Yes.
The desk is at the front of the police department where you see people coming in and out of the police station?
Yes, there's glass windows.
That night, did you have any difficulty with your memory of the specific things that you saw that night?
I was never on the scene. I never spoke to a witness. I never met a victim. I never spoke with a suspect. This was just a random shift for me 3.5 years ago at a desk that I wasn't asked to recollect for about 1.5 years after the occurrences of that night.
Did law enforcement, not the state police or Canton police, did law enforcement ask you about your memory sometime after that night?
The agents asked me about a year and a half later. It was the August of 2023 meeting.
Agency
So
say?
actually a year and 8 months later was the first time I ever spoke about this case.
When they spoke to you a year and 8 months later, did you suggest or share or tell them that you might have seen Chief Berkowitz and Mr. Higgins near the Sallyport area?
I told them on the day of that I saw that. I didn't make any indications it was anything bad. I just said I saw them. And it was in good faith that I believed I saw that. That was the extent of that comment.
So you had told them you believed you saw Mr. Berkowitz and Mr. Higgins in the Sallyport area that day?
On January 29th during my day shift, yes.
Did you then learn any information that helped you remember when your shift ended that day?
So I know my shift ended at 3:45 p.m. So I know that I left then. That wasn't ever one of my questions. The defense released a timeline right prior to the first trial that the vehicle on that day did not arrive in the Sallyport until about an hour and a half after I left, meaning it is not possible that I saw that.
When you saw this information, did you think about your memory?
So when I saw that information, it made it clear to me that there was a distortion of the timeline, and the false memory I created, I provided in good faith, but I retracted immediately, being provided evidence that it was not possible.
Who did you retract it to? Who did you tell?
So I told the defense team prior to the first trial. I also contacted the agents. The agents assured me that good faith.
Not what they said, but what you thought. Not what they said to you. But
Did they threaten to put you in jail when you told them about your mistake?
No, I even spoke with the legal team and they said that I made a comment in good faith. There was absolutely no way that I could be charged with anything of being malicious.
Before we get to your conversation with the defense team, now I wasn't there in that conversation, was I?
No,
Have you ever shared that conversation with me?
I've never shared it with anyone.
Before we get to that, you seem a bit anxious. Are you anxious?
Confused as to why I'm here, but anxious now.
Are you, have you received any negative pushback because of you sharing your memory? Objection.
I'm going to allow that.
No,
Have you received any unwarranted attention from the public or media?
not to my knowledge, but I didn't go digging to find it.
When you mentioned the media sent you something, what did they send you?
So I've seen things in the media. No media has ever been directed for me to find it. It's just this case is unavoidable as a local person on the internet who sees things that get shared.
So inevitably, you were contacted by the defense?
Yes, prior to the first trial.
You mentioned that somebody had suggested you be charged with perjury?
Yes,
Who did that?
one of the male members of the defense team.
Why did they say that to you? Objection.
Sustained.
What were you discussing when you were threatened with perjury?
They were essentially telling me what they were looking for me to say on the stand.
What were they looking for you to say?
They were looking for me to say that I saw Higgins and Berkowitz in the garage with the car.
Did you share with them that that wasn't an accurate memory?
Yes,
How did they respond?
they became very aggressive, raised their voices, and the one word that I can very definitely remember is they said that they would charge me with perjury.
What did they want you to say?
They wanted me to say that statement, although I knew at that point it was not an accurate statement given the timeline.
How many times were you threatened with perjury?
At least once during the phone call, but once you say it once, it was enough.
What else happened during that phone call? Tell us the tenor of it. Tell us the content of it.
That was essentially the thing I remember most because I understood that was what they wanted me to provide for the trial. I was never called for the first trial. Therefore, I'm not exactly sure what else there is for me to say when the one thing that they wanted on the stand, it is factually not correct and cannot be provided.
When they threatened you to charge you with perjury, tell us what your state of mind was, your demeanor.
Disappointment that legal counsel would go that route with someone who is from a factual timeline saying something is incorrect. There was no retracting based on emotion. It was very clear, given the timeline, it could not be correct.
Now, you work for the Boston Police Department?
Yes.
And by the way, when you were with Canton, did you ever talk to anybody about looting or planting evidence or doing anything like that?
No, and this conspiracy theory came out a year and a half later. I was gone.
Did anybody from Canton ever try to suggest to you you should or shouldn't say something to help her side of the case?
No, because I was never spoken to until far after I left.
Did you ever see anybody in this case or any time when you were with Canton doing something improper and tampering with evidence?
Not in this case or any case.
If you had, would you have reported it?
Yes.
Sustain.
Move to strike.
I'll strike that, ladies and gentlemen.
So you transferred to the Boston Police Department. Has anybody from the Boston Police Department ever suggested that you should lean your testimony one way or another?
No.
Has anybody from the Boston Police Department ever given you any rewards or favors for defying the defense position?
No.
Has anybody ever suggested that you should say anything whatsoever that would be unhelpful to the defense?
No.
Has the Norfolk County District Attorney's Office ever encouraged you to testify in any way other than the truth?
No.
When you spoke to the chief of the Boston Police Department, did he in any way ever tell you to shoot your testimony?
Not at all.
When you met with the Boston Police Department Commissioner, did he ever ask you the substance of what your testimony would or wouldn't be under oath?
He made it very clear he did not want to discuss the case at all.
When you spoke to the people of the Boston Police Department, have they ever weighed in any way on what they think you should or shouldn't say?
No.
As you're testifying here today, are you under any tension, undue influence, stress, threat?
There is discomfort with the way that there's attempting to guide what my testimony is, but I don't feel any need to fall into it because I'm here to speak the truth on the stand. That's my livelihood.
When you were threatened with perjury, how long was that conversation with the defense?
I believe it was just about an hour on the phone. My phone log on my physical phone would not go back far enough for me to be able to retrieve the date or the time that that phone call took place.
That conversation lasted an hour?
Approximately.
How did it end?
Not on a good note in the slightest. I remember it was a pretty hasty hang up on both ends.
Thank you for your time.
It's only her livelihood, guys.
May we approach briefly?
Yes.
Only her livelihood, guys. That's all. Why would she be at all worried about what she has to say here on the stand? It's only her livelihood. Oh, haven't we already seen enough to understand that you don't have to be explicitly told? It's the whole point. You already know. You don't have to be told what specifically you need to say or do. These guys are not children.
A male voice on that phone call threatened to charge you with perjury.
Yes.
You're a police officer, correct?
Yes.
Who charges people with crimes?
If a crime is committed, there can be a report of it.
Who
So
charges people with crimes?
in the end, it's going to go through the court system. So the district attorney, the ADAs, that's who pursues it in a court setting.
Have you ever seen a defense attorney charge anybody with a crime?
So you can seek out reporting someone for it.
Have you ever seen a defense attorney charge someone with a crime, ma'am?
Personally, no.
Right.
Right.
The fact of the matter is, nobody ever threatened you with perjury, did they?
Oh, they did. Yes.
That's
I
it.
contacted the FBI regarding it.
Oh, did you?
I did.
The FBI.
I have
Why
an
were you
email
chatting with
conversation
the
where I
FBI?
sent the 2 questions I had. She responded, I will pass these along. I was contacted by their legal team. They reassured me perjury was not applicable because I made a statement in good faith. Upon further information, I retracted it, corrected it, and made it clear that I could no longer say it because I knew that it was not a clear reflection of the events that took place.
That's a mouthful.
Yes.
My question is, do you have a report from the FBI saying that you reported that someone on the Karen Reed defense team threatened to charge you, your words, with perjury? You have a report to that effect?
No.
No. Your job as a police officer is to be objective, isn't it?
Yes.
You're not supposed to take an adversarial position against one side or the other, correct?
I don't.
Just right down the middle, just the facts as you know them, correct?
Yes.
You feel like you're being unbiased in your testimony here today in front of these jurors?
I'm telling the truth.
You think you're being fair to both sides?
All I have to do is tell the truth. If it's not perceived to be fair, that's someone else's opinion.
Let's talk about that truth for a second. What you told those law enforcement agents on August 9th, 2023 was, quote, you recalled seeing Higgins at the station later that day on Saturday. Deborah thought it was also weird that Higgins and Chief Kenny Berkowitz were by themselves in the Sallyport of the police department, by themselves while Karen Reed's car was parked inside. Higgins was a witness and present at the gathering where O'Keefe was found dead outside, and then he was in the presence of important evidence. You were sitting at dispatch by yourself and saw on the camera outside of the Sallyport when they walked in.
Objection to the entire reading.
So beyond the scope, so you have to keep it.
There's
Beyond
more
the
to the statement,
scope.
Your Honor. Do you remember making that statement to the officers?
My recollection of the time was that, so yes.
Okay, great. Did you go on to say, speaking of being truthful, did you go on to say,
I'm objecting.
All right, so you have to ask differently, but I need to see you for a minute with this and bring that with you, please.
Because it's a summary, it's not her verbatim words necessarily taken down. You know, this isn't the first time it's come up in a big trial where an attorney goes and does an interview, and then there is later a dispute about what was said in that interview. This is one of the risks of attorneys conducting interviews of hostile witnesses, unfriendly witnesses, is they may turn around and accuse you of all kinds of things. And then what do? You can't, Alan Jackson can't get on the stand himself and say, no, I didn't accuse anybody of perjury. I didn't threaten to charge anybody with perjury. So how do you deal with that situation? Guys, this is why when you are the defense, you always have an investigator present for your interviews. Always. You always have an investigator present so that there is a witness that you can put on the stand who can say, no, I was here for that entire conversation. I was literally just there to witness it and take notes about it. I played no role in it other than to memorialize, you know, in my own notes or report or whatever, what happened. So I was there for the whole thing. Nobody threatened to charge her with perjury. You always have an investigator present for precisely this reason, because this, again, extremely foreseeable in the course of a trial, that when you interview an unfriendly witness, they will turn around and accuse you of stuff. They'll say you threatened them. They'll say you forced me to say it. They'll say you lied. They'll say, you know, you were mean to them. Why? Because they don't like having to account for what they did in fact say. And so there's blame shifting going on. It's your fault. It's not real. I didn't really say that. It's just you guys being mean. It is the most foreseeable thing ever. So you always is like one of the reasons why you have an investigator at all, so that they can sit in on your witness interviews. If you're going to be the person interviewing the witness and not the investigator themselves, you have them there. You have them there. And this is exactly why. So you might remember this came up before with Deputy Hurd, because Adam Waldman interviewed Josh before trial. Here's a note about the things that Josh told him in the interview prior to the trial. Then, like within days, they go in. Ben Chu goes in and takes Josh's deposition, and his story changes. The story changes from what he told Adam Waldman. How do you get in what Adam Waldman said without me, or what he told Adam Waldman? Without calling Adam Waldman as a witness, you can't. Well, you got to have a investigator there.
May I inquire?
Yes.
Thank you. Officer Dever, did you go on to say in that interview, quote, you never saw them leave, them being Brian Higgins and Chief Ken Berkowitz. You never saw them leave, but you recalled thinking to yourself that they were in the Sallyport for a wildly long time together in there, end quote. Did you say that?
That was my recollection at the time.
Okay.
So yes.
Have you ever heard of By the way, you indicated under questioning by Mr. Brennan that you knew what they wanted from me, meaning the defense, what they wanted from me.
Yes.
You understand that?
Yes.
Do you remember on that phone call that we read directly from the exact same report that I just read from? Remember that?
And I told you the same thing then.
That's not
Yes.
the question.
Objection.
Sustained.
My question is, just answer my question, Officer Dever. Did we read to you, were you read the exact same thing that I just read to you on that phone call?
Like you can't remember my name. I don't remember.
I can remember your name, Miss Dever.
Okay, so the answer is I don't remember. No comment.
More than that, Judge. I think we all.
All right, so no comments, just questions, please.
Is that supposed to be a dunk? Nobody gives a shit about your name because you're not important.
About your
Objection.
comments.
I'm going to allow it.
But we were looking for the truth.
Which I gave you, yes.
Did you also say on that phone call something to the effect of, I know you're going to tear me a new one because I'm changing my testimony?
Changing, no. But you're trying to do that.
Did you say, I know you're going to tear me a new one?
That's what you're trying to do, so yes.
Actually, what you said was, you're going to tear me a new asshole, didn't you?
I don't recall that, so that's putting words in my mouth.
I'm not asking you to put words in your mouth. I'm asking you if you remember saying that during that phone call. Oh, I know
recall.
you're going to tear me a new asshole.
I don't recall.
Okay. But you do remember saying something to the effect of, I know you're going to tear me a new one, right?
Yes.
Okay. Have you ever heard of something called the blue wall of silence?
Objection.
Sustained.
Do you think it's important for police officers to protect one another in the field and out?
Objection.
Sustained.
Have you spoken with anyone, not Mr. Brennan, he's covered that. Have you spoken with anyone from the district attorney's office about your involvement in this case? Ever?
No.
Never?
Unless you're going to provide a person. I've never talked to any of these people.
Have you talked to anyone at the DA's office at all, in any regard?
Not to my recollection.
How about indirectly?
Not to my knowledge.
Are you friends with any people that you're aware of that are connected to this case? Are you personal friends, girlfriends, boyfriends, personal friends with anyone that's connected with this case?
Other people who's been on the witness stand, one person, yes.
Who's that?
Sarah Levinson.
How long have you known Sarah?
We became friends in middle school.
Did you watch any of this trial?
Clips in passing, but No, it's 6 hours a day. So I work during the day shift. No.
So you've seen some of the footage of the goings on in this case, correct?
Yes, nothing with her. I did not watch her testimony.
Were you aware there was a sequestration order?
I don't know what that means, so no.
You're a sworn police officer. You don't know what sequestration means
No.
in terms of witnesses not
No.
watching the proceedings in order to affect their testimony.
No, I wasn't aware.
But you did tune in to the case, correct?
In small clips, yes.
And you did, in fact, on August 9th, 2023, have a fulsome conversation with two sworn police officers about your memory of what you saw, your observations on January 29th, 2022, correct?
I don't know if they're police officers necessarily, but yes.
Law enforcement agents, how about that?
Yes.
You already
And
said
that
they're the
conversation
FBI.
is
You
reflected
let the cat out of the
in
bag.
this piece of paper that I just read to you, correct?
Yes.
Thanks. That's all I have.
Okay.
Were you subpoenaed by the Commonwealth in this case?
No.
You were subpoenaed by the defense.
Yes.
Did they tell you that there was a sequestration order or that you shouldn't watch any of the footage? Did they fairly inform you about what the ground rules were?
No. And I wasn't part of the first trial, so I had no idea about anything to do with this trial.
When you spoke to those law enforcement officers back in 2023, do you know that they made a report where you had informed them that you knew Sarah Levinson, and that report had been provided to the defense a long time ago? Did you know that?
Yes, I informed them very clearly.
So the question about if you know Sarah Levinson, that's no secret in your world, is it?
In that form, I'll sustain it.
That isn't a secret, is it?
Not at all.
That's something you were open and candid about?
Yes.
You understand that regardless of what you say, it doesn't matter as long as it's the truth. Do you understand that?
Yes.
The Commonwealth in no way is asking you to accommodate it or please it in any way. Do you understand that?
Yes.
If there was something that may be perceived by others as adverse to the Commonwealth, you understand we would want you to tell that if it was the truth, don't you?
Sustained.
You understand, well, the Commonwealth has never intimated, suggested, or advised you to say anything other than the truth, have they?
No.
Have you been given any consideration or reward because you remedied your memory?
No.
After being shown the evidence that you left that day, January 29, 2022 at 3:45, and learning that the defendant's car did not get to the Sallyport at 5:30 or so p.m., is there any way you could have seen Mr. Berkowitz and Mr. Higgins in the Sallyport with the defendant's car that night before you left for work?
There is no way.
Understanding you made a mistake, was the defense receptive to your explanation that you made a mistake?
Objection.
Sustained in that form.
Did the defense pressure you when you told them you were going to come into this court and tell the truth about your mistake?
Objection.
I'm going to allow it.
Can you rephrase it?
Yes. When you told the defense you had made a mistake about your memory, did they pressure you?
Yes.
Did they pressure you to say something other than the truth?
Yes, they wanted me to repeat a lie at that point, given it would have been with malicious intent to repeat it.
Understanding a lawyer has no power to charge with contempt, does that change the reality of whether or not you were threatened? Let me ask it a different way. You were asked questions about whether or not you knew who could take out charges for a crime. Yes?
Yes.
Okay. Regardless of whether an attorney has that power, were you threatened that there'd be a charge of perjury if you didn't comply with the defense wishes in this case.
Yes.
And knowing you were going to come into court, given this experience you had with the defense, is that why you felt like they were going to tear you? Is that the phrase we used?
Tear you a new one?
Yes, because they did not want me to tell the truth. So I told them that, knowing they were kind of trying to eat me alive into repeating something that is not the truth.
Rather than to come in here and be attacked, wouldn't it have been easier just to said what you had earlier thought was true?
Objection.
I'm going to allow that.
Wouldn't it be easier just to come in and accommodate them rather than be threatened?
Well, of course.
So why did you come in here?
My entire job revolves around what I say on the stand right now. If I was to lie, I lose my job. I lose everything. I'm here to tell the truth. I cannot lie while sitting on the stand.
Thank you.
One question.
Okay.
Your entire job revolves around what you say on the witness stand. Is that what you just testified to?
Yes.
And if you agreed that what you said to those two law enforcement agents on August 9th, 2023, you would be implicating not one, but two police officers, law enforcement officers, correct? If you agreed with what you said in August of 2023 on this witness stand, you would be implicating two officers, fellow officers, correct?
So I'm confused as to what you're asking.
You would be implicating, if you agreed with me, you have not agreed that that was the truth. You've now indicated that what you told to law enforcement agents in August of 2023 was a lie.
No.
If you agreed with that statement here on the witness stand, you would be implicating two officers as having been in the Sallyport weirdly for a wildly long time with the SUV, implicating not one, but two fellow officers, correct? That's what you would be doing.
It's not possible I saw
If you
that.
agreed with me, would you be implicating the reputations of two officers?
If I was to lie, then yes.
And your entire job revolves around what you say on that witness stand. That's what you said, correct? That's what you just said, Officer Dever, correct?
I still don't really understand the question.
You just said, all I'm asking you is what you just said. I wrote it down. You just said, my entire job revolves around what I say on the witness stand, correct?
Yes to that question.
That's all I have.
I'm confused. When you spoke to those agents, you didn't implicate Chief Berkowitz and Mr. Higgins with doing anything criminal, did you?
No, they were friends. That's why Higgins had an office there.
You didn't implicate them ever suggesting
they were
they had tampered with evidence, did you?
No.
You never implicated them saying that they had framed anybody, did you?
No.
So when you talked to those agents, did you ever suggest that Mr. Higgins and Mr. Berkowitz did anything to touch or tamper with the defendant's Lexus at all?
No.
Never.
No.
Is there anybody you're protecting?
I have no one to protect.
Do you need to protect anybody?
No.
Herself. Made it clear she's protecting herself.
Thank you, Your Honor.
All right, jurors, we'll take a morning recess, 20 minutes.
All rise, please. Close your notebooks and follow me.
Wow. Well. Was that fun or was that fun? Nothing like an unfriendly witness to really get your morning going. So where are we? We got the text in from Jonathan Diamandis. Then Brennan had him go and read some of them out to support Proctor, saying to them he was fired based on his messages in this group chat. That, of course, opened the door to the reasons Proctor was fired that he did not tell them about, the reasons that have nothing to do with the group chat. So he got to go through and, selectively read them. The witness pushed back on reading some of them. They're not his words. He doesn't want to read them. So Brennan got to read some of them himself, but even he wouldn't read the text actually verbatim, would he? He went with the C word. The C word. Which C word is that? Which C word is that, Mr. Brennan? Don't be shy. Go ahead and just own up to the text messages that your lead investigator was sending to his friends at the very inception of this investigation. So, telling everybody, the night of, she's fucked, she waffled him. I looked at his body at the hospital. Yeah, like that was some giveaway. Certainly wasn't a giveaway for the ME, was it? And then the one that really jumps out to me in all of this whole text thread, it always has, is the one from the friends. I assume you guys are out to make it cut and dry. What do you mean by that? What do you mean by you guys are out to make it cut and dry? Don't you just get what evidence there is and document it, and it makes a cut and dry case, or it doesn't? How exactly does your agency, your decision making as a law enforcement officer, give you any flexibility with regard to whether the case is cut and dry or not? What might you do to make it cut and dry? I don't know, maybe like sprinkle a little bit of glass out there, maybe some tail light, maybe some pieces of tail light will suddenly materialize. That one always jumped out at me. I assume you guys are out to make it cut and dry. That gives me those major Mark Furman vibes from back in OJ. If we just happen to have a little bit of extra blood around OJ's house and OJ's car and stuff like that, just helps make it cut and dry. Until you figure out that there is anticoagulant in this blood, and that it wouldn't be there naturally. That blood had to come out of a vial that had anticoagulant in it. Until that comes out, you were just helping make it cut and dry. But then that comes out, and it's not that cut and dry anymore, is it? So, yeah, not aware he was fired for being biased, not aware he was fired for revealing confidential information, and not aware he was fired for conduct unbecoming an officer. Then Hank came back on Recross and tried to suggest the conduct unbecoming was because of the text. No, Hank, you can try to twist it if you want, but the door has been opened now. You opened it, so it's going to be the getting drunk with Kevin Albert and leaving his gun in the car, his gun and his badge. That was the conduct unbecoming from those particular findings. So how do we get those in? I don't know. Maybe we'll call Yuri back to the stand. Maybe we'll call Tully in. Maybe we'll just let it go. Maybe it doesn't even matter. And then boy, Kelly Dever, the just could not have demonstrated more clearly what happens when a defense attorney thinks that a law enforcement officer has information that's helpful to their case. This is textbook what to expect from that law enforcement officer when they have information that may be helpful to your case. You will extract it, if at all, like a wisdom tooth. Okay, you gotta get them restrained on their back, not really able to move, and then get that wedge thing in there that it literally is like a wedge, some of that stuff. It's kind of creepy when I think about it. Whack, whack, get that tooth out. That's what it's like. trying to get information from a cop just there to tell the truth, then why you being so hostile about it? So defensive. Just like you don't remember my name, I don't remember. Well, the difference, honey, is that your name doesn't matter at all. Nobody gives a shit who you are or how your name is pronounced. You are not actually the main character in any of this. You're immaterial, except for the fact that you told the FBI, thanks for making sure the jury heard that, by the way, that it was the FBI that you talked to, and making it clear that last year there was a first trial. Thank you for clarifying that. Because you told the FBI of this very specific and rather detailed memory that you have, which you've now decided you don't remember because your shift ended at 3:45. Now, hypothetically, I can think of a lot of ways why that is not a false memory. Perhaps you stayed after the end of your shift and saw it, or perhaps it occurred the next day and you saw it then, but it's an awfully vivid and specific memory for you to just conjure up out of nowhere with no prompting. Nothing like that. It just spontaneously emerged for some reason that you thought you remembered seeing them there in the Sallyport together with her car for a weirdly long time. Kind of a little strange. Caught your attention even because Higgins is a witness and he's right there in there with some important piece of evidence. Thanks also for letting us know that Berkowitz and Higgins were such good friends that that's even why Higgins had his office at the Canton Police Department. Huh. That's why, because he's good friends with old Chief Burke. That's why Brian Higgins even has that access there in the first place. That is good to know. Gets called up to the commissioner's office at the Boston Police Department. Only about this case, not about the other ones she's testified about, but just this one. Do the right thing. Do the right thing. Do the right thing. Make sure that you shit on that memory that you reported to the FBI as loudly and clearly as possible. And accuse the defense. Make it the defense's fault because they threatened you. Guys, this is why you always got to have, when you're the defense, you always have to have the investigator on the calls. You need to be able to put that person on the stand and say, yeah, she's full of shit. Nobody threatened anybody with anything. They don't have the power to do that anyway. That's why you do it. I mean, ideally you record the interview, but not every witness is going to allow that. So if you can't do it, you got to have your investigator there with you. So what a fun morning this has been. I don't know about you guys, but I'm finding this really fun. Hank having this poor guy read the text messages, which is what people were concerned this weekend, that the defense was going to do that and it was going to make this guy very uncomfortable and make them look bad. No. That's what we have Hank here for. Hank is here to make the witness uncomfortable and feel bad. So he's trying to take the sting out of the text, and he's trying to get out ahead of the defense being able to offer them another way. Like, for example, I don't know, call Yuri back to the stand, which I think they'll probably do anyway, quite frankly. They've already set the stage for that with the first time they got to have a little nibble at Yuri. And his job as the supervisor, Proctor's supervisor, is what gives them the nexus. So remember, Yuri's already testified. He doesn't know anything about these text messages. He doesn't know anything about Michael Proctor's disciplinary, just that it happened, but he doesn't know the findings or the basis or anything like that. But he stands by Michael Proctor and the investigation as showing honor and integrity. So this is your hook. You get to put Yuri back on the stand, introduce to him, present him with these text messages that Michael Proctor was sending the day that the investigation started. And now remember, this is all brand new to Yuri, right? According to what he's testified to, he doesn't know any of this. So it's going to be brand new information to him that he's never heard before. Never heard before. What sort of effect does that have on his judgment about Michael Proctor's integrity and the integrity of the investigation? That's what I'm doing with this if I'm the defense. I'm getting Yuri back on the stand, and we're having a little chit-chat about it. One, because I want to get a read. How good are you at pretending like this is the first time you've ever heard these text messages? Oh no, he didn't say that. Oh, but it's not really that bad. See, it's a very difficult needle to thread, isn't it? I've never heard these before. My goodness. But no, just because he's calling her a whack job C word, and just because he's talking about her medical conditions, and just because he's saying no shit on the homeowner, et cetera, looking to make it cut and dry. Yeah, bringing some serious charges against the girl. Huh, that'll be how to make it stick. How do you thread that needle between, no, this is surprising, I've never heard it before, but it doesn't affect the integrity of Michael Proctor or the investigation in any way whatsoever? That's what I'm doing if I'm the defense. So I think Hank is he's saying that they have their own plan for being able to present those to the jurors. He's trying to head it off at the pass. It's not going to stop them from revisiting it. If they have a witness that they have a basis to ask questions about these text messages, then yes, that witness can be confronted with the text messages and can maybe even be made to read them. So that's where we're at. What a fun morning. I find it a fun what we've gotten to see here. Oh, the wriggling of that police officer. Just show us. Go ahead and show us what the thin blue line looks like. You don't have to admit that that's what it is. We all know you're not going to. We all know you're not going to. But if you're going to come in and recant the statement that you made, the jury gets to evaluate the credibility of that. Guys, domestic violence cases, this happens all the time. It happens all the time. Police respond to a scene, and you're still in the heat of it, and they talk to the people involved, and they get the story from the people involved about what happened, and somebody gets arrested and taken to jail and then charged with a crime, and almost instantly, it's part of the abuse dynamic, guys. And the end is not the end. It's a strange toxic magnetism that these relationships have. And so instantly, there is, no, that's not what I meant. That's not what I said. Take it back. Go in and try to recant the story that was literally just given to police, sometimes even like minutes before. What happens at trial? It gets brought out. It gets brought out, and the circumstances of recanting, what the recantation was, whether it's consistent with the original evidence or not, just all of it goes in front of the jury, and they get to decide, what do we believe? Do we believe the initial report, or do we believe them saying now that the police made that up? Police put those words in your mouth. You never said that. You were misunderstood. You left out the part where, you hit him first. There's probably a list of options for how people recant under circumstances like that. It's fairly limited, but a very common one. They lied about it. They said They said I said that. They misunderstood me. They ignored the part. They didn't write down the part where I told them, I did it first. It was self-defense, anything like that. So it just all goes to the jury and they get to decide, what do we believe? Do we believe the first version or do we believe the recanting? And I'll tell you, this witness's demeanor alone on the stand, before you even get to these surrounding circumstances, like you got called into the commissioner's office about all this. Your attitude on the stand alone is enough to tell me I don't trust your recantation. You seem way too enthusiastic to have a reason why what you told the FBI the first time wasn't true. You're really eager to lean into this false memory explanation for a very detailed and descriptive bit of information that you gave to other law enforcement investigators. What are you doing? First off, you're now putting your credibility at issue in your future investigations, your cases, additional times that you might testify about your ability to accurately recall and report things to other investigators. Did you think about that? Did that cross your mind that there's going to be a transcript of what you said here and that your explanation of this very detailed bit of information that you provided to investigators is that it was a false memory? That transcript is going to be available. And so now in the future, when you go in to testify about very detailed things that you observed, witnessed, whatever, that somebody's going to be able to point out, but you've had a confabulation problem in the past, haven't you? Where you remembered, in fact, some very detailed things. And as it turned out, they weren't true at all. You just made them up in your mind, but you're wanting us to believe that this testimony that you're giving here today is correct and untainted. See, in a normal universe, that's what would undermine your career as a police officer. If you can't be relied on to accurately remember and recount your own personal observations, that would end your career as a law enforcement officer, because how can we put you on the stand to testify to anything when your capacity to do so correctly is so problematic? In a normal world, I generated this out of nowhere, this massive false memory of a very specific event, recalled with very specific emotions associated with it. Thought it was weird because he's a witness. Yeah, that's the kind of thing that would catch your attention. In a normal world, a police officer just makes up something like that in their own mind. That would be career ending for the police officer, because how then do we know that any future evidence you give is not something you've just made up in your own mind? But here we are in Massachusetts. Apparently that is less concerning than simply that you do the right thing. Do the right thing vis-a-vis that memory that you reported to the FBI. Thanks for getting that out there. Thanks for getting that out there so that the jury is clear that they heard from the FBI. The FBI is the other alternate investigators, the other law enforcement agency that we've heard about in this. Thank you for spelling it out. It's the FBI. The jury now knows that. While we wait, let's go ahead and take in some of your guys' reactions to this. Donna ST, can a defendant sue a judge after trial? Almost never. The judge has absolute immunity for actions taken in the judicial capacity. Why do they have that? Because judges have decided that they have that protection. Judges have decided they have adopted this judicially created doctrine of immunity, where they say, because we are judges, we can't be sued for anything we do as judges. Legislature never passed the law. Governor never signed it into law. It's a judicially created doctrine. We can't be sued. And so because of that, no, defendant almost never can sue a judge after a trial. Donna ST, why would defense calling Proctor benefit the Commonwealth? Because the Commonwealth is then going to be able to lead Trooper Proctor. They will have him on cross rather than on direct examination. And when you have a compliant witness on cross, you simply get to feed them whatever you want the jury to hear, and they will be compliant with it. They will agree with it. They will give it to you. They will go along with it. And so this would be Hank's opportunity to simply feed to the jury everything that he, his Commonwealth version of what Michael Proctor did in the investigation, all of the work he did, all of the reasons he came to the conclusion that Karen Reed was guilty of committing this, driving related homicide of John O'Keefe, how the evidence took him in that direction, how the texts were tasteless, but didn't undermine the validity of his investigation. All of that. Hank just gets to make up a story of how it's all okay and feed it to Proctor, and Proctor says, "Yeah, that's exactly what happened." So that's why you don't open that door if possible. You don't put Proctor on the stand. If the Commonwealth wants to bring him on to explain the text, okay, you can do that, but now you have to do it on direct. And then the defense gets him in cross, and we're back in the orientation that makes a little bit more sense. Kiyoka, have a question. Do you think defense should file something for Brennan, moving the burden shifting on the defense multiple times during Cross Friday? So there were several things that happened in the cross on Friday that we're talking now about Dr. Welcher. Or are we talking about, we're talking about DeSogra now. So there's kind of a couple things that I noticed both with Dr. Welcher and with how they approached Matt DeSogra and his analysis of what Welcher did, that, yeah, probably wouldn't hurt memorializing in some way, getting it down in writing. One of those was the several times on cross-examination of Matt DeSogra or DeSogra, I keep saying it wrong, Matthew DeSogra, that Mr. Brennan kept implying like you didn't do any testing, you didn't do any data collection. That is very much veering on the edge of suggesting that the defense has a burden of proof. They don't. You can come in and just do absolutely nothing but poke holes in the Commonwealth's presentation. And if you poke big enough holes, the jury buys it, that's reasonable doubt, there's no conviction. So you have no burden of production as a defense. You don't have to go get data. You don't have to do any testing. That is not your job. So I would not have a problem with that being memorialized or documented in some way that happened. Another one too, though, that goes back to Welcher and his presentation a little bit is, Welcher does to some extent rely on hearsay, right? He takes the information from Scorty Bello's autopsy report, stuff from like the cell phone extractions and the testimony from trial and so on and so forth. And so he's kind of fed little bits and pieces of that back. But when it comes to actually being able to challenge the basis of his testimony, judge says, no, you don't get to ask about Trooper Paul. No, you don't get to ask about Scorty Bello. With respect to Trooper Paul, I would want to flesh this out a little bit more because he clearly did review Trooper Paul's report. He used some images, like the image of Trooper Paul in the steering in the driver's seat with the odometer and so forth. He's relied at least somewhat on Trooper Paul, and I think that photograph is a particularly important one because Trooper Paul is not a testifying witness. The Commonwealth didn't call him, and if you're going to present hearsay from somebody that you didn't call, you have a testimonial hearsay problem. This is a confrontation clause problem under the Crawford versus Washington line of cases out of the U.S. Supreme Court. Commonwealth has to be very, very careful about admitting hearsay. So just for example, that photograph of Trooper Paul sitting in the car, showing the odometer and so forth, that's potentially implicating confrontation issues. So I'd want to review Welcher's testimony very, 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 very carefully. And any time at all that he stated or even implied that part of the basis for his opinion was hearsay of somebody else, those are potential confrontation clause problems as well, not just the Rule 703 that we read several times last week, the rule that deals with what's the basis for an expert's opinion, what can they be asked about, and so forth. Beyond that, there's a potential confrontation issue. So if there's anything there to work with, yeah, wouldn't also hurt my feelings to see some of that be documented and just put into the record as well. Gypsy, didn't everyone agree pre-trial to a designated text reader? Can the defense force him back to the stand to make a cop read those Proctor texts? So they did not. The defense had objected to having a reader or having, the way that Brennan had described it, having people like read the parts of the texts. That was objected to, and Judge Cannone did not allow it. So, I mean, the basic answer to your question, yeah, anybody who there is a reason to ask them questions about the text messages, there's relevant information to be obtained by asking them about the text messages, then they can be presented with the text messages and as part of that questioning required to read them. So I don't think that Brennan has really diffused anything here. It's just kind of given a preview. But if, for example, we're going to put Yuri or Tully or somebody like that, somebody in a supervisory role, Fanning, on the stand and ask them about these texts, they can be made to read those texts. Thomas Heberling. So or Heberling. Sorry, I wouldn't want to, you're important, Thomas Heberling, in a way that Kelly Dever is not. So another cop that was involved got biffed, aka punched up or in an altercation, and the other people commenting had heard John was beat up. Yeah, I mean, that was the story, wasn't it?
So, Mr. Alessi, you're at the podium. Who is your witness?
Thank you, Your Honor. The defense calls Dr. Marie Russell.
Okay. Dr. Russell, what a day. What a day. Yeah, everyone, that was the initial story, thought that he had been beaten up. I mean, even the medical examiner thought that he had been beaten up, or they thought that. They took that to the medical examiner initially. So
Follow me, please.
Yep. Waffled. He got biffed and he got waffled.
Then you're going to step up and face the court and raise your right hand. Thank you.
You solemnly swear the evidence you give to the court and jury in the case now here should the truth, the whole truth, and nothing but the truth, so help you God.
I do.
May I have a seat?
Good morning.
Good morning.
She's not happy to see that, Judge. Not a fan.
All right,
Morning.
Mr. Alessi, whenever you're ready.
Thank you, Your Honor. Good morning.
Good morning.
Could you please state your full name and spell your last name and introduce yourself to the jury?
Yes. Marie Russell, Russell.
Can you summarize your professional background?
Yes, I am an emergency physician and a forensic pathologist.
How long have you been an emergency medicine physician?
For over 30 years.
How long have you been a forensic pathologist?
For over 30 years.
Do you have a medical license?
I do, several.
When were you first licensed to practice medicine?
In 1988.
What medical licenses do you currently hold?
Well, I have a physician and surgeon license in California. I have a medical license in Massachusetts, New York, and Idaho.
Where did you attend college?
I attended both MIT and Northeastern University here in Massachusetts.
I'm sorry.
Oh, I said in Massachusetts.
When did you attend pre-med and what was your major for MIT?
Yes, when I was at MIT, that was in 1972 to early 1974, I took pre-med courses. My major was biology, but I took pre-med courses.
Did you obtain a degree from MIT?
No.
Why not?
Unfortunately, my mother became sick with cancer, and I ended up going back to New York.
Where did you ultimately obtain your bachelor's degree, and which degree was it?
Well, after my mother passed away, I came back to Massachusetts, and ultimately I obtained my degree at Northeastern University. And what was the other part of the question?
Did you have any distinction with regard to your degree that you achieved from Northeastern?
Yes, I obtained a bachelor's degree with the highest honors.
Summa cum laude.
After college, did you go on to receive a Doctor of Medicine?
Yes.
Where did you attend medical school and when did you obtain your medical degree?
I attended the University of Massachusetts in Worcester medical school, and I obtained the medical degree in 1987.
Did you complete any residencies? And if you also could just explain to the jury very briefly what a residency is.
Yes, I completed an internship and residency in emergency medicine initially. And what that is internship is and residency both are very intense years of study and training and getting experience in a particular area. So I obtained the internship, I completed the internship and residency in emergency medicine.
Where did you obtain those internships and residencies?
Well, I was interested in emergency medicine, so I went to Los Angeles because they had a very, very busy emergency medicine program.
And it may be obvious, but let's just make it perfectly clear. Why is Los Angeles very busy for an emergency medicine practice?
Well, it's a big city, and in this particular hospital that I was at, it was right in the heart of the city. It was in the, near the downtown, but it was in a very, very busy and underserved area, so it was very busy.
Your Skid Row?
Did you complete any fellowships, and could you please explain to the jury the significance and prestige of a fellowship?
Yes, so after my residency in emergency medicine, I then decided to do a second residency, and that was in pathology, in anatomic pathology. Pathology, of course, is the study of disease, and so I did the 2 years of anatomic pathology, also at the same busy medical center, and after that, I did a fellowship, 2-year fellowship in forensic pathology at the Los Angeles County Medical Examiner's Office.
What did your forensic pathology fellowship involve?
Well, forensic pathology training involves the investigation of deaths, usually sudden and unexpected deaths. And so I investigated many death cases. I performed over 500 autopsies at the medical examiner's office for sudden and unexplained, sometimes unexplained, sometimes very obvious deaths, but sudden deaths. And then and in addition to that, there were classroom hours, there was on-scene time, there was time in the crime lab. We spent a week at the crime lab. I spent some time at the FBI. So it was a very, very comprehensive training program.
Approximately how many autopsies were you performing a day?
Usually 1 to 2, unless there was another assignment.
In addition to performing the 1 or 2 autopsies a day, did you attend any conferences or participate in any forensic case discussions as part of the fellowship?
Yes, so it was very organized, and we had conferences on some, mostly Thursdays, but also sometimes on Tuesdays. Interesting case conferences or very structured lectures.
You spoke of cases. Can you briefly tell the jury so they have an understanding of the type of cases that you would typically work on as part of your forensic pathology fellowship?
Well, there were many unexplained deaths, so some of them would be natural deaths in somebody who might be a little younger than usual old age. And then there were cases where there might be a drug overdose. Many cases were accident victims, including car accident victims and other kinds of accidents. There were quite a few homicides, and in fact, many homicides, and quite a few suicides.
Did any of those cases deal with wounds and wound patterns and wound identification?
Many of them, in fact, I would say almost most of them, because part of the examination, and a very important part of the examination, is the external examination of the body. So before I was allowed to even start an autopsy, I had to do a complete external examination of the decedent's body, looking for any kinds of wounds or abnormalities.
We'll come back to wound pattern recognition a little later. But again, I think it's probably clear to most people, but just to be ultimately clear, when you talk about external, can you just elaborate a little what you mean by that?
So the external examination is of the exterior of the body, the skin, the hair, the eyes, looking for, amongst things looking for also would be rashes and scars and those sorts of things. So that's the external examination.
In external, Dr. Russell, is to be contrasted with what?
Oh, with an internal examination. So after all that is done, and there were some other things that had to be done too, like looking at examining the clothing, or looking at X-rays if there were X-rays available from the medical examiner's office, and of course reading the medical record that was available. After all that was done, then I would proceed with the examination of the internal structures of the body. Including the organs, the soft tissues and muscles underneath the skin, the bones, etc.
Do you have any certifications?
Quite a few.
Can you name them, please?
Well, I'm
board certification. I'm sorry to interrupt you, doctor.
Okay, so I'm board certified in emergency medicine, and that was, after the residency training, had to take a qualifying examination. And then I've had to be recertified. I think it's 3 times now. I just recertified again. So I'm certified for another 5 years.
What do you have to do to get board certified and maintain that significant certification?
Well, presently, to get board certified, one has to complete a residency in emergency medicine. And so that is, depending on the program, either 3 or 4 years long. I went to a 4-year program. And then I had to take examination, both a written examination, very long written examination, and then an oral examination where I was questioned by many established emergency physicians on the various kinds of cases that might present to the emergency department. They would give you an unknown, and you would have to talk about how you would care for that person.
Do you have any affiliations with any professional organizations?
Yes. I'm a fellow of the American College of Emergency Physicians. I'm a fellow of the American Academy of Forensic Science. I'm a fellow of the the National Association of Medical Examiners, and then I have some memberships in some other organizations.
What does it take to
What happened? Sorry, guys.
And possibly have presented a study or a paper or something at the national meeting. Other of those organizations, it's a little bit variable, the membership for a certain number of years.
In addition to all of that education, background, experience, do you have any specialized training and experience with regard to investigations of death?
Well, yes. So again, the focus of the forensic pathology was investigations of death, but also in my job as an emergency physician at the hospital I was at for 29 years, I had both clinical responsibilities, meaning in the ER, taking care of patients, and administrative responsibilities, meaning committees and, office type work. And so one of my responsibilities during that time was to be director of the Quality Improvement Committee. And as director of the Quality Improvement Committee, of course, I had to do death reviews. So analyzing, studying the people who came to the emergency department and was subsequently either pronounced dead or died in the emergency department.
So now let's move to a slightly different topic. Let's discuss your work experience. What do you currently do for work?
I work for the Medical Board of California, and I do some private consultation work.
Describe your work briefly for the Medical Board of California, including what is the board, what's its responsibilities, and what do you do in your role in working for the Medical Board of California?
So the medical board is a part of government, I think, that is established to basically police the doctors and some other health professionals. So what the role of the medical board is to protect the public health. To protect them from misdeeds by healthcare professionals, particularly doctors. So, would you like me to go on?
So in terms of the medical board, just a last question with regard to that. What type of knowledge do you have to have with regard to the practice of medicine to be able to assist the board in evaluating whether certain doctors have met the standard of care in a whole host of areas of the practice of medicine? What type of knowledge do you have to have?
Well, you certainly have to be up to date. You have to be quite knowledgeable on current treatment standards, what is considered the actual standard practice of medicine, and be up to date on literature and what, things that are currently accepted as the good practice of medicine.
Prior to your current role, where did you work and when?
Well, before becoming a doctor,
just so we can do it for maybe a little more for the jury, if you could go just before the medical board where you work, or do you want to do it from the beginning? Whatever way is best for you, doctor.
Doesn't really matter. Most recently, I worked for the state of California, the prison system. I was the medical director of the, what they call the chief medical executive of one of the high security prisons in California. I did that for 5 years after retiring from my Los Angeles County job, which I held for 29 years.
And briefly describe generally your duties in that role.
So as chief medical executive, it was my duty basically to run the medical department. So I hired physicians, I supervised the physicians, made sure that they were providing the standard of care to the inmates that they were assigned to take care of. I reviewed many of their charts. I reviewed transfers and requests for services outside, such as specialty services, orthopedic surgery services, and other kinds of services. And I reviewed every single death that occurred during my years there.
So you just said you investigated every single death that occurred at the prison during your time in that role?
Yes.
Approximately how many death investigations were there that you performed?
I think approximately 60.
Now,
12 a year.
Did you have any involvement there in examining or identifying
In one facility.
wounds of deceased individuals?
I did. My office was in the medical building, and it was very close to what was the equivalent of the urgent care center on site. And so when the patients would come in with an extreme injury, a very serious injury, or near death, I would frequently go over right to the urgent care because that was my specialty. That was, my interest. And even though there was a doctor or another practitioner assigned to care for the patient, I would oversee that. And I would also, examine the patients, look for wounds, look for, signs of injuries. There were some, in some of these cases, there were some deaths, and I would examine those bodies very carefully for any kinds of wounds, just like I had done in the coroner's office for those years.
To move this along, before you became the chief medical executive at Corcoran, where did you work and what did you do?
So I worked for 29 years, I worked at what's called the Los Angeles County USC Medical Center. Now, I know that's a lot to say. It was a county hospital that was affiliated with a medical school. It used to be called, prior to that, prior to when I got there, it was called General Hospital. It was a 19-story building, General Hospital. Well, no. And now it's actually called General LA General or something of that nature. So anyways, that's where I worked for 29 years. And as I said, I had a variety of different roles there.
Can you just briefly name off the roles that you had while at the General Hospital?
So as I mentioned earlier, there was always a clinical component to what I did. I always had shifts in the emergency department where I had to see patients and supervise interns, residents, physician assistants, nurse practitioners. So in addition to seeing my own patients, I would also supervise them as they were seeing their patients. So that was the clinical role. Then there was an administrative role. And my administrative roles ranged from director of what they called life support training, which provided training to the trauma surgeons and the neurosurgeons regarding things such as advanced trauma life support and also to ER doctors. So director of life support training, director of QA. For many years, I was director of the jail unit, which was a very unique unit at this hospital. For a hospital, it was a very unique unit in that it had three components: a dedicated ER, a dedicated for jail patients or patients in custody, a dedicated clinic for in-custody patients, and a dedicated inpatient. So it's three sections dedicated to in custody services. I was medical director of that for a while.
In addition to all that, were you also a professor?
I was an assistant professor.
Assistant professor. And what did you teach? Just a brief summary of what you taught.
Well, most of my teaching was clinical, bedside teaching, rather than in lecture halls. I would occasionally give lectures to the residents, the residency group, which was about 50 doctors.
And those residents are medical doctors, correct?
Yes, they are. Yes,
Yep.
they are medical doctors. So I would occasionally give lectures to them, but a lot of the teaching was actual bedside teaching.
Switching gears just a little bit and segueing. Over your course of your career as an emergency department physician and otherwise, did you treat individuals with animal-inflicted injuries?
Yes.
And did any of those animal-inflicted injuries involve dogs?
Yes.
And
How many?
generally, is it correct to say that in terms of dogs, there's sort of the canine police dogs, and then there's the civilian dogs with which most people have experience?
Yes.
Are those two categories that you're familiar with, you're comfortable, as we discuss dogs, to have canine versus civilian?
Yes, because the injury patterns are a little different.
Okay. So what is the difference between a canine dog on the one hand and a civilian dog on the other?
Well, generally, civilian dog bites are rather minor, generally. You know, puncture wounds, maybe, some slight avulsions, like, skin defects, slight skin defects, usually not major. Whereas in the canine or trained police dog bites, the wounds I saw were extensive wounds where there was extensive ripping, tearing, crushing of tissue, and many times even injuries to the muscles and blood vessels underneath.
From your experience, do you know why the injuries from a canine dog are as you describe them, as opposed to injuries from a civilian dog?
Well, in the LA area at that time, the dogs were taught to bite and hold. So they would, the canine dogs would get a grip on the individual that they were pursuing, and then hold on, even if the individual was trying to pull away. And so there were oftentimes tearing injuries to those, because that's how the dogs were trained at that time.
Even with canine dogs, did you ever see injuries from canine dogs on humans that were not a complete bite, that were an incomplete bite?
Yes. So if the dog missed on the first attempt at a grab, the teeth might only scratch the surface of the usually extremity, by the way, and so you get what I consider an incomplete dog bite, because it was just scratch marks from the teeth. But the dog would then try a second time and third time.
Now let's go to civilian dogs. A term used for more dogs of household pets that people have. Can you describe from your experience the type of wounds from those civilian dogs that you would see, and contrast it with what you just described for a canine dog?
Generally, they were minor. So a scratch, a puncture wound, maybe a little tearing of the skin, a little skin flap, but generally much different. In
your 30, did you say about over 30 years experience in the emergency medicine department?
Mm-hmm.
What did you see more of? Civilian dog wounds on humans or canine wounds?
Actually, it depended on where I was assigned at the time. So in the very beginning, because the jail unit was one of my first assignments, I saw these terrific, horrific wounds, many of them. I learned that what was in the textbooks about how to treat them was so wrong because these patients many of them needed hospital admission, intravenous antibiotics, and many of them needed surgery. And what I was reading in the textbook was, that you could patch them up and clean up the wound and send them home with, sometimes with antibiotics, sometimes without. But anyway, so initially what I was seeing a lot of in the very beginning was the law enforcement dog bites, because I was assigned to jail board. And also I was very interested in this because I used to be a police officer. And before going to medical school, I was a full-time police officer here in Massachusetts for 7 years. And so I had this interest in law enforcement type injuries sustained during the arrest process, et cetera, et cetera.
So you had an early interest in with regard to dog-inflicted wounds on humans and a police officer. Where were you a police officer in Massachusetts and when?
In the city of Malden, I was appointed as first woman police officer in 1977 to 1984, full-time.
And while you were a police officer, were you doing that full-time and anything else while you were a police officer? Were you pursuing school while you were a police officer, your college education, or was it separate?
No, I was a full-time police officer working the night shift, and I was attending Northeastern University part-time during the daytime to pursue my degree.
Were you a sworn duty police officer?
Yes.
Full member of the police force?
Yes.
Did you attend academy?
Yes, I attended the Boston Police Academy.
And how many years were you a Boston police officer?
No, I wasn't.
I'm not Boston, the ball.
I was a Malden police officer for 7 years, full-time.
Now let's go back to your emergency department and other experience. Can you approximate how many dog bite injuries you provided treatment for while an emergency department physician?
Overall?
Overall.
Well, I don't know the exact answer, but I estimated it at a very conservative number of 500 dog bites because, would you like my methodology?
Oh, please.
Oh, okay. So I considered that even though I worked there for 29 years, I would take 25 years and 40 weeks out of the year, because the other weeks I might be assigned something special, a special rotation or a special assignment or vacation or some kind of course. So 25 years, 40 weeks per year, that's 1,000 weeks. So even if I only saw one dog bite at this busy trauma center, that would be 1,000 dog bites in my career. But I just took it in half. I cut it in half and said I think at least 500.
In addition to the 500, did you oversee other physicians or healthcare professionals like physicians' assistants, nurse practitioners, who themselves were treating and observing dog-inflicted wounds on humans?
Yes.
And approximately just the number, approximately how many of those in addition to the 500 you just calculated?
Well, I generally supervised about 3 to 4 people per shift. Med students and interns, residents, whatever, all those people. And so I would say very conservatively another 500.
In terms of other work, I want to shift just a little bit in the emergency department. Did you encounter injuries from persons involved in motor vehicle accidents?
Many.
And you mentioned you were in Los Angeles. And in terms of those, can you approximate how many humans you saw and treated and diagnosed in the emergency medicine department from motor vehicle accidents?
Well, it was a very busy level 1 trauma center.
What is a level 1 trauma center?
So level 1 trauma center is the highest designation that a trauma center can have. And there are many requirements in place in order for a medical center to be a level 1, including 24-hour in-house neurosurgery, 24-hour in-house orthopedics, and an active research program, and many, many, many more requirements. And a certain level of training for all of the ER docs and all of the trauma surgeons. So we were level 1 trauma center, one of the busiest in the west of the Mississippi. And we were, the hospital was located near some major freeways. So we saw lots of patients from motor vehicle accidents. But if I were I would say, if I took the 1,000-week number again, if I saw, at least 3, motor vehicle accidents per week, that's 3,000 at least. And that's just me. That's not the interns, residents that I'm working with.
So shifting again a little bit, as medical director of jail medical services at General Hospital, can you just describe a little bit about the work there? Similar to what you just described, or is it a little different?
So in the jail medical services, we dealt with people who were in custody. Some of them were also, drunk drivers and under arrest. Some were, they're arrested for a variety of reasons. Anyways, and if they were in custody, rather than have them in the main emergency department, we had a special emergency department for them. And so we would see, interesting cases there.
In terms of being a professor, is that your time as an adjunct professor at Cal State Los Angeles? Is that where you were an adjunct professor?
Yes. So while I was doing all this, I also had a part-time job teaching a course called Legal Medicine to graduate students, master's level students in the criminalistics master's program at Cal State University.
And in terms of topics, just briefly, some of the topics you would have taught them, and particularly any that may be apropos to why you're here today.
So knowing that many of these students were going to go on to work in crime labs or be crime lab directors someday, what I needed to do was to teach them about the aspects of a crime scene that dealt with a body or someone who was injured or killed. And so we dealt with things such as time of death, postmortem changes, wound analysis on the body, looking for different patterns of wounds or types of wounds that could direct them into to steer them in their investigation. Let's see, so many other things. Yeah.
There was a little bit of a noise here when you were talking about wounds and patterns. Could you just repeat that aspect of it?
Sure. So when a criminalist or a crime scene investigator goes to the scene, they have certain duties to attend to, and they need to be aware, that certain kinds of wounds, might indicate certain types of deaths. For instance, gunshot wounds in certain locations, or lacerations or stab wounds in certain locations might mean that this could be a suicide, this could be a homicide. They need to know, if there's something that might look like resemble a bite mark, that maybe that area needs to be swabbed or photographed, especially, and etc. So that's basically, it was very basic, but that's what
Let's now shift again to your work at the County of Los Angeles Department of the Medical Examiner's Office, or is sometimes called the Coroner's Office. When did you have that work, and what did that position involve?
So that was from 1993 to 1995. And as I mentioned, there was death investigations. I was assigned a certain number of cases myself, but we also reviewed cases that other doctors had. And I, given my curious mind, when I would do my autopsy, I'd also look at whatever other cases were going on. And there was typically 10 to 15 cases going on any given day. And so so I learned a lot, not only from my cases, but from other cases.
Did you ever conduct an autopsy of any individual that sustained dog-inflicted wounds?
Yes.
Please describe that autopsy.
That was a case I'll never forget. It was a young boy who had been attacked by 3 dogs, large dogs, but not specifically canine, law enforcement trained dogs, but 3 large dogs. And the wounds there were extensive wounds all over the body, or as best I can remember, including a wide variety: puncture wounds, some scratches, abrasions, contusions. There were a number of different types of wounds.
So let's now go, we've talked about dogs and motor vehicles. I want to go back, please, to motor vehicles. Did you, as a forensic pathologist, did you ever conduct autopsies of decedents that were involved in motor vehicle accidents?
Yes.
Approximately how many?
Hard to say. I'm not sure, really, but probably at least, motor vehicle accidents, probably at least 20 or 30.
Did you conduct autopsies of victims of motor vehicle pedestrian incidents?
Yes.
Now, prior to working at the coroner's office, you worked at the jail emergency department at General Hospital that you described, right?
Yes.
And in that position, did you provide treatments to persons that suffered dog-inflicted injuries?
Yes.
And just approximately how many? And then we'll move on to the next topic.
Approximately, personally myself, about 40, but I was involved I worked as part of a team, and so I think we saw probably about 60 of these severe dog bites.
We're going to shift again to keep it moving. Have you authored or edited any publications on dog-inflicted injuries on humans?
Yes.
And what publications, please?
So I was a co-author on 2 peer review articles in major emergency medicine journals. One of them was describing the law enforcement dog bites, injury patterns, and another one was more focused on the management of the law enforcement dog bites.
And did you, those are ones you co-authored, correct?
Yes.
Did you ever edit the work of others' articles or books as part of a peer review process?
Yes.
Describe that, please.
Yes. I was asked to be a co-editor of a 2-volume series on forensic emergency medicine in a peer review article series. And one of the chapters in one of those issues was on was on bite wounds. It was written by Dr. Gerald Vale, V-A-L-E, and who is a renowned board-certified forensic odontologist.
In terms of moving now from peer-reviewed articles you co-authored, peer-reviewed books and articles you edited, have you attended any seminars or talks or lectures on wound identification and or bite wounds?
Yes.
Just briefly describe a couple to give the jury a flavor of what those were.
Well, there have been many lectures on wounds of all sorts, and in the emergency medicine program, of course, there were lectures on wounds from various types of animals and how to treat them. In the forensic arena and at some of the professional organizations, there were lectures or talks on wounds, and also there was a yearly talk on bite wounds given by Dr. Vale at the coroner's office.
State perhaps the obvious. Have you had a lifelong interest in dogs and dog-inflicted wounds?
Yes.
And is that a professional and a personal interest?
It's professional.
Right, mostly professional, as you've described it. Let's now keep moving and go to another topic. Have you testified as an expert in court before?
Yes.
Is that in state and federal court?
Yes.
What topics have you testified to in state and federal court?
Causes of death, wounds, child abuse, domestic violence, mostly causes of death.
Have you testified as an expert regarding emergency medicine?
Yes.
Have you testified as an expert regarding forensic pathology?
Yes.
Have you been found to be qualified as an expert in each of those categories in the courts in the United States?
Yes.
Have you ever not been qualified to testify in any court in the United States?
No.
Have you ever testified as an expert regarding identifying dog-inflicted wounds on humans?
No.
And why not?
Because it's, prior to this case, because it's not a topic that comes up very often.
So although it comes up often in your practice in terms of whether it's an issue in court, is it my understanding from your answer, it just doesn't come up that frequently?
Correct.
Are you aware of any other physician practitioner that would be testifying in court a lot on this topic, given what you just said about the infrequency of it coming up?
No, I'm not.
Now let's go on to what were in the last question on this line, give a general idea of the types of wounds that were at issue and whether there were any pattern wound issues in those cases that you've testified in court about.
Well, many of them were stab wounds. Some were blunt force wounds from from variety of mechanisms, including assaults or motor vehicle accidents. Again, a lot of wounds from accidents, and then of course gunshot wounds.
Were those the topics both living persons as well as deceased?
Yes.
Let's now move to, you've mentioned wound pattern, right? And are you familiar with the topic in the area of wound pattern recognition?
Yes.
Can you please describe for the jury what you mean by wound pattern recognition in your practice and from your experience? What is it generally, and we'll get to some more specifics as we go through.
Well, generally, pattern recognition is very important in medicine. It's important in a lot of different fields of medicine, including radiology. They look for patterns on x-rays. Pathologists under a microscope looks for certain patterns to identify cancerous cells, for instance. So pattern recognition is very important. And then as a subset, wound pattern recognition is of course very important to physicians that deal with patients that come in from the street, so to speak, from who may have been assaulted, may have been child abuse victims, may have been domestic violence, elder abuse, those kinds of victims, because sometimes it's important to or you learn that what actually happened is not what the patient or the relative or the presenter said happened. And so you have to discern or figure out what happened in the case. And so you have to be able to identify certain patterns and regions of the body, for instance, where wounds are, in order to make that happen. And so it's very important. It's emphasized in emergency medicine.
When you were in residency, were you taught wound pattern recognition methodologies?
Yes.
And is wound pattern recognition an area that you continue to learn and then gain experience from your over 30 years as emergency medicine physician?
Yes, it was emphasized in both emergency medicine and forensic pathology, in both fields. Very important.
Is wound pattern recognition a generally accepted methodology that is applied in the practice of medicine?
Yes.
And you've given a few examples of that pattern recognition methodology. Is that pattern recognition methodology generally accepted and discussed in the peer-reviewed medical literature?
It is in certain articles, right. Yes.
And we'll be getting to some of those. In terms of wound pattern recognition, just roughly how frequently in your experience as an emergency medicine physician did you have to exercise your skills in wound pattern recognition?
I would say probably weekly, because I always questioned, what the patient was telling me, and did it fit? Did the story make sense? So I did it quite often.
And was that particularly important in child abuse cases where you may not be getting the story and you'd have to look at wounds and make your own determination?
Yes.
Now let's go and slightly move on to a very similar topic as to whether you ever had to determine the source of the wound without any input from a patient.
Oh, yes, many times. Many patients arrive to the emergency department unconscious.
And that's one example of others. And with regard to language barriers, did you ever encounter that as an obstacle to you understanding what may have happened and you therefore had to exercise your pattern recognition skills?
Yes.
So now in terms of dog bites specifically, how often, if at all, did you have to look at a patient without input from anyone to determine whether it was from a dog?
Occasionally.
And can you recall any specific instance, or is it just you're recalling that you generally had to do it, but you can't recall a specific instance?
The second of that I generally had to do it. Sometimes, there was a language barrier and people couldn't describe what it was that bit them. And it was important to know because treatment for different types of bite wounds is very, very different.
And to be fair to the situation, you can't give any one specific. You remember this person was this age, et cetera, but you know that you did that on more than one. I'll withdraw that and go to the next area. Let's now talk about wound pattern recognition in the area of forensic pathology. What role does pattern recognition play in forensic injury analysis? And could you please just let the jury know what you mean by forensic injury analysis as regards pattern recognition?
Okay, so forensic analysis or forensic injury analysis is the analysis of injuries from a medical legal perspective. In some areas of medicine, the doctors are taught to just treat just treat the injuries, and no figuring out about how it happened or what caused the injuries so much as they treat. But in my case, both the emergency department and the forensic pathology training, I was interested in how the injury happened. That was a very important factor to me.
Why is pattern recognition important in the field of forensic pathology?
Well, you could look at a wound all by itself, an abrasion, for instance. Abrasion is a scratch. And in and of itself, it might not tell you how the wound occurred all by itself. But if there are a series of scratches or a series of lacerations or cuts, they can tell you more about how it happened.
And have you applied wound pattern recognition skills in your practice as a forensic pathologist?
Many times.
Could you just give the jury a flavor of why, just a few examples, maybe two?
Okay. Self-defense wounds, for instance. An issue comes up often in court if certain wounds were inflicted on purpose versus were they inflicted self-defense, and things like appearance and location can help you determine that. What was the question again?
It's just a few examples of applying pattern recognition skills in forensic pathology.
Oh, yes.
Thank you, doctor.
Oh, more?
No, more, yes.
Oh, yeah. Motor vehicle accidents, people who are struck by cars. There are certain patterns that one expects to see when a individual is struck by a car. And we're taught, to look for certain patterns, and that can help you determine if they were struck by a car.
In terms of motor vehicle accidents and patterns, can you give an example of some of the patterns you would expect to see in someone, and that you have seen in someone that is struck by a motor vehicle?
Oftentimes lower extremity fractures, for instance. Lower extremity bruises and fractures are commonplace for someone who is struck by a car.
And in your practice as an emergency medicine physician, a rough approximation of how many lower extremity injuries you have examined and evaluated with regard to motor vehicle accidents, including in the Los Angeles area?
Oh, I think probably hundreds.
Alrighty, so now let's continue with the topic that you were talking about. You called it defense injuries and wounds. I want to cover that topic. Are you familiar with the term posterior surface?
Yes, in terms of anatomy?
In terms of human anatomy, and with Your Honor's permission, could Dr. Russell point to her arm to show what she's referring to with regard to posterior surface for a defense injury?
Sure, go right ahead.
Let me explain just in general.
Sure.
Anterior is the front of the body. And
Excuse me, Dr. Russell, I'm sorry, if you want to stand up so the jury, with Your Honor's permission.
Yes, are you comfortable standing up and doing this?
Yes. Okay. So many years ago, anatomists decided on a nomenclature for describing parts of the body, and so the way the body the descriptions go is that you take a person in what they call the standard anatomic position, which is upright, with their arms, their palms facing forward. Palms facing forward. So that is the standard anatomic position. So anything in the front is anterior. Anything in the back is posterior.
Could you point to the arm when you talk about anterior and posterior, please?
Yes. So with regard to the arm, if the palm is facing forward, that's the anterior. So the posterior part of the arm would be the back part that I'm touching right now. This back part of the arm and the back part of the forearm would be right here. So that's the posterior of the arm.
And what relation does the posterior of the arm have in determining whether or not a wound is a defensive wound?
Well, oftentimes, when someone is being attacked, they will put their arm up to defend or protect their face, their neck, their chest, their vital organs, the vital parts of their body. So they put their arms up. And in doing so, the posterior part of the arm becomes presented to whoever is attacking them or whatever is attacking them. So this is the part of the arm that oftentimes gets injured when someone is defending themselves.
Thank you, Doctor. How often have you observed and concluded regarding defensive wounds to the forearm?
Many times. I don't know. I don't have a number. 20, 30, I don't know. In terms of decedents, and then in terms of live people, many, many more.
And if we just start with the posterior part of the forearm that you've described and you encounter wounds there, are those wounds indicative or highly indicative of anything?
Well, they're indicative of defensive wounds being caused during a defensive action.
In your experience as a resident, a fellow, emergency room physician, and a forensic pathologist, and your time at Cochrane, have you experienced and taught the topic of defensive wounds?
Yes.
Now let's move on to another topic. Do you have knowledge of the dental features of dogs?
Yes.
Where did you gain your knowledge about the dental features of dogs?
Generally from reading articles.
And in terms of examining patients with dog-inflicted wounds, did that inform you anything about dog dentition or not?
Not specifically.
In terms of dog dentition, Your Honor, may I approach?
Okay.
Thank you.
Dog Dentition, that's a great band name. Dog Dentition. What kind of band is that? What kind of music are they playing?
Yes.
Can we drop kick Murphys? Maybe.
Your Honor, may I have
Dog
this
Dentition.
depiction marked as an exhibit for identification?
Okay. So for ID?
For ID only, yes.
It's 000 for identification.
Thank you, Madam Court Reporter. Your Honor, may I hand it to the witness? I'm handing you, Dr. Russell, what has been marked for identification as 000 as in orange.
Dr. Russell, do you recognize that depiction?
Yes.
What is it?
This is a diagram of canine dental anatomy.
And could you please, just for the jury, briefly describe dog dentition and what we mean by the term dentition? I think most know, but just for the record.
So I believe dentition just means the teeth and the shape of the teeth and of the mouth of the animal or a person. And what this diagram shows is that in general, dogs tend to have a triangular mouth, meaning, it comes, to a narrowing towards the front of the mouth. It shows how many teeth a normal dog will have, and what they look like. There are different kinds of teeth, just like humans have different kinds of teeth.
In Your Honor, to assist the jury in the understanding of what Dr. Russell is speaking about, with Your Honor's permission, could we publish this as a chalk for the jury?
Is there any objection?
None, thank you.
Okay.
Sure, go ahead.
Thank you, Your Honor.
Let's look at the dog
And
dentition as a chalk.
Will enlarge Mr. Woke, Dr. Russell, where would you like to start with regard to this, just to give the jury a brief discussion of dog dentition?
Because they don't know yet why we're talking about dog dentition at all.
I think the lower half around the triangular upper and lower jaws, right there.
Right there? Very
Yeah.
good. And Mr. Woke, if you could just, to start with, pull it down just so we can see the headings, and more importantly, the jury can see the headings of those two diagrams that Dr. Russell has pointed
Bottom
out. Yes,
and
just
the top.
enlarge that. Can you read what's on the left and what's on the right? It's slightly blurry.
Mandible and maxilla.
It's slightly blurry.
Mandible, lower jaw, maxilla, upper jaw.
Yes, I
got
can
that
read it.
right. Alrighty. So if we could then just reduce it back down so it's a little bit so that it's not distorted. And then Dr. Russell, if you could just talk about it. And before we do that, I think it would be helpful, Dr. Russell, we can go to the depiction up above just to get the overall picture up above there of the dog. All right. Is that that's an overall picture, correct? Do you want to point out anything generally on that picture?
I don't have a pointer, but generally it's a side view, and it shows the and it's a skeletal view, so there's no skin, and it shows that there are some prominent teeth. They're called the canine teeth, and then there are some smaller teeth in front of that. Or
Excuse me if I couldn't interrupt. Pardon my interruption.
Yes.
I'm just going to try to locate in the courtroom a pointer, Your Honor. If
There's nothing on that, Mr. and Dr. Russell?
I've got one where I may approach. If there's one on this.
No.
Yeah, I didn't see. May I approach, Your Honor? Thank you.
Let her
Here,
use
Dr.
the
Russell,
pointer.
hopefully that will work for you. Thank you. Excuse me.
Okay, so this is a side view, and it shows many teeth, and and this is skeletal view, obviously, and it shows these prominent teeth, which are called the canine teeth. Humans also have canine teeth, and ours are not quite as prominent. And then there are some teeth in front of that, which are called incisors. So that's the overview.
Right. And just to put this in context, we are looking at this and talking about dogs. Have you had the opportunity to review any photos of the right arm of the decedent in this case?
Yes.
And is one of the topics you're going to address whether those wounds are from a dog?
Yes.
And so this background in terms of dog dentition part of what you're going to cover for the jury later on?
Yes, and I want to make one more comment, if I may.
Please.
Just when a dog bites, they usually don't bite with all of the teeth. They usually don't get all the teeth impacted on the individual. So that's important to know. Oftentimes it's the anterior or the front teeth.
Why, doctor, is it the case that a dog doesn't always have a complete bite, get all of the teeth? Why is that the case?
Well, there's oftentimes movement. Oftentimes the dogs aren't really trained on biting techniques. And so, there's oftentimes the person who's being bitten is pulling away and trying to avoid the bite. So oftentimes there's only impact with a few of the teeth in the front.
Great. Please continue, doctor, with your...
Dr. Russell, could I ask you to use this screen?
Oh, yes.
The other one, please. I think it's easier for counsel.
Oh, okay. So overview, these large canine teeth, these are the anterior teeth. And as I said, it's very rare for all the teeth to be involved in the bite. It's usually just the front teeth and canine teeth.
Are there certain teeth that are on this depiction that cause certain types of injuries, abrasions, tears, punctures? Is there any relation to the teeth in any of those categories, or can it be just general?
Well, oftentimes, because the canine teeth are so long compared to the others, they are the ones that seem to cause the the puncture wounds, and those are the ones that appear to get the grip on the person's skin.
Is there a medical term for a puncture wound from a canine? Or is it just it's a punctate wound from canines?
I'm not sure there's a medical term.
Okay, please continue.
Okay. And that's about it on this side view.
And is there any other view on this exhibit that you would like to discuss with the jury?
Well, I was going to show that it's triangular. Again, the here, the upper and lower jaws. Yeah, they tend to be somewhat triangular.
Is that also sometimes the shape referred to as an hourglass, or is it triangular, or you prefer triangular?
I've heard it referred to as hourglass. I don't see an hourglass, but and yeah, maybe in some dog breeds, because all the different dog breeds have different shapes of their mouths. But this is just a generalization.
Okay, please continue.
I don't know that there's anything else.
All right, and so you.
Actually, yes. So here you can see. Go back, please. So here you can see again the canines, and it's oftentimes this is the upper jaw, the maxilla jaw. It's oftentimes these teeth that do the impacting.
I'm sorry, I didn't hear you say it's often these teeth that what?
That do the impact. The upper jaw is oftentimes the part that actually makes contact with the skin. That's all.
Thank you. We can take that down, Mr. Woke. Thank you, Your Honor. Now let's go to dog-inflicted injuries on humans generally. What type of injuries to humans can be caused by dog-inflicted bites?
Well, there are lots of different types of injuries. So they could be extremely minor, from a minor scratch to puncture wounds by individual teeth to actual puncture and punctures by several teeth. There could be several abrasions because there are multiple teeth involved, and if they don't puncture, they at least scratch. They can scratch the skin. That's what I call abrasion, is a scratch. So they scratch the skin, but in parallel because the teeth are lined up. So they oftentimes have parallel lines. And then, of course, there are bruises that could occur because of the crushing injury, and there can be what we call avulsions, which are where the actual flap of the skin is removed. And I can go further, but there's a wide extent of injuries.
So there's a wide extent, a wide range, and can you just give one or two factors that are going to determine whether you're on the more minor side of the range to the more major part as regard to the type of bite that the dog is able to get?
Well, I think that when there is penetration of the skin and pulling away of some of the tissue, I would consider that a more significant bite because of what's needed for treatment.
Just bear a moment, please. Thank you. So in terms of the nails and claws of a dog, what type of injury, if any, can those cause?
So the nails they're also somewhat pointy or triangular in configuration or shape. And so they can cause scratches, and actually they can cause even deeper wounds if the nail catches the victim's skin a certain way. But most of the time, just scratches.
From your experience, what type of medical experience, peer-reviewed article experience, your whole professional experience with dog-inflicted wounds on humans, do you have experience with just a part of the range or the whole range of injuries that a dog can inflict?
Well, I think I have a very wide range of experiences because those very serious ones we talked about in the very beginning, where there were crushing and ripping injuries, or those were the trained canine dog bites. Most emergency physicians don't even get to see those. They're so uncommon. But because I was assigned to jail ward, that's how I got to see them. But in the majority, in the main ER, most ERs in our main ER, we saw the more minor type of injuries.
So in terms of if someone is bitten by a dog, where are they? Again, I think most people understand this, but just to be clear for the record, when someone gets a dog-inflicted wound, where do they usually go?
Well,
Sustained.
Doctor, are you aware of the medical facility from your experience where people go who have dog-inflicted wounds?
Well, if they feel like they need medical care, they will either go to a family doctor or most likely the emergency department, because the emergency department is where the resources are, the people that with the experience. They go to the emergency department in general.
From your experience for people in your literature review and authoring of documents, do people with dog-inflicted wounds go to a veterinarian for treatment?
I'll let you answer it.
Not from my experience.
All right, now let's move to another category and to keep this moving along. How did you initially become involved in this case?
Well, very interesting. I live in Los Angeles, and I saw something in the Boston Globe about this case, but I really didn't pay much attention to it. And then eventually I saw or heard something, because I'm not from this part of the Massachusetts. I'm from a different part of Massachusetts. So anyways, eventually I heard or saw something about there being an issue with some possible dog-inflicted injuries versus maybe car-inflicted injuries. So that got my attention. I thought, that's interesting. And so that's how I initially became aware of the case.
Let's talk about the Boston Globe. How is a person from Los Angeles reading the Boston Globe? And why? Is it like a one-time thing, or why is it you're reading the Boston Globe?
I had a subscription. I would, not always read it. I lived in Massachusetts. I went to school in Massachusetts. I worked in Massachusetts as a police officer. So I have some interest in Massachusetts, but none of that was in this geographic area. It was all north of Boston. So that was the area I mostly paid attention to.
Did you reach out to anyone after reading that article? And what do you recall from the article in the Boston Globe, if anything?
I'm going to sustain that.
Did you reach out to anyone after having read something in the Boston Globe?
Yes. I thought the question was interesting.
Objection.
I'll let that stand, but just answer Mr. Alessi's question, please.
Yes, I did.
Go ahead.
Okay. Yes, I reached out to one of the DAs in Los Angeles County.
And at that point, what, if anything, did you know about this case?
I didn't know much. I just knew what I mentioned, and I knew that the decedent was a police officer, had been a police officer, and that interested me also because I was a police officer.
Please keep your voice up, Dr. Russell.
I said that interested me also because I had been a police officer at the time.
Hey, go ahead.
So that's about all I knew, really.
Right. So did you know anything about what the prosecution was claiming or the defense was claiming at all? Did you know anything?
Sustained.
What did you know, if anything, about the case?
I'm going to see it sidebar really quickly on this.
What did you know? It's calling for hearsay. What did you know? But I'm not sure it's important because it feels like she's already said a few times she doesn't know anything about the case except that there was a dispute about possible injuries from a dog versus from a car, and that the decedent was a cop. So I do think this ground has been covered. Don't know why we're objecting, but also don't know, why we need to continue to visit this point. A lot of foundation to establish with Dr. Russell to get to her particular expertise.
Moment, Your Honor.
Okay.
Dr. Have, in terms of, Mr. Wolk, if we could please, and Your Honor, may we publish what is already in evidence, which is Exhibit 167?
Okay.
With the arm.
Dr. Russell, do you recognize Exhibit 167?
Yes.
And how do you recognize that? Well, first, let's start. What is it, and then how do you recognize it?
It is a picture of the decedent's right arm and forearm.
Now, without stating what it is, have you been able to form an opinion as to the source and nature of the wounds that are depicted in that exhibit?
Yes.
Now, in terms of the next area, can you describe for the jury what method you used in forming your opinion without yet stating what your opinion is?
Well, I used pattern recognition and differential diagnosis.
So let's start with wound pattern recognition. Is that the wound pattern recognition you've been discussing up to this point in your testimony?
Yes.
And did I hear you use the phrase differential diagnosis?
Yes.
Please tell the jury what you mean by the term differential diagnosis as a physician, emergency medicine physician and forensic pathologist.
So when a patient, when a physician sees a patient and, or, an Imogen's case, and is attempting to make a diagnosis, it's very important that not only do they consider what they believe is the obvious, but also in their mind go through other possible diagnoses and determine if they can rule them out, so to speak. If they can rule them in, rule them out, so that they are not just focused on one thing, but they've actually given consideration to other conditions that may be causing whatever it is that they see.
So, Mr. Wolk, if you could take that, we're going to come back to this back and forth, but I'd like to have it taken down until we do have the need to, and if we could have the lights go back on, Your Honor. Thank you. So, does applying a differential diagnosis Well, let me start out. Do you understand what confirmation bias is?
I believe so.
Yes. And does differential diagnosis assist or not assist in avoiding confirmation bias?
I believe it assists in avoiding confirmation bias.
So in terms of differential diagnosis, did you apply that concept in the beginning of your analysis of this case?
Yes.
How did you apply differential diagnosis to, among other things, avoid confirmation bias in this case?
Well, in my mind, I went through other possible things or causes of wounds on an arm, and what they would look like, and the configuration, the patterns, etc. And then I figured out why these other potential causes of wounds in the arm did not fit this case.
So is phraseology a synonym for differential diagnosis, what doctors call ruling out something? Is that another way to say it as well?
Yes.
So we're going to come back to the differential diagnosis. I just wanted to have that question first. Now let's switch to the materials that you considered in forming your opinion about the nature and source of the wounds to Mr. O'Keefe. Describe what you looked at in terms of coming to your opinion, conducting a differential diagnosis, and avoiding confirmation bias. What did you look at?
Well, I looked at pictures similar to this. So there were pictures taken at the hospital. There were pictures taken at the medical examiner's office. I looked at the medical records. I looked at the autopsy report, and I looked at other reports from the Massachusetts State Police, and then those are some of the things I looked at.
Did you look at any photographs, including of clothing?
Of what?
Clothing?
Oh yeah, clothing, of course.
What clothing did you look at?
So there was a shirt like a hoodie shirt that I looked at that had many defects in it.
And when you say defects, what do you mean by defects? Is there a more layperson's term?
Holes.
Thank you.
Holes.
Did you look at any history of any dogs with regard to any municipalities and dog incidents?
I'm going to sustain that, Mr. Alessi.
Did you look at any municipal records with regard to your review in this case?
So that's sustained.
With regard to
Is that everything you looked at?
other
Do you not remember?
documents, if any, could you describe any other documents that you looked at?
Well, I also.
I'm going to see you at Sidebar.
What's the problem? What else did she rely on? She relied on stuff she was provided about the case, the forensic odontology stuff. I mean, not quite sure what the problem is here. I really like how he's set up the differential diagnosis as being the counter to confirmation bias. It's how you don't assure you have tunnel vision because you consider other possibilities. How revolutionary is that idea? Radical. Radical and strange. So guys, the reason why he is going so slowly with all this and so systematically is because he has to establish all of the foundation for her opinion before she can state what her actual opinion is. So because she's an expert, we have to establish her particular qualifications. We have to establish that there is a methodology that can be used to make this kind of judgment, that it's accepted in the community and reliable, that the materials that she relied on, the information that she relied on is of the type that experts in this field are normally going to consider and rely on, and that she applied the methodology, in a way that is accepted and so forth. Basically has to show she's qualified. It's a valid type of opinion in terms of the data and the methodology used to produce it. So he's trying to get it seems to me like he's trying to get this before lunch, so that like right before lunch we can get, and so what is your actual opinion? And maybe that goes to our timing here. But I don't know. We'll have to wait and see if we get a how much longer, Mr. Alessi, from the court. We're about 10 minutes from when she wants to take the lunch break. So we'll see if we can get to that. All in all, so far, not a whole lot of objection coming from the prosecutor's side of the courtroom. But now we're close to lunch. We're getting objections. I don't know what everybody in the witness or in the family box is paying attention to. I guess somebody just left the courtroom and that was interesting. Don't know. I also am very glad that Mr. Alessi took the time, took a minute, but took the time to orient the jury to why are we talking about dogs and dog bites at all. We spent an awful lot of time going through her qualifications to look at and evaluate and treat and have opinions about dog bites, but the jury did not have any frame of reference for that at all. So taking the time to stop and say, by the way, the reason why we're talking about this at all is because it relates to what you think is shown on John's right arm. Good, so that they understand why we are going through any of this in the first place. Otherwise, they're just sitting there.
1 o'clock, and then today we'll give you an hour for lunch, okay?
Yep, taking that lunch break. Gets till 1, so you get 7 more minutes.
May I continue, Your Honor?
Yes.
Thank you. Thanks for your patience, Dr. Russell. We had broke off where you had described the materials that you had reviewed. Based on your, and Mr. Woke, if we could please put the exhibit that we just had, and with Your Honor's permission, republish it. Thank you. Based on your review of all the materials that you had described and your experience that you had described, without stating it, were you able to come to any conclusions or opinions about the source and nature of the injuries that you see depicted on that exhibit?
Yes.
And what is your opinion and conclusion concerning those injuries?
Those wounds were inflicted as the result of a dog attack.
I'm sorry, I didn't hear you. Can you speak a little louder?
They were inflicted as the result of a dog attack.
And how did you form that opinion? Just describe your thought process to the jury.
Well, there are multiple groupings of wounds.
Do you have the pointer?
I do.
And if you could use the screen that Her Honor has requested.
So there are multiple groupings of wounds right here. Here's one on the what I'll consider the upper arm, which is above the elbow. Here's another grouping. Here's an interesting, complex grouping at the elbow. These are all at the posterior surface of the arm. and there's another grouping down here on the forearm. These multiple groupings are patterns, and they are, in my opinion, were inflicted by the teeth and claws of a dog.
We've discussed previously pattern recognition skills and methodology, and you just mentioned the word pattern here. Can you elaborate on what you mean by pattern with regard to this exhibit?
So there are groupings, and one can see that these wounds are going essentially in the same direction. They are oriented in the same way on the almost from the inner, close to the inner surface of the arm or the anterior surface towards the posterior surface.
What is the significance, if any, of that orientation you just described?
So what that gives me direction. And that tells me that the dog's teeth were over here, over here. The dog is over on this side of the arm, and the teeth started their punctures or their injuries over here, and through either the action of the dog or a combination of the action of the dog and the action of the decedent pulling away, or the victim pulling away, the teeth made these abrasions in this direction, from here down to here. And then here it's very complex because of the bending of the elbow. We don't know the exact configuration of what this elbow was in the arm. Was it fully extended, meaning it's fully stretched out, or was it partially bent? Was it fully bent? We don't know. But in addition to the pulling away movement, there's also the bending movement. So that one is even a little bit more complex. And of course, there are some additional marks down here and some possible bruising down here, punctate marks down here, which may represent the lower teeth.
If we could just stop at that area, have you observed in your experience what you call that complex area pattern? Have you seen that before?
Not that exact pattern, no.
But have you seen any that is similar to it?
I've seen some characteristics of these patterns before, right. Yes.
And it is the appropriate methodology to zero in on one section, or is the appropriate pattern methodology to look at all the wounds and then reach a conclusion?
The second, to look at all the wounds.
And could you please describe?
Why don't we take our recess?
Okay, Your Honor.
Okay.
Thank you.
Why don't we take our recess? We're 2 minutes early.
Goodbye.
Why is she in a hurry? Light's not even on yet. We couldn't even take the time to turn the lights off. We got to sprint to lunch so fast. Is she also just sprinting off the bench here? I don't know. Guess we're going to wait and see if the courtroom stays dark. I think we can take it on faith that everybody is leaving. Well, I'm going to go ahead and assume that we're going to lunch and that's that. And if something changes, I'll pull it back up. Oh, I remember why we all like Dr. Russell so much from the first trial. She is a very impressive person. And boy, doesn't that life story give us just an enormous contrast with Shannon Burgess? If there is anybody who is in a position to say life got in the way of me continuing my education, surely it is this woman who went back to New York to take care of her sick and dying mother, and then went and worked as a law enforcement officer for a number of years on the night shift while going to school part-time during the day to get her degree. And then not only didn't stop there with that bachelor's she got, but went on to medical school, 2 different types of residencies, all of these different fellowships. I mean, very, very impressive person, very unique background, such a unique background, having the law enforcement experience, having the ER experience, and having the pathology experience. She's seen it all. So one thing that seems to be coming out very loud and clear from this foundation that Mr. Alessi has been laying here, they're going to ask her not just about dog bites. They're going to ask her, why is this not a motor vehicle collision? You might remember from the first trial, she wasn't allowed to go down that road. And the explanation for it was that she hadn't been proffered as an expert in motor vehicle collisions, those types of injuries. She had only been proffered as an expert in dog bites. Well, this is a new trial, isn't it? And so we can do a new disclosure and we can identify her as an expert in more than just the dog bites, but also in the motor vehicle accidents that she's seen and treated and autopsied and so forth. So I think we're going to hear a little bit differently from Dr. Russell this time. In the first case, all we heard about was the reason why it's consistent with a dog bite. I have a feeling we're also going to be hearing in this case why it is not consistent with a motor vehicle collision, that was in fact part of her differential diagnosis, was to consider and rule out that these injuries were caused as part of a motor vehicle incident. So, as far as our recap so far, we've been doing a massive amount of foundation, spent a lot of time on her qualifications, her job history, the number of autopsies she's done, why she has this unique exposure to dog bites, and not just dog bites generally, but also very specifically the distinction between everyday civilian dog bites and the bites you get from a trained police dog. Why they're different, why they're so extensive, and just how that can contribute to the injury pattern that is presented. She's taught about this stuff, but probably also about 300 or 3,000 or more motor vehicle accident patients that she's been involved with in a trauma 1 center. A trauma 1 center at the highest designation means you're getting the worst injuries. So you've seen pretty much everything a motor vehicle collision can cause. And based on that, yeah, she's also going to have some opinions I think we are going to hear from. So she has testified in court before about all kinds of different things. Pattern recognition, yes, important to doctors, important to forensic pathologists. It is a methodology that is taught. It's a methodology that's used. It's valid. It's normal. Really like the example that he elicited. For example, with child abuse, you might not be getting the story. Domestic violence, you might not be getting the story. You need to look at these injuries and evaluate, is this consistent with I fell down the stairs, I ran into a door, enter whatever trope explanation you want to use for why somebody is showing up in the ER with a busted jaw and a black eye and so forth. You have to be able to evaluate what that witness is telling you and determine if that is true or not. Could have spelled it out a little bit more, but maybe it's just, not necessary. Maybe it comes out on redirect or something if she's challenged on that. But why does it matter? Because you in the ER, you are a mandatory reporter. And so if you believe it's caused by abuse, if you're treating somebody in California's mandatory reporting law, if you're a physician, you're treating a physical injury that is the result of domestic violence, you are a mandatory reporter. You have to get law enforcement involved. So very important for you to distinguish when an injury, you know, that black eye and that broken jaw is caused by somebody fell down the stairs, as they said, versus it's not consistent with that. So what they're telling you is not the real story, and it looks actually a little bit more like a blunt force type of thing that you might expect from a physical altercation of some kind. So I like that he brought that out because, yeah, talk is cheap. And that's kind of why you don't rely on, for example, well, here's what the witnesses said about whether there was a Jeep parked there or not. And some said there were, but the majority said it wasn't. So you just don't really worry that much about what people said. It's a piece of information, but that's it. And if it's contradicted by the other evidence, then you would not accept that as evidence of anything really, other than maybe, you know, why you might be going into the ER, you know, telling an incorrect story. So got her story of how she found out about this case. She had read about it in the Boston Globe, understood there was this dispute, and got in touch with the LA District Attorney's Office. And here we are. Little bit of a preview as it comes to, as it goes to defensive wounds. A little bit of foundation as to that. Hey, if it's on this side of the arm, this is why. This is how people are going to tend to protect themselves. So very helpful for her to describe also that standard anatomic posture because, you know, yeah, if you think about yourself just standing up, which direction are your palms? Your palms can be any direction. I think most people might default to your palms are just inward towards your body, but in the anatomic position, palms forward, you got the shoulders fully externally rotated. So it's not necessarily obvious what the front and the back of the arm is from an outsider's type of position. So spelling that out really clearly, posterior is what you might think of as like the top of your arm, your forearm, your you know, tricep and stuff like that. It's that's the back. That's the back of your arm. So helpful just to get us oriented about what we're talking about. A little bit of preview of dog bites and how they work. They don't usually bite with all of their teeth. It's usually just the front teeth and the canines that are involved. There's often reactions. Either the dog doesn't get the grip or the person is pulling away or things like that. That's what can cause abrasions and punctures and stuff like that. Also, the nails and the claws can cause injury, can cause different types of injuries, usually just scratches, but sometimes it can cause a deeper wound as well. People do not go to the veterinarian for treatment of their dog bite injuries. That's a little bit of a preview of what's coming from the Commonwealth, isn't it? So, yes, tied it all together now. John's arm. Let's take all of this to John's arm and talk about John's arm. Based on your review, you formed the opinion that those wounds were inflicted as the result of a dog attack. Dog attack. Unequivocally stated, the dog bite doctor thinks this is a dog attack, dog wounds. Based on the patterns of what she sees, there are these different groupings. She's described the 4 different groupings of wounds and how they show the pattern of how the teeth moved. Started on this side, and then the dog either moved or the victim pulled away, and it causes the teeth to draw across the arm and create that scratch. The elbow is a little bit more complicated because the elbow has flexibility, and so you don't know what position the arm is in. but she's seen similar complex grouping patterns of wounds like that. You would not also preview of what's coming from the Commonwealth. Just look at the individual wounds in there to evaluate them. You have to look at the grouping as a whole in order to interpret what that pattern means. So that's where we were at before Bev decided in the dark, 2 minutes early, we are going to go take lunch now. Why the hurry? Why the hurry? The fan is back up in the courtroom. It's still dark. It's still dark in the courtroom. I mean, she was in a rush. Why don't we take our recess? Maybe Mr. Alessi wasn't supposed to get to what the actual opinion was before lunch, because now, of course, the jury is going to sit under lunch and think about, oh, is that it's a dog bite? No kidding. The arm's a dog bite. The Commonwealth didn't say anything about a dog in their theory. So quite interesting that these wounds that they say are caused by taillight pieces are identified, which, by the way, no medical expert testified to that, right? Squirty Bello didn't testify to that. They don't have a medical expert for the Commonwealth saying these appear to be motor vehicle accident taillight bites. Nobody from the Commonwealth is testifying these are taillight bites. But clearly, you know, they've had witnesses say that, including Dr. Welcher. Injuries consistent with the taillight. Well, except now you have the medical dog bite expert saying it's a dog. These are a dog. So that's sitting with the jury over lunch. That's what they're thinking about. Guys, let's go ahead and sit with that ourselves for a moment. We do have an hour lunch today, so a little bit of time to play with. But I have been sucking through my tea this morning. So I'm going to go ahead and do my step aside, do my rounds, check in on things, you know, probably 10, 15 minutes or so. Then I will come back. We'll take a look at what you guys have been seeing and thinking this morning, and we'll have a little conversation about that until people start flooding back into this darkened courtroom so that we can continue with Dr. Russell for the rest of the afternoon. So with that, guys, I'm going to switch my banner. Go ahead and hang tight if you don't mind, and I will be back shortly. All right, guys, welcome back. Thank you so much for hanging tight for me. So one thing I also did want to mention, because I did see it this morning, but I think we are still waiting for the actual documents to become available. A number of things were filed and hit the docket this morning. So we have a defendant's motion to impound defendant's motion to present a missing witness argument and request for subsequent instruction. Affidavit of Elizabeth Little in support. Then we have the motion itself, defendant's motion to present a missing witness argument and request for a subsequent instruction. And then defendant's motion for reconsideration of the court's March 31st, 2025 order excluding the testimony of defense expert Michael Easter. We saw this one coming. Okay, definitely saw this one coming, that they would just go through the Commonwealth's case, get to the end of it, and then go back and ask Judge Cannone to revisit that decision. Why? Because she said you'll be able to get whatever you need to get through cross-examination. So they have now cross-examined who the Commonwealth has called. They're going to be making whatever their offer of proof is as to why that is not adequate in terms of their ability to elicit what they want to and expect to elicit through Michael Easter. Will that be sufficient for Judge Cannone? I don't know. We'll see. I'm interested in this motion because I have mentioned, like, if I were handling this, I were dealing with these witnesses and so forth, I were dealing with this ruling, and I was trying to kind of make my record for why I think this decision needs to be reconsidered. I would have been doing things like asking Sergeant Lank, for example, or not Lank, Lieutenant Gallagher, for example. He put himself up there as the supervisor of the investigators and so forth for the Canton Police Department on that day. It was his turn. He drew the straw, so he's in charge. In fact, that's why he doesn't even have to write his own report. He has other people to do that kind of thing for him when he's in his supervisory role. So I would ask him absolutely everything about the policies. What are the policies? You familiar with this one? Do you train people in that? You oversee their compliance with it? It's part of what your job is as the supervisor, to make sure everybody's following the policy. And then above and beyond the policy, there's what you get taught in the academy. And then above and beyond the academy, there's just what you learn through training and experience is good practice, and so on and so forth. So I would do everything possible to get as much foundation. Anything that I'm going to have Michael Easter come in and testify about, I'm going to try to get these witnesses to say it. So I know Michael Easter, for example, is going to come in and say, yeah, Canton Police Department has a policy number, 8-1A that deals with how evidence should be secured into custody. Then I am going to ask Lieutenant Gallagher about Canton Police Department policy. What did I say? 8-1A. I'm going to ask him about that. I'm going to ask him to authenticate it. I'm going to want him to tell the jury what it is. If I need to ask him, did they comply with that in this case? Maybe I would, but typically you're not even going to have to. You're just going to know from the context. Is that what they did? We don't have the Canton Police Department, for example, booking that broken cup that they uncovered into evidence. We didn't have them booking the solo cups and the bag into evidence, right? Because there's no chain of custody for these things. They just kind of show up in Michael Proctor and Buchanan's possession at some point, and then they show up at the crime lab. And as far as I can tell, that's when our chain of custody starts for these items. So you may or may not have to ask him the kind of ultimate question there. Did they comply with the policy or not? We already know what they did. And if the policy says you should immediately, take it into custody and bag it and, log it in with the evidence clerk, then it's fairly obvious that they didn't follow the policy. So I would have done that in an abundance of caution, just gone overboard, and pretty much anything I want Michael Easter to testify to, I'm taking it to these witnesses. because I want to make the best record I possibly can. That, look, everything I would want to get in through Michael Easter, I tried with these other people and they wouldn't cooperate. Either they don't remember the policy, or they don't know, or they won't authenticate it, or whatever. Fine, but you have to at least make the effort. So I don't know if Judge Cannone is going to think there's enough here to overcome that ruling that she made, that, hey, if you just give it a shot on cross, just give it the old college try, you'll be able to get everything that you need to get from Michael Easter. I don't know if that's going to be the case or not. So I'm intrigued to see that motion once the document is available. So that one is not impounded. We will get a redacted version of the motion to present a missing witness argument and request for subsequent instruction. It is the unredacted one that is impounded. So there's something in it requiring redaction. My suspicion, grand jury materials. It's going to relate to grand jury stuff. Maybe also, personal information or whatever. But sure seems probable they're talking about Proctor. Doesn't it seem probable they're talking about Proctor? The other one, who could they be talking about? They could be talking about Trooper Paul. Could be talking about Trooper Paul. He did a whole analysis for the Commonwealth. 2.5 years. His theory was what drove the Commonwealth's theory of the case. So now all of a sudden, he's gone. He's vanished. Could be about him. So we'll continue to keep an eye out for those documents to land. If we see them, we will pull them up and have a little chit chat about them. Take a little look, see what they say and what they tell us. In the meantime, guys, let's talk about you. Let's talk about you in the chat. Is the chat having a good day today? Is the chat having a fun time today? Did we come to an agreement on what the genre would be of the band Dog Dentition? Dog Dentition. Did we reach a consensus on that? Is this going to be ska? Is that going to be new metal? Is it going to be some type of folk alternative indie like Dropkick Murphys? I definitely had Dropkick Murphys going in my mind when I was thinking about Dog Dentition. What have some of your comments and questions been? Let's just go ahead and take a look, shall we? Plain Whisperer. In Paul O'Keefe interview with CBS Boston from July, he explains the family were the ones who immediately fingered Karen Reed on the day he died, and they drove the theory of car collision. They were convinced of her guilt. That came through from that clip Karen, he played of Karen, right? If we take away this whole, we just did that to make Karen look bad because she's characterizing Peg O'Keefe, and we take that at face value, Peggy O'Keefe, the morning of, like later in the day, sometime around noon, John O'Keefe has been declared dead at like 8:30, something like that. Within hours, Peggy O'Keefe is leaning over the island, the kitchen island, to Karen, saying he looks like he was hit by a car. He looks like he was hit by a car. Yeah, consistent. They already decided she was guilty, and they didn't need really much, if anything, to sell them on that. We talked about that at the time when Peggy O'Keefe testified. It's not a good look to show so openly how antagonistic you are to Karen, how eager you are to blame her for stuff that is not really the thing that normal adults would blame someone else for. You left him at a party? Yeah, because he's a grown-ass adult who can decide he wants to go to a party. He's a 40-some-year-old man. He can be dropped off and left at a party. And all it really does is just highlight, you would blame her for anything. You blame her for anything. It was her fault for dropping him off. Wait until, you find something you can sink your teeth more into, like, ooh, this cracked taillight that starts to evolve over the course of this day and in the following days. Could I have hit him? Did I hit him? Suddenly becomes I hit him, and the taillight becomes holes with a thing sticking out, and she points it out to them, and she mentions it in her initial phone call to Carrie Roberts. None of this stuff is being told to police the day of. It all has to kind of grow and emerge over the following days. So, yeah, I think that raises an interesting question. Do you call Paul O'Keefe? This is your theory as the defense. They swallow it because they're happy to believe that it's Karen. That's why they would buy into it. The investigators want to protect Brian Albert, the thin blue line. They want to close ranks. Why would the family buy into that? Because they're perfectly ready to blame Karen. Perfectly ready to blame her. So if you're protecting Brian, your thin blue line closing the ranks involves throwing Karen under the bus, they are going to be just fine with that. It's giving them what they want. Bird Fam Bam. She told the jury there was a first trial. She said it many, many, many times. The first trial, also the FBI spilled the beans that it's the FBI. That Southern blonde lawyer. Will AJ have her declared hostile? Is that a formality in Massachusetts? I was actually kind of curious about that and tried to look into it a little bit. I found a case. I found this one case, Commonwealth versus Jermaine Carter. It's from way back in 1995. And all I can really tell you is that, so I'll just read you part of it. As to the witness issue, at the voir dire of Furtado, the mother of the defendant's son, the prosecutor requested that she be declared a hostile witness so that he could examine her regarding her alleged prior inconsistent statement concerning the events surrounding the alleged murder. Notwithstanding that Benoit, this is a case, was decided February 12th, 1992, 9 months before the trial of this case, the defendant objected only on the ground that the witness should not be declared hostile. He argued that the prior statement was merely a mistake and that the witness had admitted that to be so. Defendant's counsel then added, I have no problem in the prosecutor showing her statement or playing the statement and showing that she testified or that she made a statement that was somewhat different. The judge, over the defendant's objection, declared the witness hostile. And at the trial, the prosecution, without objection by the defendant, used the prior statement in his examination of Furtado. So the issue in this particular case had to do with the use of the prior inconsistent statement. It wasn't like, declaring her hostile or not hostile was the issue here. So this is what I was able to find on the fly. And it implies at least that, yes, there is a formal declaration that the court would have to make, or at least a formal finding the court would have to make as to hostility in order to get that permission, granted. There is generally in the rules, Section 611 on the guide to evidence, the court gets to exercise reasonable control over the mode and order of examining witnesses. So they have some, discretion to be able to do that. However, then there's also subsection, this is Rule 611 BC, which is leading questions. Says leading questions should not be used on direct examination except as necessary to develop the witness's testimony. Ordinarily, the court should allow leading questions, 1, on cross-examination, or 2, when a party calls a hostile witness an adverse party or an officer or agent of an adverse corporate party or an investigator appointed under whatever this rule is. So we know now that you get to use leading questions, not just in cross-examination, but also then with hostile witnesses. So I went through, a little bit of the notes on this rule. It just says whether whether the decision whether to allow leading questions should be left for the most part to the wisdom and discretion of the trial judge instead of being restricted by the mechanical operation of inflexible rules. Some judges in Massachusetts require that when the subject of the cross-examination enters material not covered on direct, the attorney should no longer use leading questions. This is what I was talking about before when it comes to Proctor and the downsides of calling Proctor. Some judges would do what in my mind is the normal thing and say when you're dealing with cross of Proctor, meaning you're asking him about the stuff that was brought up on direct, you get to use your leading questions. But once you go beyond that scope now, it's just you're getting flexibility to do that because you're not having to recall him yourself. It's an economy issue. But because we're allowing you that economy, we still need to pretend like you're back on direct now because this wasn't brought up in the scope of cross. So you should have to do your same direct like you would do with any other witnesses. But all we have here is just that some judges might require that, meaning others might not. And so it appears to be entirely up to them. What do we think? What do we think Judge Cannone would do in that particular situation? Otherwise, as a general rule, leading questions should not be used on direct examination. There are many instances where they are permitted in the discretion of the judge. And then they go in to talk about adverse parties, but they don't talk specifically about hostile witnesses. So it's a very broad kind of overview of what I was able to find law-wise in terms of handling hostile witnesses. The case law seems to suggest that's a decision that the judge makes formally on the record, but not necessarily required. All of it just in general seems to be discretionary, especially to the extent that it's going to, can you ask leading questions or not? So, but bottom line, he didn't go through that. Wasn't necessary. Summertime, how are witnesses declared hostile and what difference does it make as far as questioning goes, etc.? Thank you, Andrea. Well, we just walked through that. And, you go to the judge and you ask him to be declared hostile. The rules didn't give us a whole lot of, really anything to kind of understand what the basis is, what's the justification for that. So there's probably some stuff in the case law, but it's just not something that I'm really able to pin down and find a lot of examples of just while we're kind of midstream here. So appears to be something you have to ask the judge to do, but there's flexibility for the judge to handle that more or less however she wants. Bird Fam Bam, just when I thought this case could not get any worse, these departments are disgusting. What, you got a problem with BPD telling her, make sure you do the right thing? In this case, it's important to call that out in this case because there might be a question about whether you do the right thing or not. It doesn't just go unsaid that you would do the right thing. Is that a little bit of a confession? A little bit of a confession that you have a need to say this kind of thing anyway? Why would you have a need to say this kind of thing? Surely it goes without saying. You're there to tell the truth and you're there to do the right thing. In this case and in any other case, because of course there's nothing special about this case just because Boston police officers are involved. They're the same as any other witness. They'll be investigated the same as any other witness. They'll be held accountable the same as any other witness. Surely that's our baseline expectation, isn't it? Perfectly normal. No reason to do anything different here. So why in this particular case we need to be reminded to do the right thing by the commissioner of the Boston Police Department? Pretty gross, isn't it? Texas Sister 2, why have Brennan have a witness read the messages and not the defense? I don't think the defense ever intended for this witness to be the one who reads the messages. They want to present them through somebody else. My guess is going to be Yuri, but we'll see. Anybody for whom Proctor's text messaging presents some kind of relevant issue, for the defense, they can be asked about him. So Yuri, because he was the supervisor and he already kind of took on that role, and he, insists he never doesn't know anything about this at all, never seen it, never heard about it. Oh, so perhaps we should go ahead and put you on the stand so that you can hear for the first time what Proctor was texting to his friends, and then you, as your supervisor, go on record with what you think about that and what that says about his honesty and integrity of his investigation. So I think, yeah, Hank is just trying to take the sting out by getting some of the messages out himself, selecting which one of the messages, he's going to get out himself. It's honestly not a bad move by Hank, kind of a smart move. Although you do run the risk now of looking like the asshole trying to make this guy say things that even you, Hank, even you didn't have the balls to say what Proctor was texting in open court. You didn't have the balls to say it. That's disappointing. Alyssa Ramirez, did she just Kool-Aid man the door to the FBI? It's out. Is Bev going to say the door is open? No, I don't think so. One of the points Hank brought up on his cross, or the recross, one of them, I don't remember which one is, and it is actually a good point. The defense is calling her. So it's the defense that has the obligation to make sure that she understands what the restrictions are on the testimony, what the restrictions are on viewing the trial, and so on and so forth. So if they didn't do that, it's not something that the Commonwealth can be penalized for. Remember in the Depp trial, viewing some clips, that was enough to get Gina Deuters tossed. She got tossed because of that. Wasn't allowed to testify about anything that she observed or anything that she knew, because she admitted she had watched some clips of the trial while subject to the sequestration order. If she wasn't supposed to mention FBI, if she wasn't supposed to mention the prior trial, if she wasn't supposed to watch anything in this trial, because it's the defense calling her, it's their obligation to make sure she complies with that. So I don't think this is going to be opening up the door, frankly, even if it had been elicited by the Commonwealth. The defense can't open the door themselves, so they can't have their own witness kick it open. But even if it had been elicited by the Commonwealth, Bev is going to take the approach of just let it go. Don't highlight it. Don't emphasize it. Don't repeat it. If it happened, it happened, but not anything they're going to bring out a bullhorn now and continue to announce. Mr. Pastulio, can they use the fact that Proctor didn't testify in argument? That may be what they're trying to accomplish with that motion about the missing witness. Could be him, could be Trooper Paul, could be somebody else I haven't thought about, but those are the main ones that stand out in my mind. Could be Good, could be Seraph. I mean, seems like there's a few people that might be contemplated by that type of ruling. So they have to get permission to do that. They have to meet the standard to be able to present the missing witness instruction. Here's what I'm going to do. When we get back into session in the afternoon session, I'm going to go ahead and pull up the missing witness instruction and kind of the rules about it and stuff, so that we can look at that when we're done with court today. And then maybe I can tell you a little bit more about whether they're going to be able to use this or not. NDP 0911. In this case, I would love to see at least one instance of a competent law enforcement officer. This testimony is as cringeworthy as the evidence collection and documentation. They just don't have any compunction at all about making it clear how much they hate the defense. Right? It doesn't bother them at all. They stand up there and talk about how impartial and unbiased and how they only care about the truth and stuff like that is. But when it comes to providing information to the jury, if the defense wants it, they're going to fight and they're going to resist and they're going to try to work around it and they're going to try to explain everything and they're going to try to excuse everything and they're going to try to characterize everything. The defense wanted me to lie on the stand. Well, the defense hasn't asked you to lie on the stand. The defense has simply asked you about the statements that you made. and understanding you now recant them, everybody knows that will come out, whether the defense asks you about it, whether the prosecution asks you on redirect. Nobody asked you to get up on the stand right now and say, based on my own independent knowledge, this is what happened. They know it's just based on what you told the FBI back at the time. But they gotta wiggle and color and characterize and resist and fight and kick and scream. And it sends such a message that the truth only matters if the truth benefits one side. If the truth benefits the defense, then we're going to come in with all this attitude. If the truth benefits the Commonwealth, then we remember everything and we're compliant and we provide them with what they want. So it's just visually such a contrast by people who are literally, by virtue of your position, supposed to be above all that. You're supposed to be above all that. But that is clearly not the state of affairs in Massachusetts law enforcement. Nick Starrow, with this, has she opened the door for those agents being called? Here's the issue with the agents being called. I'm not sure that they would have necessarily been precluded anyway if they were necessary for foundation or to authenticate something to come into evidence or something like that. Maybe we'd have to sanitize who exactly they are and where they're from or something like that. But I'm not sure that that in and of itself is the impediment to calling federal agents as witnesses. The main problem, the main impediment with calling any of the federal agents as witnesses is that you're back in TUI land, okay? We've heard so much about TUI over the course of this case. TUI is a specific case that deals with the fact that under the Constitution of the United States of America, the federal government, generally speaking, has supremacy over state issues kind of on the same topic, dealing with the same issue. And so because federal law is the supreme law of the land, federal agents, they're not subject to the jurisdiction of state courts. And so what happens is if you subpoena a federal agent, they don't have to do anything with that. They don't have to do anything with that. So what happens? A federal agent doesn't show up to court. A state court gets all mad. Well, this agent is in contempt. I order them into court. So now I'm going to issue an order to show cause and demand that this person come into court and explain to me why they've ignored that order. What is that federal officer going to do? They're going to walk right into federal court, say, please void this, because that judge, that state judge, has no authority to compel me into court. I can only be compelled into court by the supreme law enforcement of the land, the federal courts. So they'll move to quash it and they'll win. That's why we have TUI at all, is because you can't subpoena a federal officer either to come in and testify or to provide any kind of evidence unless the federal agency, who is the supreme, I'll say it last time, supreme law of the land, unless the federal agency decides, okay, you can come in and testify, you can provide that particular information, they don't have to. The state court can't compel it. So it is with the grace of the federal agency that any of this happens at all. So this is kind of a long-winded answer to the agents being called, just as a general proposition. You would have to subpoena the agents. You would have to go through the TUI process. You'd have to establish to the satisfaction of the agency, what do you want to call this witness for? What are they going to testify to? What are they going to be confronted with? And then if they decide they want to allow the witness to testify, okay, they can. But if they decide no, they won't. And there's some guideline for what they have to decide in the TUI regulations for each agency. But by and large, pretty much all of it has catch-alls. It's always going to be in the discretion of the Attorney General. So that's the main impediment for agents being called, is you have to go through the TUI process to get it done. And even then, no guarantee that it's going to happen. Alyssa Ramirez, do you think Brennan is regretting not calling Proctor, given this witness is defensive and wasn't even involved? How bad will Proctor be if called? Proctor at least had a trial run already. He's already had an opportunity to try out different explanations and excuses. And I don't stand by these texts, but it didn't affect the integrity of the investigation and stuff like that. Proctor at least has had a practice run to see how it worked out. Didn't work out that badly because they didn't acquit her. At least of one of 3 charges. Legally speaking of any of them. So, I mean, they didn't convict her, but they didn't acquit her. So did it really go that bad for Proctor? I don't know. I don't think Brennan is regretting not calling him. I think he is angry, or he wishes that the judge would have made the defense call Proctor. Because, like I said on Friday when we started talking about this, I think Proctor remaining a ghost in all of this is beneficial to the defense. That helps the defense far more than it helps the Commonwealth. If he's up there on the stand, now he's a living, breathing, flesh human with a face and a voice and a family and a way of saying things and history and all of that stuff that you start thinking about when you start thinking about what he's at least implicitly being accused of doing in terms of tampering, guiding the investigation, potentially tampering with evidence, being determined to make sure Karen's fucked, as he said. You start to put a face on it, and you have to sort of reconcile the accusation with this person, this actual person that you're confronted with. It's much easier to imagine a ghost. It's much easier to imagine a ghost who would go in and be biased and fabricate things than it is a living, breathing person. So, my view, Proctor being a ghost, it's beneficial to the defense. So they don't want to call him for that. I think Hank wishes he could have forced them to call him so that he's not a ghost. For them to be able to get that information in, they have to make him a living, breathing human, but they didn't have to. So now it's back. Now it's back in your court. Now it's back in your court, Hank. Back in your court to call him or not. If you want him to be a human face to the jury, it's really looking like you're going to have to be the one to try to achieve that. Duncan, Idaho, she's showcasing the training of police officers to be as evasive and contentious as possible when answering questions in court. Why can't the police stand behind their answers without 5 minutes of hedging, qualifying, and gaming? Yeah, I mean, not every officer is like this. I don't know what else to tell you. Definitely a vibe in this whole area in Massachusetts, from everything I've seen in this case. You're not going to get, I don't care if you're talking about the local, the state, or whoever. It just doesn't seem that you're going to get anybody who's real happy to provide information that the defense is looking for, that the defense considers helpful. You don't always get that in a case. I remember a case I had. We're dealing with a motion to suppress, and the officer who's on the stand that's testifying, nice guy. Turns out we went to college together. I didn't really remember him at the time, but he remembered me after the fact. So, we have to do a cross-examination about what he observed and the conclusions that he drew from that. Why did you think this constituted probable cause? So one of his reasons for searching this car without a warrant was that, or basically impounding the car to later search it. One of his reasons was that there was, he called it Mentos, but I think he meant an Altos. There's an Altoids container sitting like on the front dash. And he's like, Altoids containers, they're really commonly used to hold paraphernalia and stuff like that. And so I asked him on cross-examination, well, isn't it true in your experience you found that Altoids containers sometimes contain Altoids? He's like, oh, yes. I mean, duh. You know, it's like a duh. It's a duh kind of thing. Duh. Of course they sometimes contain Altoids. You don't have to fight me over something that is so, obviously apparent and true is the fact that Altoids containers do sometimes contain Altoids. They are not explicitly always repositories of drugs and drug paraphernalia. So as it turned out, that ended up being one of the dispositive issues in this case, because in Washington, we have these rules that basically, if evaluating probable cause, you have something that is equally consistent with guilt and equally consistent with innocence, they can't rely on that. And when all you pretty much had was the Altoids container, it's equally consistent, if not maybe more consistent, with having Altoids in it than it is with having drugs in it. So you don't get to use that for PC. A cop like one of these cops would have already known where I was going with that and would have fought me tooth and nail over this straightforward concession that yes, sometimes Altoids containers have Altoids in them, because they would have been thinking down the road. They would have already known, this is what I want to do with it, and it's going to be helpful for me to get that information. So we don't want that. So we're gonna fight you tooth and nail. Not every department is like that. I just brought up this example to kind of explain. This is a cultural thing. This deals with the culture of law enforcement, the community, and so forth. So it may very well be the case in Massachusetts that like all of the law enforcement is like this. I'd be willing to bet it's pretty likely that maybe in some smaller communities, more rural communities and stuff like that, it might be a little bit different. And I've talked about that before too, why the culture is so different in places where the police officers are also the little league coaches. They're also the people that you go to church with. They're also the people that are in the Rotary Club with you. You know, there's much more involvement and integration into the community as a whole that improves some of that accountability, I think, than when you have large urban law enforcement agencies where you have, cops that hang out in their car, and we have this distinction between us on the force and everybody else who's not in the force. And we don't really run into them because we don't socialize with them. We socialize with other cops. We hang out with other cops. Just a very different vibe and a very different culture, I think, that you get because of that. So this is totally just kind of me anecdotally spitballing. But like Boston, yeah. Boston cops are hanging out with other cops. They're doing cop things. Probably not nearly as much integration with the community as a whole as you might have in a smaller community. Like, I don't know, maybe Williams, something like that. Trying to think over on the west side of the state. What's over in Western Massachusetts besides Williams? I don't remember. But just generally a little bit more rural. Yeah, if it's helpful, they're going to fight. That is clearly the culture of what we can expect in this particular case. The incredible shrunken bee guy. Surely this jury is not as dumb or as brain dead as the Commonwealth hopes. Dance, monkeys, dance. Yeah, you're here to answer the questions, ma'am. Not here to argue with them. Not here to qualify them or whatever. Do your job. You're just here to answer the questions. Why do you got to make it a whole production? Then the takeaway from your testimony is the production you just put on and not necessarily what you had to say. Was what she had to say really that compelling? Berkowitz and Higgins together in the Sallyport with Karen's car for a wildly long time. That's what the defense wanted out of all of this. That's why they brought her in, was that statement. That statement which she is now recanted. Nope, couldn't be it because my shift ended at 3:45, so I couldn't have seen it. You have no memory today, 3.5 years later, that you did or didn't stay late after your shift, for example. Whether you might have confused it with the next day shift or anything like that. Don't know. The explanation now is just you generated this very detailed, entirely false memory out of who knows what. Ugh. But that was the trade-off that the defense made. They wanted that statement in front of the jury enough to take on all of this potential damage, I guess, about the defense bullying you. The defense wants you to lie on the stand. The defense is threatening you with this, that, or the other. We don't know how any of this is landing with the jury. Once again, dumb or as brain dead as the Commonwealth hopes, we don't know. Because unfortunately, you can't say, no, I have 100% confidence that the jury is not brain dead or dumb. You don't know. You sure hope. You sure hope. But there's no intelligence requirement to serve on a jury. No qualification to have common sense or anything like that. Just the best you can figure out about who people are and how they think through the voir dire process that you get to participate in and somewhat conduct as an attorney. So we would certainly like to hope so, incredible shrunken bee guy, but unfortunately we just don't know for certain. We really don't. Summertime, can defense call a real cop now? Clearly jurors in this area have never seen an example of one with integrity. Can Judge Bev allow it? Oh, like Michael Easter? Like Michael Easter? I don't know. We'll see. We're getting Dr. Russell at least. We're getting Dr. Russell at least. Does she seem like she has integrity? Not going to spend an awful lot into her, her career as a law enforcement officer. It just isn't relevant to this case, except to the extent it makes her particularly interested in the issues that's presented by this case. Yeah, I mean, if we're just pulling from Canton, the investigators, the folks involved in this case, who do we even call? Who do we even call? Barros? Barros is a possibility. The Dighton police officer who was there for the tow. Maybe him. We'll see. Kim's expired registration. There's no videos of Higgy and Berkey in the Sallyport, so how would she get that from the media? Great question. Great question. If she's supposed to have false memories because she has incorporated things that she learned from the media into her own memory, then where did she learn before August of 2023 that there was any issue with Higgins and Berkowitz being together in the Sallyport with Karen's car? Where did any of that come up with anyway? Like, this is not something anybody has said or theorized or whatever, is it? It's very specific. It's very specific. If you were following the case in the media and you were following the defense motions and the arguments and so forth, I'd have to go back and look at what the exact timing was relative to this interview. But this interview is after the feds are getting involved, and the defense learned most of what they learned only long after the feds started getting involved. It was in February of the following year, 2024, when the TUI information starts coming in. So it's not clear that even the defense knew this at the time that she's having this conversation with the feds. So yeah, where's the trigger? Where's the source of the information that she just somehow incorporated into her false memory? It's a great question. This is the first time I'm ever hearing anything about them being together in the Sallyport. Don't recall seeing anything like that in the media. Dr. Bob, Andrea, I was thinking all through this about your young jury discussion last week and how they may think differently about this police officer. If the young jury is going to tend to be more skeptical of the police in general, then I would certainly think that this witness's behavior has just reinforced that. This is exactly why you're not going to give law enforcement witnesses an awful lot of weight, because she's demonstrating exactly why they're not here to be objective. They're not here to tell you the whole story. If it benefits the defense, they don't want to tell you. They want to keep that to themselves. The witness herself is a little bit younger. Don't know how old she is, but she doesn't have doesn't have the gray, doesn't look like she's particularly old. Are they going to identify with her just by virtue of her being like them in that way? Younger rather than older? I don't know. But if they are going to tend to be skeptical of law enforcement just because culturally you've grown up in an area where in an era where law enforcement abuses are just too commonly known and discussed and talked about, and the prejudices of law enforcement and so forth are just out there and known, then I don't think this witness gave you very good reasons to think that those things wouldn't apply here. I would feel like if that's your bias, yeah, she's just confirmed it. She has just shown you why that might be a good position to have when it comes to law enforcement officers. One of skepticism. Skyway, if I'm ever on a jury, I will do my own research. Why be the only party playing by the rules? Corrupt judges and prosecutors do not get to demand honor from me. Wouldn't encourage anyone to take this position publicly, certainly. This is the $1 million question, isn't it? When the other side is playing dirty, what are you supposed to do? Are you supposed to keep the high ground? Are you supposed to get back in the mud with them? Everybody is going to have a different approach to that. Everybody's going to have a different comfort level with it. I don't care if you're talking about you're in a boxing ring and a guy is fouling you, low blowing you, headbutting you, whatever. Some people are going to respond to that by complaining to the ref. Think like Lomachenko likes to point stuff out to the ref all the time, complain about it, maybe get him to pay attention to it. They don't. Well, you might end up taking a bad loss to a retired cab driver.
Dr. Russell.
Good afternoon.
Your Honor, if we could please publish Exhibit 1 in evidence.
Okay.
Mr. Wolk. Dr. Russell, do you recognize Exhibit 1 from your review of the documents in this case?
Yes.
And what is it that Exhibit 1 represents?
It's a picture of the forearm of the decedent.
And we left off at lunch, and I'm not going to cover too much old ground, just to reorient ourselves back to where we were. You were discussing the basis of your opinion and conclusion that you said that these wounds were caused by, why don't you restate, well, let's continue on in the basis of your opinion. Let's just continue on. Can you go through what is in Exhibit 1 and describe how it is that you came to your opinion?
Well, I observed multiple patterns of striations or linear abrasions.
I'm sorry to interrupt you so soon. Do you have the pointer in case you want to use that available?
Thank you.
Thank you.
So there's multiple groupings of linear abrasions, and linear means like a line, linear. So there's multiple of those, and here's one. Here's another one closer to the elbow. He has another one closer to the wrist. And he has another array of linear abrasions near the elbow.
In terms of these wounds, in assessing their source, do you look at them individually, collectively, or both?
Both. I look at them individually, and then I put them in context of how they relate to one another.
And how they relate to one another, is there a name of that methodology that you use in terms of how they relate to each other?
Well, I think it's a pattern methodology, pattern recognition.
And what pattern is it that you see here with regard to all of these wounds on the right arm?
Well, I see multiple linear groupings together in a area from the mid arm to the mid forearm.
Is there any analysis of direction that is involved in your analysis?
Yes.
What is it?
I believe that these wounds were initiated closer to the anterior surface or the front of the forearm.
I'm sorry, Dr. Russell, to interrupt you, but there's a fan back here which I can hear, but if you could just keep your voice up, that would be great for me.
Yes, I believe they all started closer to the anterior or front portion of the arm. Like they started up here, up here, and the direction is towards the posterior portion of the arm.
Now, if we could just go back briefly, I want you to do a comparison. If we could go back, Your Honor, please, back to Exhibit 157 that we had up earlier.
Okay.
I'm sorry, 167. As between 167 and 1, which one is closer in time to when Mr. O'Keefe was located?
The previous one.
All right, so let's go back to the previous one. So that one is closer in time to when Mr. O'Keefe was located on January 29 of 2022, correct?
Yes.
And so January 29, 2022, if we can go back to Exhibit 157, or 67, excuse me, 167, can you tell when this picture was taken from the depiction?
Well, it says January 31st.
Okay, so is that the basis for you saying that the Exhibit 1 was closer in time to when Mr. O'Keefe was located?
Yes.
All right, so I want to do another comparison, have you do another comparison of the two. If you can look at what is depicted in Exhibit 167, and now go back to 1 and see if you see any differences at all as to what's depicted. Do you see any differences with regard to the wounds on the arm, or the arm just in general? Let's go back to, see that now, let's go back to 167.
Well, the coloration of the photograph is slightly different.
And what do you mean the coloration?
Well, the skin tones here are more yellow than they are in the previous photograph.
And I'm sorry, what is, do you have a conclusion as to why there is a difference in skin tone in this exhibit compared to Exhibit 1?
Well, it could just be technique, lighting technique. I do see some lividity on the chest, postmortem lividity, and that's what that means is pooling of the blood, which happens after death.
Can you explain to the jury what lividity is?
Yes. So, blood follows the laws of gravity, and the
One of the
blood
few
will
things it does
settle
in Canton.
to the dependent parts of the body. In this case, the body the body of Mr. O'Keefe is horizontal, and so the blood is going to settle from the top of the chest, which would probably be up here somewhere, down towards the back, which would be the inferior portion of the chest in that position. And likewise, it would happen on the extremities too.
So you just mentioned the extremities. Do you see any lividity on the extremity here, the right arm?
You know, actually, there is discoloration over here in the elbow area. I do see some lividity. Okay, so there's several areas of lividity on the arm. I'm sorry. There's some right here. This redness right here in the near the wrist. I believe that that's postmortem lividity. I believe that this redness in here near the elbow is also postmortem lividity. And yeah, that's what I believe. Okay. That's postmortem lividity.
And again, lividity is that you said something that sets in after time, after death?
Yes, it's the pooling of blood.
Okay. Is there, with regard to this depiction, do you see any bruising with regard to that elbow?
You know, I think that initially, earlier this morning, with the lighting, I may have said that this was bruising, but now as I think about it, and I see all this other lividity here, lividity over here, I believe that's postmortem lividity.
And if we could go back to Exhibit 1, and you said this is the one that's closer in time to when Mr. O'Keefe was located. Do you see any lividity or bruising with regard to that photo?
Looks like some yellow spots.
I don't see any definite bruising. I do see some discoloration up here near the shoulder. I'm not sure if that's postmortem lividity or not. It could be early postmortem lividity.
Okay. So if we could, thank you, Mr. Woe, can we take that depiction down for the moment? What I'd like to do is to, and we'll come back to that. If we could have the lights back on, please. Thank you. Have you had experience prior to this case in performing your pattern recognition methodology skills with regard to dog-inflicted wounds on humans? In other words, have you seen dog-inflicted wounds that have a pattern on humans?
I've seen dog wounds that have had a pattern. I didn't need to do it to utilize that skill because I also had other information about the case. You know, for instance, police officer or the victim himself said, you know, I was attacked by a dog.
Right. And for those that can you give an example, like in the ER, just as to how you would come to have that knowledge or otherwise? How would you generally come to have the knowledge as to a potential source of the wound?
Oftentimes it's the victim that tells me, or in the case of the law enforcement dog bites, I had both victim and police officers tell me that the police dog, inflicted these wounds.
And so and how many times generally in your career, we discussed it this morning, how many times generally did someone present with dog-inflicted wounds and you were told that these wounds were from a dog? Roughly how many in your career?
Well, all of the law enforcement dog bites. So that would be 40 to 60 or so of those. Plus, most of the non-law enforcement dog bites, the patients or the mother have said this, a dog bit me or a dog bit my son.
And for those that where someone said something, the dog bit my son, were the wounds that you saw similar to or different from the wounds that are depicted in Exhibit 1 that we've had up on the screen?
On the civilian dog bites, there's some similarities, but not as many striations on the civilian dog bites.
And are the more striations on what's depicted Exhibit 1, does that lead you to more easily conclude it's from a dog bite, or is it harder for you to conclude it's from a dog bite?
Neither.
So is your prior experience as an emergency room physician, as a physician in Cochrane, does that experience allow you to exercise pattern recognition skills with regard to Exhibit 1 in Exhibit 157?
Objection. Sustained.
Do you use your pattern recognition, did you use your pattern recognition skills in evaluating Exhibit 1 in Exhibit 157?
Yes.
In terms of characteristics of dog bites, if we can go back to Exhibit 1, please. Is Exhibit 1 highly characteristic of a dog bite or lowly characteristic of a dog bite?
Yes. Sustained.
How would you describe the characteristics of what appears on Exhibit 1?
What I see on Exhibit 1 is multiple strikes from a dog.
I'm going to allow it.
Yes.
Can you please repeat your answer?
Yes.
What you see?
Multiple strikes from a dog.
And with regard to, do you see any characteristics in terms of a medical observation with regard to those strikes?
I don't understand the question.
Are you familiar with the medical term pathognomonic?
Oh, yes.
What is the definition of pathognomonic?
Pathognomonic in medicine means that the characteristics of a condition are so highly specific and unique that they basically say that it can only be from a certain condition and no other condition. So to the exclusion of all other conditions. That's what is meant by pathognomonic. At least that's my understanding.
Do you consider these wounds pathognomonic?
Yes. Sustained.
How do you evaluate these wounds in terms of what you call their characteristics?
I characterize them as highly specific for a dog attack.
Yes.
I'm going to strike the last word, Mr. Wilson.
For dog attack?
In terms of the characteristics that you have talked about, are there any other aspects of dog dentition that you can discern from Exhibit 1?
I don't understand the question.
You mentioned earlier when we had the dog dentition exhibit up, you mentioned an arch. Is there any aspect of Exhibit 1 that concerns an arch?
Yes. There is, in my opinion, an arch-like structure right here towards the lower part of the forearm, towards the wrist, suggesting that this here is made from the very front teeth of the dog. Now, when one looks at these injuries or wounds, one has to remember that, number one, this is not a mannequin. This is a person whose skin is somewhat elastic, whose skin will slide over the underlying bones, and so therefore some of the wounds may have been created by the exact same teeth, for instance, but look differently, depending on the part of the anatomy, the elasticity of the skin, also depending on things like if there was clothing or something in between the teeth and the skin. So one has to consider and also there may be motion motion effects. The living victim could have been pulling away from the dog. The dog could have been, pulling or jumping and only catching a glimpse, a little slight bit of the skin with his teeth. So there's a lot of movement and things that one has to consider when an injury is inflicted on a body.
Objection, move to strike.
I'm going to strike that.
Can we approach, Your Honor?
Sure.
Yeah, I don't know why we're striking that. Was it unresponsive? Perhaps. He's just trying to get her, it sounds like, to detail what is it specifically when you looked at this photo that made you say, oh, those are dog bites and not just dog bites. Those are highly specific wounds for a dog. Not attack. Not attack. This is a loving puncture bite by a dog. Come on, Bev. What a ridiculous striking. She can't say the word attack. What else is it doing when a dog is chewing on your arm multiple times? She said it shows multiple strikes from a dog. What is that besides an attack? Pathognomonic, had to go look that one up myself. Pathognomonic, it's with the GNO, pathognomic. That's why it's gnosis is the etymology from it. The Greek GNO, GNOSIS. That's Greek for knowledge. So sounds like it's saying you would know the source of this injury because it is so specifically characteristic. It's a known injury. Can only come from one specific source. At least is how I kind of understood that term. So, because they haven't gone through and coached the witness to say specific things, sometimes you ask open questions and the witness isn't quite sure what you're asking about. So you get comments about the skin elasticity and why the wounds might look a little bit different than other ones and so forth, which does make sense. The skin is different. The position could be different. The movement could be different. The clothing could be different. But they would still be created by the same teeth. How would you know that? That's where I think he's trying to get to, because you can see from the patterns how the dog teeth inflict these wounds. And I think that's all he's trying to get her to elaborate on. But if you haven't coached your witness, they don't necessarily know that. So we'll see. I think he's probably Hank is now going to come back and yell at her about the bruising photos, bruising. Don't you know what but you're a forensic pathologist. You don't even recognize lividity in the photos, and you didn't say that before. And he's going to try to poke holes in something like that. Can already kind of see that happening. Discoloration, lividity. You're saying that's lividity, but it's on this side of his shoulder. And don't you know he was found on his back? Isn't that not how lividity works, doctor? Something like that. We'll see. We'll see. It did look like there was more yellowing in the second photo, but it looked to me like there was some yellowing in the first one as well, the hospital one. Not nearly as much, but yellow isn't what you'd expect from a new bruise, right? If he's just gotten bit and there's bruising, you wouldn't expect that to be yellow. Yellow is the later stage of the bruise's development. There's like whole charts on this and stuff. Trying to remember what that's called. There's like I feel like there's a name for it. It's a colorimetric scale. Is that what it is? As a visual aid for bruise age determination. So anyway, yeah, you can kind of tell by the color generally. Is this a new bruise? Is this an old bruise? You're looking for, is it pink? Is it purple? Is it brown? Is it yellow? And the different colors give you a sense of where in the bruise development that particular bruise is. Anyway, yellow is down the road. So even if it is yellowing, I don't know that would be bruising from a dog bite, because it seems like it would be too recent. But I don't know. I just see the photos. I don't necessarily know what they mean. But I did notice a little bit of yellow, at least in both of them, I thought. So what's the yellow if not the bruising? People don't get embalmed before autopsy. It would be a problem. It would interfere with being able to interpret. So that's why they, sit in the cooler. Sit in the cooler, slow down the decomp process until you can get the autopsy done. And I would imagine, it's probably pretty close to bringing the process to a halt, but not completely. You can't completely bring the process to a halt. So that maybe be part of the explanation. Don't know. Oh, other folks pointing out betadine stains like that. Yeah, it does. That's a good point. That's a good point. Very yellow.
Mayor, Your Honor?
Yes.
Thank you. If we could put the Exhibit 1 back up on the screen, please, Mr. Wolt. Dr. Russell, is what's depicted on the screen one dog bite or more than one dog bite?
Ask it differently, Mr. Russell.
Dr. Russell,
how many dog bites?
Can you determine from this depiction, how do you evaluate this depiction with regard to dog bites?
Groupings?
Well, I see several groupings of wounds. Here's one grouping up near the shoulder. Here's another distinct grouping near the elbow, but above the elbow. Here is a third grouping around the back of the elbow and the upper forearm. Here's some additional marks. I think they're separate, but I don't know exactly if they are separate dog bites or scratches. And then there's another grouping around the posterior forearm near the wrist. So 1, 2, 3, 4. There's at least 4 different types of either bites or combination bite and claw marks.
You mentioned claw marks. Is there any evidence of claw marks in this exhibit?
It's hard to say exactly what what these marks are. This one here, and even to a certain extent,
camera guy.
This one here has some characteristics of both claw marks and bites. So
even though you may not be able to determine whether it's a claw mark, can you determine, or the specific type of mark, can you determine that those are from a dog?
I believe they are, yes.
So now let's go. You mentioned, we'll switch. We can leave that up for just a moment because we're going to come right back to it. And Dr. Russell, earlier on, you used the phrase incomplete dental impression. Do you recall that?
Something like that, yes.
Yeah. What phrase would you like to use? Because you were describing whether a dog or not had a complete bite. What phrase would you like to use?
That's okay. Incomplete bite. I
okay.
Might
do you
consider.
see any evidence of an incomplete bite on Exhibit 1?
I believe all of the bites here are incomplete.
Why do you come to that conclusion?
Because in my opinion, they don't penetrate the skin, which I would consider more of a bite or more of a complete bite. So they're just scratches on the surface of the skin.
When you say they don't penetrate the skin, we see the marks that are on there. What do you mean that they don't penetrate the skin?
They don't penetrate the full thickness of the skin and extend into the soft tissue underneath.
And what, in terms of incompleteness that you just described, have you observed incomplete dog bites in your career?
Many.
Roughly how many incomplete dog bites have you observed and treated in your career?
Over 100.
In our incomplete bites, the majority of bites from civilian dogs, or are they a minority of the bites from civilian dogs?
I believe they're the majority of the bites of civilian dogs.
Did you determine whether these wounds occurred at the same time?
I believe they did.
Why do you come to the conclusion that they occurred at the same time?
Because of the wound characteristics, the coloration of the wounds, the tissue reaction to the wounds. So they all timing are at the same time, around the same time.
Did you determine whether these wounds were sustained by Mr. O'Keefe before or after he died?
Before he died.
How do you reach the conclusion that these wounds were suffered by Mr. O'Keefe before he died?
Because they have what we call a vital reaction. So there is an ever so slight vital reaction or inflammation around the edges of the wounds. And so that determines that, that supports the fact that they were inflicted during life.
Dr. Russell, did you observe Mr. O'Keefe's right arm personally?
No.
Is it generally accepted in the practice of medicine, particularly emergency or pathology, to observe and determine the source of a wound from a photograph after death?
It is generally accepted.
And have you, in your career, used photographs to determine wounds and patterns of wounds?
Yes.
And is that an accepted practice?
Yes.
And it is a generally accepted practice?
Yes.
Now, in conducting we're going to switch a little bit now to what you call the differential diagnosis.
Differential diagnosis.
In conducting your differential diagnosis with regard to motor vehicle accidents, describe for the jury how you performed that differential diagnosis with regard to the decedent. And we can leave that up for just a moment. Go ahead, Dr. Russell.
Okay. So I'm going to need to see you. Sorry, folks.
What are we objecting about it being on the screen? The question, how did you perform your differential diagnosis? What's the problem with this question? I don't know. It's devastating to my case, Your Honor. How did you rule out? Are we assuming facts not in evidence? Is that the issue? Dr. Russell, were you able to rule out that these injuries were caused by a motor vehicle accident? We can make it that explicit if that's what you're going to insist on, Hank. But maybe be careful what you ask for. Maybe be careful about that. Interesting chat there. Don't know where that data's coming from, but 85.7 to 143, a 60 almost $1,000 raise in 1 year. It's quite a lot. Quite a lot. That's quite a promotion. Quite a promotion from 2023 to 2024. The $800,000 home, I don't want to speculate on that because, you know, I don't know. I lived through the 2008 crash. And so I remember a lot of people were able to buy homes that probably they shouldn't have been qualified for by virtue of income and so forth. So not necessarily prepared to say this is 100% her fault and not, you know, bank is willing to give out a loan for a really substantial amount that perhaps it shouldn't. But that's a very legitimate question. If that's, I mean, officer salaries typically are public information. So I don't know exactly the source of this, but it is verifiable. So it is quite a question, isn't it? The $60,000 raise almost. It's a lot. Not quite doubled her salary, not quite, but pretty close. When Karen backed out at One Meadows the morning of January 30th, this is actually the morning of January 29th. Okay, January 30th, the car is already in custody of the Canton Police Department. And that was just Shannon Burgess not knowing what days were what. But when she backed out at One Meadows in the morning of January 29th, it looks to me like what you would count as a 3-point turn. The one that we watched her do where she backed into John's car. Yeah, you're in a backing motion and then you turn. I think the only difference is just the starting point, the orientation of the car at the starting point. She made a 90-degree, you know, turn rather than a 181. But that's because she had already pulled into the garage the night before. So like that part of the 3-point turn, go in the driveway, go back out the driveway. She had just already performed that the night before. Didn't have to do that again to get back out of the driveway. So, I mean, if you're asking me, semantically, is that a 3-point turn? Yeah. I mean, it's close enough. Sure looks a lot like all those other turns. Steph sells stuff by the seashore. I'd just like to brag that I was once admitted into Dr. Russell's trauma department at Los Angeles General, where they saved my life back in 1998. Congratulations to you. Congratulations to you. Was she the treating? Or just the supervisor? Doesn't she seem like she would have a wonderful bedside manner as a doctor? Doctor doesn't always have a good bedside manner, but I just feel that she would be very comforting and easy to understand. Aaron White, does the TUI issue you explained earlier get the ARCA guys off the hook for getting updates from the DOJ during trial 1? ARCA is not themselves federal agents. So the extent to which they are kind of subject to TUI is much, much more of a gray area. Are they going to be considered agents of the FBI for purposes of TUI? I don't know. I haven't gone that far down that rabbit hole. What it seemed like is that sort of TUI aside, the reason why ARCA had restrictions on what they were allowed to say is because that's what their contract with the DOJ required. And if that's the case, I would anticipate that the DOJ is putting that in the contract with the third party, witness, because they're recognizing this witness is not a federal agent and so might not be subject to TUI. So we can't necessarily use this legal power, the supremacy clause, to protect what they have to say, but we can use our power of contract to make sure that they're not going to go out and volunteer information that they're not supposed to. So there's a relationship between those things, but the extent to which they overlap, it's a big gray area. These application here to these guys are a gray area to me.
May I proceed, Your Honor?
Yes.
With Your Honor's permission to republish Exhibit 1. Thank you for your patience, Dr. Russell. Is what the wounds you see on Exhibit 1 consistent or inconsistent with what you have seen from your experience with regard to motor vehicle accident victims?
Inconsistent.
Why? Is he going to be allowed to ask why? Probably not.
If I could have published Exhibit 206, which is in evidence, Your Honor.
Okay.
Do you recognize Exhibit 206?
Yes.
Did you review that as part of any report in this case?
Yes.
And can you describe how you reviewed this document as part of your evaluation of this case?
Well, I reviewed the injuries, which are so this is a decedent, a picture of a decedent, a different case, not the decedent in this case, totally separate case.
And so is this from Dr. Welcher's report that you reviewed?
Yes.
All right, so continue, please.
And so this is a person deceased, looks like in the street, and he's got multiple injuries. And this is allegedly from an auto versus pedestrian accident.
So if we could, are you able to discern any injuries to any limbs from this? If you could zoom in on the limbs, Mr. Roll.
The cameraman on this one, I think, is not going to show us the dead guy.
There is a very extensive degloving, partially degloving, avulsion injury to the forearm of this individual, the extensive skin loss, damage to the subcutaneous tissue, possibly damage to other tissues beneath that.
And
degloving.
Mr. Wolk, if you could zoom back out and go to the list that is highlighted in the original of this. And Dr. Russell, can you tell me whether you evaluated the list, and if so, how did you evaluate that list in connection with the photo?
Well, the photo is limited only really to the upper chest and the right arm. And so I can't comment on any of the CAT scan findings here on this list, but this is a list of numerous traumatic injuries to this person. And regarding the arm, it says right upper extremity wound with vascular injury, clinical.
What does that mean, if anything, to you?
Well, that suggests it's a soft tissue wound. However, what they're saying is clinical, so they're not commenting on if there were any X-ray findings, for instance. On an X-ray, but I mean, would be a post-mortem X-ray, and this is just a clinical diagnosis or a visual hands-on diagnosis.
Do you know whether that line that you just read relates to any part of the photograph? Any part of the photograph?
Well, I believe it relates to that injury that we pointed out in the previous photograph.
Can you switch back to that, please, Mr. Wolf? If you could just zoom in and just what does...
So this is the wound that they are talking about. It's a large gaping wound, soft tissue wound.
If we could go back to the list, please. Zoom in. Thank you.
But
please continue.
No. What I was going to say is that there are multiple other injuries in this person. Multiple serious, significant injuries, subdural hemorrhage, subarachnoid hemorrhage, intraventricular hemorrhage, liver laceration, pneumothorax. That's blood and air in the chest cavity outside of the lungs. So it's in an area where it shouldn't be. This person had numerous injuries.
Are you able to compare these injuries in that photo in this Exhibit 206? And did you compare them to your review of the autopsy report and other medical records of Mr. O'Keefe?
Answer the question? Oh. Okay.
You can take that down. From your review, did Mr. O'Keefe sustain any liver laceration?
No.
Did Mr. O'Keefe sustain any gaping, as you called it, lacerations to the right forearm?
No.
Did Mr. O'Keefe sustain any pneumothorax injuries that you were describing with regard to 206?
No pneumothorax.
Let's switch to another topic. Let's talk about clothing of the decedent. In forming your opinion, did you consider Mr. O'Keefe's clothing in relation to his wounds?
Yes.
If we could, Your Honor, have Exhibit 150 in evidence published.
Okay.
Got to have our afternoon stream glitch.
Do you recognize what's depicted in Exhibit 150?
Yes.
And what is it?
It's a picture of part of the hoodie, sweatshirt or shirt that Mr. O'Keefe was wearing at the time.
And wearing when?
At the time of his death.
And did you evaluate this photo as part of your review of the autopsy report?
Yes.
And we're going to come back to this. If we could please switch to, Your Honor, 147C in evidence.
Okay.
Thank you. And what is 147C?
So this is a close-up of the sleeve of that shirt that we just saw on the previous image. And there's a hole or defect here in the sleeve, which I'm circling with the pointer. And there's a label that labels it number 1. And so I see this hole that is rather round and appears to have some fabric coming out of the hole towards the exterior of the jacket or the shirt.
Did you attribute any significance to the shape of the wound? And if so, what significance?
The shape of the hole, yes. So it's rounded. I actually attributed a lot of significance to that.
Describe a lot of significance that you attributed to this hole.
Well, I believe that this hole was made by a canine tooth. And with the tooth going into the shirt, reaching the skin, and then coming out of the shirt, pulling out some fabric with it.
And we'll come back to this, if we could,
Like a
Mr. Wolf,
snag.
go to 147D as in David that's in evidence. Do you recognize this photo?
Yes.
What is it?
A round hole in the shirt, again with some fabric fibers pointing towards the outside of the shirt.
Is this the same hole that we just saw on 147C or a different hole?
Can we go back? I don't know.
Okay, so let's now go back to Exhibit 150. What significance, if any, do you give to the various triangles that are on the hoodie? Can you describe to the jury what those are and what's their purpose?
So the triangles are labels that were placed by either the police or the crime lab or someone, and the point of the triangle generally is pointing towards a hole in the shirt. As you can see, there are multiple ones here, and I want to make sure that you don't confuse it with this rather large defect, which is caused by something else.
So let's start with each one, and we'll go through these quickly. Let's start and zoom in on number 1. What did you conclude about the source of that hole in the hoodie?
Sustained.
Did you evaluate what is depicted as number 1 in that slide as part of your review?
Yes.
And what was your evaluation?
Sustained.
Let's go back and zoom out. Have you in your career examined clothing either as part of your forensic pathology practice or your emergency medicine practice to determine the source of defects in clothing?
Yes.
How many times have you done that approximately in your career?
She's not a clothing expert.
Several hundred.
And have you, in those several hundred times, have you ever had to reach a conclusion as to whether there was any connection between defects in clothing and wounds to humans?
Many times.
Can you give some examples of the many times you've had to look at clothing and defects in clothing to assist you in determining wound recognition in a human?
Yes. So let me clarify. It's mostly used in forensic pathology, not so much in emergency medicine. The clothing and the cause of the wound is as important as in emergency medicine as the treatment of the wound. But in forensic pathology, it's a key component to any examination where you think that it was an unnatural death. So, so I've done it in gunshot wounds, in stab wounds, multiple times, looking at the defects, looking at the direction of the, of what I think the bullet, the bullet track was, determining entry and exit wounds. In stab wounds, I've utilized them to help determine offensive and defensive wounds or injuries. So yes, many times.
Have you ever performed that analysis? You mentioned, testified earlier, 500 to 1,000 evaluations of dog-inflicted wounds on humans. Have you ever performed the analysis of defects in clothing and compared them to wounds on humans in the context of dog-inflicted wounds on humans?
I don't think so. Perhaps in that one
Well, yes. So in terms of, have there been any instances of doing that in your career? Have you done that at all in your career?
Maybe that one child case.
All right. So let's go now to
Her mic went out. Oof. Did we all hear
you
that?
were discussing the defects in the arm, as well as the wounds in the arm, and then the defects in the clothing. In terms of the, back to Exhibit 1. In terms of that pattern that is in the arm, and in terms, let's go back to the hoodie. I'll strike that. Have you, in your career, in the terms of evaluating motor vehicle accidents, have you evaluated the clothing of victims of motor vehicle accidents?
Yes.
How many times roughly have you evaluated what clothing looks like in terms of motor vehicle accidents?
Well, in many cases, I had to cut off the clothing in the emergency department, so I observed the clothing then, and then in the post-mortem cases, I evaluated the clothing, but oftentimes sometimes it wasn't helpful.
Have you ever evaluated clothing in determining whether or not the defects in the clothing are consistent or inconsistent with a motor vehicle accident? Have you ever evaluated that as a forensic pathologist?
Not specifically.
Right. And in terms of your observations in either emergency medicine or forensic pathology, have you ever observed defects from motor vehicle accidents in clothing?
Yes.
Is what is depicted in this exhibit consistent or inconsistent with a motor vehicle accident?
Sustained.
Nothing wrong with that question.
In determining, let's go back to Exhibit 1, please. In determining and reaching your opinion with regard to the source of these wounds, is it necessary for you to reach that opinion to see a specific dog to determine whether the wounds are from a dog in general?
No.
And in your experience that you talked about earlier today, the 500 to 1,000, was it ever necessary in that experience to go locate the dog, to see the dog, to treat or evaluate the patient?
No.
Why is it, well, in terms of, we're going to move to another category. Studies. Did you review any studies informing your opinions in this case?
Can we put the lights on and take this?
Yeah, yes, thank you, Your Honor. Yes.
Yes, many.
And did those studies that you review support or not support your conclusions in this case?
Sustained.
Which studies did you rely upon?
Well, I reviewed quite a few, 10 to 20 in depth, and I relied a lot on 2 of the articles.
Do you recall the names of the lead authors in the studies that you said, that you just referenced?
Yes, one of them was Demuniak.
Could you spell that, please?
I wish. DEMUNNYCK, I believe.
And was there?
And then there was another one, Pollack, Pollack.
Hey, she tried to spell it herself. Kudos to her.
May I approach, Your Honor?
Yes.
Thank you. Your Honor, my recollection is correct. We've already pre-marked as exhibits for identification these studies, 2 studies. I may be incorrect in that. If so, I have studies. I'm going to show them to Mr. Yes, thank you. So we can just make sure I have all the pages. Do you have these handed out? For the order?
Oh, I have none.
Okay.
If I can just have them go, Your Honor.
Okay, I've got them. These are them. If I could have marked for identification as one document, please.
Exhibit PPP for ID.
One more, Madam Court Reporter, thank you.
And exhibit QQQ for ID. Mr. Alessi and court reporters down.
Sure. Yes, Your Honor.
Which is what?
Exhibit PPP is the Munich, and exhibit QQQ is Pollack, and those are the lead author names. You're welcome. Yeah, I leave them with the witness, Your Honor.
You're welcome. I don't really like it when he does it either.
Dr. Russell, I have provided you with those 2 exhibits. I would ask you to just briefly take a look at them and let me know whether you recognize those as the articles that you were referencing before.
Yes.
Now let's start out with the Munich study. Is that exhibit PPP? Right. So is this the study that you referenced earlier in your testimony?
Yes.
Can you briefly describe for the jury how that study related to the opinions in this case? Okay.
Sustained.
Are these the studies that you cite to as a basis for support for your opinions in this case?
Yes.
And is QQQ a study that also supports your opinion in this case?
Yes.
Now, in terms of your conclusions with regard to, if we can go back once more to exhibit number 1. With regard to your opinion on the cause of these injuries, can you once again state your opinion as to the cause of these injuries?
I believe these injuries were caused by a dog attack.
So I'm going to strike that word.
Yeah, so Dr. Russell, if you could, with regard to bite parlance, can you state what your opinion is with regard to bite. So do you have an opinion as to what caused these injuries?
Yes, I believe that these injuries are the result of dog bites and or claw marks.
And do you hold that opinion to a reasonable degree of medical certainty?
Yes.
She sighed and closed her eyes because, boy, and then blew her breath out because what a dumbass question is that?
I have for this witness at this time.
All right. Thank you.
You want this? Okay.
Well, what are we going to get from Cross here? Couple of binders Hank has, checks the clock. Flop around your stuff on the podium.
Good afternoon, Dr. Russell.
Good afternoon, Mr. Brennan.
Dr. Russell, we've met before.
Yes.
I've asked you questions before.
Yes.
And you've testified before where I've had a chance to ask you about some of your statements and opinions, haven't I?
Yes.
Before this case, had you ever testified as an expert in dog bites in any federal court in the United States?
No.
Before this case, had you ever testified in any state court in anywhere in the country as an expert in dog bites?
No.
Other than this case, have you ever testified in a courtroom as an expert about dog bites?
No.
Last year, you learned that there was litigation regarding this case, Commonwealth versus Karen Reed, correct?
Yes.
You learned a little bit of information about it, and it piqued your interest, didn't it?
Yes.
Did you know that the case was receiving a lot of attention?
No.
Did you know that it was on television?
I had no idea until I got here.
You spoke to a colleague in Los Angeles, correct?
I'm sorry, I spoke to who?
A colleague?
I spoke to a district attorney in Los Angeles.
And did you just bring up the subject, or did that person bring it up to you?
I brought it up.
When you brought that up, is it because you knew of the relationship between that district attorney and somebody on the defense team?
Yes.
You wanted to get involved in this high-profile case, didn't you?
No.
Well, you weren't called by anybody on the defense and retained as an expert in the traditional sense, were you?
That's correct.
It was after you reached out yourself and interjected yourself into this case, true?
I did so for a reason. And the reason being that I knew I was one of the only people in the United States board certified and residency trained in emergency medicine and also residency trained in forensic pathology. And therefore I had a unique skill or knowledge set. And I was one of the very few people that had the knowledge of dog bites, as well as those other trainings.
And because of the fact that you held this opinion about yourself, you wanted to get involved in this very high-profile case, didn't you?
I thought I could help clarify the issues as to whether or not this could be a dog bite, and maybe they could move on to something else if it wasn't.
Did you want to get involved?
No, not really.
Inevitably, you got hired by the defense, didn't you?
Yes, I reluctantly agreed.
And they paid for your time?
They are paying for the time.
Yes. Did you know that there was a relationship between the district attorney you spoke to in California and somebody on this defense table?
I know, yes.
So when you spoke to the district attorney, did you have the hope that they would reach out on your behalf to get you involved in this case?
As I said, I hoped that they could reach out to the team and I could help clarify issues so that they could move on. If it wasn't, if these weren't dog bites, then no sense spending a whole bunch of time on it.
After you testified in this case last year, you then began to advertise yourself as a dog bite expert, didn't you?
I had advertised myself many years ago as a dog bite expert. I think I'm not sure, but yes, I did advertise myself as a emergency medicine and forensic pathology expert.
Did you take
with other sub interests?
Sure. Did you take a photograph of you testifying at trial and put it on a website to promote your accomplishments?
It's a listing service for physicians. And yes, there is a photograph.
So you took a photograph from your participation in this event?
Yes, that's there.
And you used that photograph in your participation in this event to try to procure future work, didn't you?
I wouldn't say that was the reason, no.
When you listed a number of things that you have experience in after this case, you then added that you were an expert in dog bites, didn't you?
I believe I am an expert in dog bites, yes.
But after this case, and after you took the photograph from this case, and after you created this advertising, you then added the fact that you were an expert in dog bites, didn't you?
It was all at the same time, and it was submitted at the same time.
Right. After this case, after you participated, volunteered to involve yourself in this case, you then used it as a marketing opportunity, didn't you?
Well, I also I had retired from my full-time job, and I had time, and I wanted to get more involved in some forensic legal cases, and not specifically dog bite cases. I have much more experience with other cases.
Undoubtedly, I respect that, but simply after you testified in this case, you did use
post hoc, ergo
participation
propter hoc
as a way to try to garner future interest in cases and income, didn't you?
I did, but I did not mention this case.
Have you testified in any other court since this case as a dog bite expert?
No.
You had written a few articles that were peer reviewed on dog bites back in, is it the 1990s?
Yes.
And they involved law enforcement canines?
Yes.
And you describe in those articles how a law enforcement canine grabs and holds. Is that the technique they call it?
Yes.
Where they lock their jaw and then they pull and hold on to the subject that they're attacking or holding?
Yes, that's what they were trained to do back then.
And you would agree that there's a difference between generally the way a domestic dog bites and a law enforcement dog bites?
Generally, yes.
Since those two articles in 1990, have you authored anything else regarding dog bites?
No.
You had mentioned that you had gone to seminars regarding identification. Now, I had a chance to ask you a number of months ago about some details about training and education you have on pattern recognition analysis as it specifically relates to dog bites. Remember, I asked you those questions a number of months ago?
I believe you did.
And I'd asked you if you could give us any specific listed trainings that you had regarding pattern recognition analysis of dog bites. And at that time, you did not have any names of any classes or seminars or certificates that you have. You mentioned again today that you have attended seminars regarding dog identification analysis. Do you now know some of those trainings and seminars? And are any of those listed on your CV?
The trainings that I went to on bite marks in general, they were bite marks in general, and included things like how to determine what was a human bite, how to differentiate a human bite from a dog bite. But no, I did not specifically attend seminars limited to dog bites only. However, actually, there was one this past February that I did attend at the American Academy of Forensic Science.
Over your many, many decades, you did not attend any seminars on pattern recognition analysis of dog bites, did you?
Of specifically dog bites? No.
I only want to talk about dog bites. I know you're well trained and educated. I respect that, but I want to talk about dog bites. You didn't attain any certificates in pattern recognition analysis of dog bites, did you?
I don't think there are any that exist, any training programs like that.
In fact, forensically, have you ever been presented with a wound and been asked to determine whether or not the source of it was a dog bite, other than right here in this very case? Have you ever been asked to do that in your entire history?
In my clinical career, perhaps once or twice, but not, not that I can give you a specific name.
Well, the couple times, tell us what stands out. When were you asked ever over your entire career to do a forensic evaluation of a wound and identify whether it was a dog bite? When did that happen?
A forensic evaluation? No, never.
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 Okay.
It just doesn't come up.
Okay. And so this is the first shot, the first crack you've had at looking at a photograph and trying to make a determination based just on a photograph whether or not the wound is generated from a particular mechanism, and in this case, your opinion, a dog bite.
No, actually, I disagree. I've been taking photographs of dog bites since the 1990s.
And when you took the photographs, you knew they were dog bites.
I did know that there were dog bites, yes. I have a collection.
I'm sorry. I didn't mean to interrupt you. I'm sorry.
A collection.
That was it.
Okay. So not when you knew it was a dog bite and you took a photo. I know you have an interest. I'm asking, other than this case, there was never, ever a time in your career where you were presented with a photo and asked to give an opinion whether the mechanism of injury was a dog bite, other than this case?
That's correct.
So this is not a pattern recognition analysis engagement that you have any experience in before this effort?
No. I've recognized that pattern many times.
I appreciate your opinion, but I want to ask my question. You do not have experience over your long, accomplished career.
Yes, she does.
In the
Clinical
effort of pattern recognition analysis of dog bite wounds. Isn't that fair to say?
No.
Okay.
I wouldn't concede that at all.
You mentioned before, and you just mentioned again, so I want to ask you some more questions. You believe that you are uniquely qualified to look at a photograph and give an opinion about the source of the injury.
I'm not uniquely qualified. That's done all the time in forensic pathology. Many forensic pathologists do that.
Did you just say you're one of the very few physicians in the United States who has both the forensic and the clinical experience to look at a photograph and make a determination, the mechanism of injury?
No, I said, if I said that, then I was incorrect. I meant dog bites. But your question just now was not specific to dog bites. Postmortem photographs are used all the time in forensic pathology for second opinions.
You're right. My apologies. Did you say today and before, have you said that you believe you're one of the only few physicians in the United States who could authoritatively distinguish between causes of wounds when it relates to dog bites?
I did say that, and that's because of my unique training. I don't know of another doctor in the whole United States that did 2 residencies, one in emergency medicine and one in forensic pathology, and has a lifelong interest in dog bites.
So, Dr. Russell, from your perspective, as far as you know, you were the only person in the entire United States of America who was qualified to look at a photograph and make a determination whether the wound was derived from a dog bite.
No, I am one of I'm the only physician that I know of that can do that. There may be, a few others out there. There may be, but I don't know of any other physicians that can do that.
Do you recognize anybody other than yourself who has this very particular expertise
No, that's why
to
she
be able
volunteered.
to do this kind of work?
I'm not aware of anyone.
You were a medical examiner, a forensic pathologist,
Yes,
and you know there's about, or would you agree there's probably about 900 to 1,000 medical examiners around the country at the same time over a period of time?
I believe that there might be, there's probably, I think there's around 500 or 600 practicing forensic pathologists.
And do you think because they are forensic pathologists, those 500 or 600 people have the unique qualifications as you do to be able to give an opinion about the genesis of a wound?
Wounds in general, perhaps. Dog bite wounds, I doubt that very many of them have a specific interest in dog bite wounds.
And so you think that of all those forensic pathologists, medical examiners, you think that qualification and experience itself is not enough to qualify somebody to give an opinion on a photograph about the genesis of a wound related to dog bites?
Well, if a forensic pathologist has autopsied 1 or 2 cases of dog bite wounds versus my experience with over 500 to 1,000 cases of dog bite wounds, I'm not so sure that person would be a very good expert in that kind of a case.
Have you ever heard of a doctor named Dr. La Posada?
I've heard of Dr. La Posada.
Have you ever read any reports by Dr. La Posada?
No.
Has anybody ever shared with you any information or opinions of Dr. La Posada?
I believe she has a very good reputation.
Have you ever, well, how do you believe that? Who told you
Because I've heard of her name at national organizations. I believe she's given presentations nationally. I've seen her name, for over a dozen years or so.
Do you know whether or not she has any participation in this case?
I believe she does.
Well, so you know when you're providing accolades that she has maybe some involvement in this case? Do you know that?
I would provide those same accolades if she didn't have involvement in this case.
Do you know that she has involvement in this case?
I believe she does. The attorneys have not shared everything with me in terms of who the witnesses are.
Somebody must have shared her name. Who shared her name with you?
I'm very familiar with her name outside this case.
Who shared her name that she may be a participant in this case?
I don't remember. I don't remember.
Well, somebody met.
I think I got a file or something, but yeah.
So when you were reviewing this case, did you get materials from any of the attorneys authored by Dr. La Posada?
I don't think I read a report. I was very interested in reading a report by Dr. La Posada. I was very interested, but I didn't see one.
So when you received materials in this case, you didn't read all the materials the defense gave you?
I don't believe they gave me the report.
What report?
Any report that Dr. La Posada might have written.
Do you know whether or not you've received the report or not?
I received something that had her name on it. I don't remember what it was, but I was looking for a medical examiner's or a report, an actual report, and I did not see one.
Dr. Russell, you are meticulous when you look and examine things.
Right.
So you would know what you've received and what you've read and what you haven't. So the fact that you're telling us that you saw something with her name on it, can you give us a little more information and share with us what it is you actually received about this Dr. La Posada? What did you get from the defense?
I saw something. I think it was the name of a file folder, but I looked for a report and there was no report in it.
Did you ever ask for one?
I didn't ask because I didn't ask. I really wanted to read it, but I didn't. It wasn't given to me, so I didn't ask.
Were you ever told what other people's opinions might be regarding those photographs?
I'm aware that there was a Dr. Sheridan involved in a previous proceeding, and he believed that those were consistent with dog bites.
Did you ever receive any reports from the defense about what other person's opinions would be in this trial about dog bites?
Oh, yes, I received a report authored by a non-physician, yes.
So when you say non-physician, you're trying to make the point because you think that person might be your opponent in this case?
I don't have any opponents.
Okay, so why did you qualify him as a non-physician?
Because I believe that in order to really understand wounds on a human being, one needs to have treated wounds, seen lots of wounds, and I think that the person that is best qualified for that is a physician.
So a medical examiner wouldn't cut it, in your opinion?
Medical examiner is a physician.
So you think a medical examiner has enough experience to come in and give an opinion on dog bites?
Some, but in their case, I would hope that they have had actual clinical experience with autopsying some cases where there were dog bite wounds, because I don't think they worked in the emergency room or any other clinical setting where they treated people. So I'd want to see if they had experience with dog bites.
I'm doctor as a disqualification. How about a dog trainer? Would a dog trainer who's not a doctor have the experience in your mind to come in and give an opinion about photographs and the genesis of the wounds?
Objection, Your Honor.
I'm going to allow it.
Can allow it.
How about a non-doctor, as you said, you made a distinction.
Uh-huh.
They're simply a dog trainer, maybe even an uncertified dog trainer. Would that person have the qualifications in your mind to be able to look at photographs and determine whether or not the cause of the injury is a dog bite?
There may be a certain small subset of people who have, very much experience with dog bites that could qualify, as suggesting that these are consistent with dog bites. But I don't think that they could definitively. I think that someone could, who dealt with many dog bites in the past on humans, could possibly say that they were consistent with.
Even if they didn't have the clinical experience?
Well, I prefer that to hear that information from a physician, but I wouldn't rule out that only doctors, only a physician, MD, could say that something was a dog bite.
It seems like the standard is now kind of changing a little bit. Because when I asked you,
Objection, Your Honor.
you mentioned the other person, you disqualified the person because they weren't a doctor. It seems now in some instances, you're willing to accept a non-doctor into your very select group of experts.
I can explain. If someone had looked at perhaps hundreds and hundreds of wounds inflicted by a dog that they know was inflicted by a dog, and they saw the resulting photographs on a person, I think that particular person may be able to make some comment as to whether or not some wounds are consistent. However, if in terms of a medical examiner, if they've autopsied one case or two cases of dog bites and they're trying to testify based on some pictures, I would be a little concerned about that.
Does qualification for this type of business, in your mind, depend on who hires you?
Absolutely not.
Suffice to say, you've never taken a class in the forensic analysis of dog bites.
I don't think any class exists.
But I'm asking about your experience.
Well, that's correct.
You haven't, have you?
That's correct. I can't think of a course that doesn't exist.
You've never engaged in any type of opinion looking at photographs and then had that opinion peer reviewed by other dog bite experts, have you?
No.
Do you have any experience in veterinarian medicine?
I'm aware of it. That's my experience.
Do you have any accomplishments like degrees?
No.
Now, you've testified a number of times in this case, haven't you?
Yes.
And when you testify, you know there's a court reporter and there are transcripts, correct?
Yes.
You originally testified when you first came out and volunteered to testify last year, and there was a hearing before trial, wasn't there?
Excuse me? Say again, please.
When you volunteered to come out last year, there was a hearing before you testified at trial, wasn't there?
Yes.
Do you remember that was on June 18, 2022?
Sounds right.
And then you testified at trial on June 21st, 2022.
Yes.
I didn't have the privilege of meeting you on either of those events, did I?
No.
But since then, we have met.
Yes.
And we had a chance to speak at a subsequent hearing on December 12, 2024.
Yes.
And then after that, we again had an opportunity to discuss this on January 7, 2025.
Yes.
At trial last year.
When you reviewed the case, when you first reviewed it before you testified last year, you had very limited information, didn't you?
Yes.
You had just an autopsy report, photographs from the coroner, photographs from the hospital, an emergency room report. Yes?
Yes, I had more than that.
The medical examiner file had a toxicology report.
Yes, and there was more.
Okay.
I believe there was a dog bite, town of Canton report.
Okay. So when you had an opportunity to look at the medical examiner's report, you yourself had been a medical examiner, correct?
Yes.
And there's a unique advantage of actually conducting an autopsy as opposed to just looking at photographs, isn't there?
Yes, there is.
And if you are actually conducting the autopsy, you firsthand can make observations about injuries, make measurements, and see things that don't always appear in photographs.
That's correct.
And when you would do medical exams, you had a distinct advantage over people who would later see your work, a written report, or photographs, because you were there actually conducting the investigation.
Yes.
And it's for that reason that when you testified before, you have acknowledged that you relied on Dr. Scordi-Bello's report for information.
Yes.
Because you didn't have the benefit of doing measurements or looking at depths or anything else firsthand.
Yes, correct.
And when you looked at that photograph that you discussed with the jury, you also had a chance to see Dr. Scordi-Bello's report regarding the abrasions on Mr. O'Keefe's arm.
Yes.
She described those abrasions as superficial, didn't she?
Yes.
She actually gave measurements, 3 centimeter superficial abrasion on the right medial upper arm. Right?
Yes.
You not only read that, you deferred to her ability to have a firsthand observation, and you accepted that as true, didn't you?
Yes, but there's no interpretation of that abrasion.
Multiple abrasions from 2 to 3 millimeters and up to 7 centimeters on the posterior right arm and forearm.
Yes.
Did you read that from Dr. Scordi-Bello?
Yes.
Did you accept her finding and observation?
Yes.
And you would agree she was in a far superior position than you when she made these observations and notes, correct?
They are not inconsistent with what I said.
But that's not what I asked, though.
Okay.
Sorry, I didn't mean to be sharp.
Okay.
I apologize.
Yes, you did.
Did you rely on her ability and firsthand observation of those wounds?
Yes.
And did you appreciate or accept the fact she had a superior opportunity to evaluate those wounds firsthand that you did not have the benefit of?
She made no interpretation of those wounds.
Well, did you know that Dr. Scordi-Bello had described them as superficial?
They are.
Did you know that she said there was no depth and no puncture?
Not inconsistent with what I said.
I understand, doctor, but I'm asking you, do you know that her position is that there was no puncture and no depth to those wounds?
Objection, Your Honor. Do we have the witness see the report that he keeps referring to?
Can you answer that question without seeing it, or do you need to see it?
Well, I remember it, but there's no inconsistency here. I agree with that.
Would you accept that Dr. Scordi-Bello's opinion is that there was no depth and no puncture to those wounds?
May I see the report?
It might not be in the report. I'm asking about any testimony, anything that she's ever said. Would you agree or accept her position that there is no puncture or depth to those wounds?
Objection, Your Honor. Like all the questions that were about an autopsy. Yes. Sidebar.
Okay.
Oopsie, Hank, you're not prepared to show her any reports. You want to confront her with general unspecified, maybe it happened testimony of Dr. Scordi-Bello. Well, that's what goes to what we call the good faith basis for asking the question. What exactly are you relying on to imply that this is what Dr. Scordi-Bello said and or concluded? We just had a lot of chats about superficial wounds with no depth or puncture. Where are you getting that from, Hank? That's all that they're asking is show the witness where you're getting that from. And now you seem to be saying you're pulling it out of the air. Might not be in a transcript, might not be in a report, might just be in her testimony somewhere. Well, where are you getting it from? That's what they're asking you to show the witness. So, did you just get caught with your pants down? Oops. Don't have anything ready to go through that with your two binders up there. And none of them actually have the documentation that's relevant to the examination that you're conducting right now. What are those binders? Are they props by any chance, Mr. Brennan? Are these just prop binders that you bring up there so that you can flip through and make it look like you're real prepared and real organized for your cross? But when push comes to shove and you actually need a document, lo and behold, it's not even in there. It's not even in your prop binders. How very interesting. I would say I learned a lot just now. So he's going to make stuff up. I thought it was amusing seeing Dr. Russell smile a little bit when he got caught out on that, not having it. She's being very polite with him. She is pushing back where appropriate. She is explaining where appropriate. But if he asks a question that's well-founded, she simply gives a direct answer to it. So she doesn't come across as particularly difficult or obstinate or contrary or anything like that. But she sure did look happy to see him step into a hole, didn't she? Gotta say, I don't think it would break Dr. Russell's heart to see Hank Brennan take a flying fuck right out of this courtroom, maybe out of one of the upper windows. Don't think it would bother her to see that. The abrasions are superficial. I don't know what Hank is on with that. The abrasions are superficial. That's exactly the same thing that she said in her direct, because they don't puncture the whole layer of the skin. They don't protrude down into the soft tissue and everything that's below it. So yeah, it's superficial. It didn't get through all of the skin. But he Hank is the king of equivocation. He likes words that have multiple meanings. Maybe it's got a technical meaning and a lay meaning, and he can confuse those things. So you think by saying superficial, what he means is, well, it's not serious. It's not a serious wound. It's nothing like that. But no, all she means is the technical. It's on the surface of the skin. It doesn't get through the whole skin. She didn't fall into the trap of trying to pre-disqualify, I guess, Garrett Wing, the dog trainer. Yeah, if he's seen hundreds and hundreds of bites, he might be able to say it's consistent with a bite. Of course. I mean, going to school is not the only way that people gain knowledge. Definitely not the only way that people gain knowledge. If somebody is, for example, a collector of, I don't know, Mickey Mantle rookie baseball cards, do you think that somebody is especially qualified to look at a proffered Mickey Mantle rookie baseball card and give an opinion about whether that's what it is or not? Be able to spot a fake, maybe? Somebody who is collected and seen, I don't even know if there are hundreds of Mickey Mantle rookie baseball cards out there, honestly. I have no idea what the pool is there. Seen hundreds of them. Can they say, hey, this thing that you're showing me, yes, it is or is not a Mickey Mantle rookie card? Do you have to have a specific class on identifying Mickey Mantle rookie cards? in order to have that expertise? Of course not. Of course not. All of this is pretty ridiculous. Quite a long sidebar here. Seems like Alessi was already strike all of that. Strike all of it. If he doesn't have a basis, strike it all. Thank you, CH.
May I?
Yes, please.
Dr. Russell, I read to you the measurements that were in Dr. Scorti-Bello's report. Are you aware that she testified that these superficial abrasions did not have any depth or any puncture?
I don't recall that.
Well, would you agree if Dr. Scorti-Bello testified in this court that those superficial abrasions did not have any puncture or depth? Would you agree with that assessment?
Objection, Your Honor.
In that form, it's sustained.
Would you agree that the superficial abrasions on Mr. O'Keefe's arm had no punctures?
I agree.
Would you agree that the abrasions, the superficial abrasions on Mr. O'Keefe's arm had no depth?
No measurable depth, yes.
Between the last time you testified and then you testified here today, have you spoken to the attorneys at all regarding the issue of punctures?
No.
Because you are agreeing today that those superficial abrasions did not have any punctures, right?
They don't appear to have any punctures.
But you, in the past, have testified very, very differently than that, haven't you?
No.
Now, we've spoken many times. I'm going to go through many of those examples later, but we'll do that a little bit later, Dr. Russell.
Okay. And why not now? You just brought it up. You got to thumb through your prop binder or some? You're not prepared for that?
Over the course of your many testimonies under oath, would it be fair to say that you have changed your opinions about the superficial abrasions to John O'Keefe's arm many times?
I don't believe that's fair to say.
In the past, when you were describing Mr. O'Keefe's superficial abrasions on his arm, did you give varying and different opinions about the cause of each individual wound, area of wound?
I don't believe so.
When you first gave opinions, that was before the last proceeding. You came in and you were questioned before you testified in that initial proceeding, right? I'm trying to be as specific as I can. You testified last year?
Yes.
And please.
There was a hearing and then there was a proceeding.
Okay. That prior hearing, can we call the first event the prior hearing and the next one the prior proceeding?
I'm confused.
I don't want to confuse you. I'm just trying to follow the rules. You testified twice last year, didn't you?
3 times.
3 times. Okay. The first time you testified was just before the judge?
Yes.
Okay. When you first testified before the judge, do you remember that you had uncertainty about how each and every one of those wounds was caused?
I don't remember that.
Do you remember when you then testified a couple days later at the proceeding that some of your opinions changed from the first time you testified?
I don't believe that.
And then when you later met me and we've had a chance to talk over the last 2 events, December and January, would it be fair to say that your opinions regarding the individual areas of wound changed?
I don't believe so.
Okay. At some point before or during our conversations in December and January, you wrote a report, didn't you?
Yes.
When you wrote that report, you hadn't written a report before the first time you came in and testified, had you?
That's correct.
And it was between those hearings in December and in January where you wrote your first report.
Sounds correct.
You dated that report December 9th, 2024. Does that ring a bell?
Yes.
When you wrote that report, you did not write that report alone, did you?
I did.
You had some help, didn't you?
Not in the content of the report.
Well, you sent the report back a number of times for review and revisions, didn't you?
In terms of organization.
And some of the language in this report is really not your language. It's the language of somebody who helped you write some of this, isn't it?
You know, if somebody helped me write it, it would have been much better written than that.
Didn't you agree that you had some assistance with the report? Haven't you testified to that before?
And no, and in terms of organization, there was some comments, though, this sentence belongs, you know, with this paragraph or the, you know, whatever. But in terms of content, that was my work.
Well, it was your report, correct?
It's my report.
And when you write a report, it's your words, not somebody else's. Isn't that true?
That's correct.
But nevertheless, you had somebody assisting you. True?
In terms of organization, yes.
Who was helping you with the report?
It was somebody from the law office.
Well, it was this gentleman right here, Attorney Alessi, who just asked you questions. He helped
No,
you, didn't he?
actually, it wasn't.
Oh, was it from his law firm that somebody helped you?
I believe so, but it was in terms of organization.
In your report,
Sorry,
you
guys.
provide your background.
Glitch again.
Yes?
Yes.
And you've been licensed to practice medicine since 1988
Yes.
as a physician?
Yes.
And you've been licensed to practice medicine as a surgeon?
It's called, in California, it's called physician and surgeon license.
Mm-hmm. Do you have a physician and surgeon's license?
I do.
Okay. Have you ever practiced as a surgeon?
Well, in the emergency department, we do surgery. We have to do some surgery sometimes. We have to open up people's chests and, you know, and compress the heart sometimes when they have gunshot wounds to the chest. I've had to put chest tubes in. I've had to debride dog bite wounds and other wounds. So yes, there is a component of surgery.
If you do stitches, that's considered surgery, isn't it?
Maybe.
Well, medically speaking, stitches is surgery.
I don't know, maybe.
Okay. Do you have a surgeon's license?
I have a physician and surgeon's license in California.
Now, when you first looked at this case and testified, do you remember when you were looking at Mr. O'Keefe's superficial wounds, you said that you thought they appeared to be consistent with an animal attack?
I do remember that.
And when you were describing animal attack, you were a lot less specific than you were today, weren't you?
Yes.
You were less sure about your opinion when you first testified about this case than you provided to this jury today.
I was certain that it was a dog attack. However, as I mentioned before to you, in medicine, we're taught never, nothing is 100%, and therefore never say, anything's 100%. So that's why I gave that that generalization. However, I have reviewed the case. I personally was certain that was a dog, that those were dog marks. Now, I have reviewed this case over and over and over again. Plus, I've read additional articles more than once, and which substantiate again my findings. So, so my degree of certainty perhaps increased.
So when you first testified in this case back in June of 2022, are you agreeing that your testimony was less certain than today?
I believed that it was a dog attack at that time.
When you testified, you didn't say dog attack, you said animal attack at the beginning, didn't you?
Yes.
And when you were asked about the cause, you said that it could be bite or scratch wounds.
Correct.
So back in June, when you were looking at individual wounds, you, at that time anyways, were unable to differentiate between
facts
bite
and evidence
and scratch wounds.
They are very similar.
I understand, but today you seem pretty unequivocal. So I want to go back to the beginning and see the evolution. I'm asking a question.
All right. So the argumentative part is out. Ask the question, Mr. Bulger.
I want to go back to identify the evolution of your opinions. So let's start at the beginning.
Your Honor.
So question, please.
At the beginning, before your opinion evolved,
Objection.
you started with an opinion that this could have been either bite or scratch wounds, right?
Yes.
And if there was actually a methodology where you could identify superficial abrasions and make a determination whether it was from an animal or a dog, there would be something definitive, specific, where you could identify a scratch from a bite wound, wouldn't there be?
Not unless there was a piece of tooth in the wound or a piece of nail. There would otherwise not be any specificity.
You talked about patterns when you first testified back in June of last year.
Mm-hmm.
And when you talked about the patterns, again, you had some uncertainty whether those patterns were caused by nails, claws, or could have been caused by teeth. Isn't that fair to say originally that was your position?
There is some overlap in terms of the appearances. They can appear very similar, and they can be arranged very similar in terms of parallel lines.
In fact, when you first testified, you weren't consistently even saying that it was a dog, or as you say today, dog attack. You were saying, in your opinion, they were the result of animal bites or scratches. That was what you originally opined, isn't it?
We just went through that, yes.
And at some point, you said that it might most likely be a large dog. Do you remember that?
Objection, Your Honor. Can we approach with regard to this line of questioning?
So why don't we break for today?
Yes, why don't we break for
So
today?
judges, we're not going to finish this today in the next 5 minutes, so it seems like it's a good place to break. I do have to give you those same cautions. Please do not discuss this case with anyone. Don't do any independent research or investigation into the case. If you happen to see, hear, or read anything about the case, please disregard it and let us know. Please be very careful with your social media use. Tomorrow is also a full day. We'll see you tomorrow. Thank you very much. Dr. Russell, you can again just follow.
Thank you.
Please. Close it open. Follow me.
Okay, thank you.
So good,
Can I
3
see
minutes
counsel while the
early.
jury's filing out, please?
Have the sidebar while the jurors are filing out. What's Mr. Alessi wanting to sidebar about with this line of questioning? We haven't established that any of these are inconsistent. You know, prior testimony is hearsay. And so the exception to the hearsay rule to bring in a prior inconsistent statement is it's inconsistent. And in some cases, some jurisdictions, you have to present it to the witness and give them an opportunity to explain or deny it. We looked at the rule for Massachusetts quite some time ago, and it's not that stringent for a non-party witness, for an adverse witness from the other side. But you still have to show it's inconsistent. And I think part of the problem here is this is, you know, is it inconsistent to say, it's my opinion that these are dog bites, and in my opinion, it was most likely a large dog? I mean, where's the inconsistency in any of this? Same thing with bite or scratch wounds. Hasn't she said in this trial, some of these she believes are bites, some of them could be scratches? Where's the inconsistency? So I think that might be the issue that Mr. Alessi has with what he's trying to do here. He's trying to generate a confrontation And just by presenting the prior testimony and coloring it the way that he wants to, he's trying to turn it into something that is inconsistent. But substantively, it's actually not. So there's nothing to argue with here about her previous testimony. If there is a discrepancy, he needs to narrow down a lot more on how that's different from what she's saying today. Really wanted to get in that evolved. Her opinion has evolved. It's evolved over time. Multiple comments with it. The last time he just loaded it into the question and Mr. Alessi let it go. I wouldn't. I'd still object. Assumes facts not in evidence. We haven't established her opinion evolved. Hey, kudos to Bev once again. She did, in front of the jury, call out that the problem with what he's doing there is being argumentative. Leave out the argumentative part. If you're going to chastise the attorneys and how they ask their questions in front of the jury, at least do that with both sides. So nice to see the Commonwealth getting a little taste of that for once. It's certainly very well earned. They have been extremely argumentative throughout a significant part of the case. Well, I'm going to go ahead and give us, I'm going to give them a few minutes on the stream to see if they come back to do anything, or if they're just going to chit chat at the sidebar and then tell us they're going home, which is kind of what I expect. But yeah, sorry about the glitching. Kept kicking me off the stream, kicking me out of the stream. I had to go back and get back in and get the feed back up. But hopefully, I don't think we missed anything material. A couple of times that happened today. She worked with somebody from a law office, paragraphs and format, but not the content. Well, I mean, the bulk of what we wanted about Dr. Russell's testimony, I think we got before the lunch break. So when we came back after, we just examined the wounds a little bit more closely, talked about them. What's lividity? What's the wounds? The fact that these are multiple strikes from a dog, in her opinion. Brennan seems to have now implicitly at least given her permission to talk about it being a dog attack. He went ahead and used that parlance. So for the sake of consistency, let's go ahead and stick with it. In fact, when I get back on redirect, I might even make that specific point. Dr. Russell, during cross, you were talking about a dog attack, and I just want to stick with the parlance to make sure we're talking about the same thing. So when you describe this dog attack, hey, if he wants to object, let him object, but you went ahead and adopted it. She thinks all of the bites are incomplete. They don't penetrate the skin. They're just scratches on the surface. Oh, you mean they're superficial? No kidding. What does she mean by that? It doesn't extend to the soft tissue underneath the full depth and thickness of the skin that is on the surface. The skin is elastic, so there can be some movement. It moves over the underlying bones. You can also have issues with clothing, issues with position, issues with motion. Those things all matter in terms of the appearance of the wound. She believes they all happened at the same time because there is what she calls a vital reaction, meaning ever so slight signs of inflammation around the edges of the wound. You need to be alive to have an inflammatory response. So that tells her it occurred before death, not after death. That was a question I had during the first trial. Is it possible John's out front and some animal comes on and chews on him, post-mortem? Doesn't, you see the scrapes on the arm, but you don't see any bruising. It doesn't look like swelling or anything like that. Wouldn't you normally expect that? A living person is attacked by the dog, not just you're going to get scraped, but you're going to be like swollen, and it's going to be a little bit of a mess. That was my thinking, but looks like it kind of falls somewhere in the middle ground of it's enough before death that there is an inflammatory response, but close enough to the time of death that the inflammation response remained just slight in around the edges of the wounds. Perfectly normal for a forensic pathologist to look at photographs. Then we got into the motor vehicle collision and the ruling that out. And she didn't like that. Hank didn't like that. She meaning Bev, trying to lead that in with a differential diagnosis. How did you rule out a motor vehicle accident? They don't want her to be able to talk about that. So instead, we just go to Welcher's report. And here's this guy, and look at all the injuries that guy had. It's the same thing we said when Welcher uses this example. This guy has got 2 collapsed lungs and a lacerated liver. And I don't think we knew about the degloved hand, the arm. I don't think we knew about that. But that's, going to be pretty serious. Degloving is gross, guys. That's one of the avulsion injuries where your skin you're flayed. You've been flayed. Okay, you've been flayed. Your skin has been removed. That's pretty serious. John, of course, did not have any similar injuries like that. Then the clothing and in relationship to the wound, the shape of the hole is rounded. It's got that little bit of fabric coming back out. Why? Because that's a snag, guys. That's what happened when something goes through and punctures it, but then it catches on the way out and it pulls some of the thread back out. Every single person on the planet has snagged a sweater. Understand how that works. But the rounded shape of the hole, she thought, was significant because it appears to be a canine tooth. Common to look at this in forensic pathology, to look at the clothing and the patterns that emerge from the clothing. Looks like she's just saying, I don't know. Whatever she's saying, I guess they're not going to share the sound with us, but give them a moment to see if they have anything to say on the record. Doesn't look like it. Bye. Yeah, okay. So I kind of thought that was significant and a great point to raise, because the examples that she's able to give make so much sense. Oh yeah, with gunshots, help you figure out the entrance wound versus the exit wound. Makes perfect sense. Stab wounds, things like that. Is it offensive? Is it defensive? Yeah, I could totally see that being something that you need to look at. You need to look at the clothing and compare it to the wounds, and it can potentially add to the story beyond what you can tell just by looking at the wounds alone. So then, not allowed to give an opinion about whether John's clothing was consistent or inconsistent with the types of defects she's seen in clothing from motor vehicle collisions. Even though she established, yes, she's looked at them before, but she's never been asked to determine whether there was a motor vehicle collision based on those defects. So I think that's why she's not allowed to give that opinion. No, you don't have to see a specific dog. Yes, she has read some studies that support her work, and just reiterating that she believes these are dog bites and or claw marks, and she holds that opinion to a reasonable degree of medical certainty. So then we get to Cross, and we start off with how she's never been a dog bite expert in court before. She testified last year, we heard about what she did. She spoke to the DA in Los Angeles. She interjected herself in the case, according to Brennan. According to her, I knew I was one of the only people in the U.S. who would have the relevant experience and knowledge to be able to evaluate this. So she thought she could help clarify whether or not this is a dog bite. So yes, she did get hired by the defense. She knew that there was a relationship between the LA district attorney she spoke to and one of the attorneys on the case. We know already that's Mr. Jackson. He used to work in the LA district attorney's office. So then after the trial last year, there's a listing service for physicians. I don't know, Hank's calling it marketing. It's not clear what exactly this is, that has a photograph of her from the trial, and it lists her as an expert in dog bites and so forth. She had at that point retired from her full-time medical position, so she wanted to get more involved in forensic cases, but she hasn't testified since then as a dog bite expert. Hank wanting to clearly insinuate you're trying to gin up a career as a dog bite expert. That's what all this is about. You interjected yourself and then marketed what you did. If true, why is that a problem? She does seem to have pretty unique and extensive expertise in dog bites. So why would that be a problem? Are you only allowed to advertise if you're aperture? She agrees there's generally a difference between the law enforcement canine dog bite and what that looks like, and the civilian dog bite, what that looks like. There's no classes on pattern recognition of dog bites. She has a whole collection of photos of them that she's been taking since the 1990s. She's seen the pattern many times. Uniquely qualified when it comes to dog bites. Doesn't know of another doctor in the U.S. with the 2 residencies and a lifelong interest. Not to say there isn't anybody else out there. She just doesn't know of anybody. There's about 500 to 600 practicing forensic pathologies right now. She doubts that many of them have a specific interest in dog bite wounds. If they've only autopsied 1 or 2 cases with dog bite wounds, she's not sure that person would be a very good expert. I mean, is that not sensible? That seems pretty sensible to me. If I'm a doctor, I'm just a regular treating physician, and I've never seen porphyria. Am I going to be very good at diagnosing it, analyzing it, at recognizing it on site? Maybe not. Maybe not. I mean, it might depend on, what stage are you in? Are you actually blue at this point? Would that narrow things down? I don't know. But if you're the person who has seen everybody with porphyria, you have a special interest in it, so you've hunted that down. Are you going to be able to spot the porphyria? Yeah, probably. Isn't this just logic? Seems pretty logical to me. Dr. La Posada, this was what a misstep by Brennan, trying to get her triangulated against Dr. Russell. That's not going to work. Where no, she's got a fantastic reputation nationally. I've heard of her outside of this case. She's given national presentations. Very familiar with her name outside of this case. Only reason to know she has any involvement in this case at all is because her name is on like a file folder. And she was extremely interested in reading the report, but there wasn't one, so she didn't ask. Otherwise, as far as quote unquote peer review, remembers Dr. Sheridan from the first proceeding, and he also believed they were consistent with dog bites. Hank, you got to be careful what you ask. Okay. Jury wasn't going to know anything at all about Dr. Sheridan, but now they've heard, hey, in the first trial, there was Dr. Sheridan who also thought these were dog bites. Then we get into the non-physicians. Somebody who has a lot of experience with dog bites might be in a position to say that something is consistent with a dog bite. She'd prefer to hear something like that from a physician, but she's not going to say only an MD could. If someone had seen hundreds of the wounds that they know are inflicted about the dog, they might be able to comment about that. There are no courses on it, so she can't take a course that doesn't exist. She doesn't have veterinary degrees. Testified multiple times, including at a hearing before trial last year. Thanks for reminding us of that as well, Hank. It was a trial that was had last year. She also had the town of Canton dog bite report in the materials that she reviewed. Dog bite report. She relied on Scorty Bello and the superficial characterization is superficial, no depth or puncture. Doctor's like, yeah, there's no inconsistency with any of that. I agree. I agree with that. Have you not testified very differently? No, she says, as far as punctures. Well, we'll do that later. Don't mind my binders up here. It's literally the reason why you have a binder with a witness, so that you're prepared. All the material that you need for your part of the examination. You've anticipated that. That's why you have a binder. That's what is in the binder. Hank, what is in your binder up there if it's not the materials that you need, that you have prepared in order to cross-examine Dr. Russell? What even is that binder? Is that your safety blanket? Is that Hank's version of the 8 laptops and smartwatch and so on and so forth that Dr. Welcher had up on the stand? Don't know, but he wasn't ready for that cross, so we'll do that later. He's got to probably go and have somebody find it for him overnight, and then come back tomorrow to talk about what she's testified previously about punctures. So no, she doesn't believe she's changed her opinion many times, doesn't accept that characterization of it as being an evolution. She received some feedback on format, but the content is her work. It was not Mr. Alessi. It was somebody from the law office. The first time she testified that it was consistent with an animal attack, she was certain that that was a dog. But in medicine, nothing is 100% certain. So she's given that generalization. And since then, she's done more reviews. She's read more articles. So possibly, yeah, she might be a little bit more certain than she was before she testified last time. But she believed it was a dog attack at the time. Made it pretty clear. That's what she thought at the time. That it was either a bite or a scratch. And there's no real specificity between those injuries if you don't have a piece of tooth or a piece of nail in the wound. Keratinized tissue. This brings me back to keratinized tissue. It was found on the sleeve of John O'Keefe's hoodie near those punctures. We already know. We haven't heard yet. We know from the first trial they had pig DNA. They sent those swabs off to the lab to try to see if there was dog DNA on any of those holes. No dog DNA, but there was pig DNA, and there was also keratinized tissue. Google that out of curiosity. What is this? Oh my, it's gum tissue. I realize it can be other things besides gum tissue, but that's like the top thing that comes out. It's gum tissue. Gum tissue and pig DNA. Anyway, we're not there. May not get there with her. May not get there at all. I don't know. Just a little piece of something that came out of the first trial, that pig DNA. Is the defense going to bring out the pig DNA? I do wonder. Maybe not. Maybe we'll just let that one lie. I don't know. I find the DNA, the pig DNA, helpful to the defense. I mean, explain to me how the pig DNA gets there if it's a taillight bite. Does the taillight regularly eat pork? Is that one of its favorites? You know, you gotta sit down for a healthy pork chop dinner before a busy night of shattering and exploding. I think that the pig DNA is helpful just in terms of explain how it got there, but I guess if you can't rule out it's just background, you know, somebody was eating bacon and wiped their greasy fingers on their sleeve. That would explain pig DNA being there. It just doesn't necessarily have anything to do with the holes. So maybe we're not going to get the pig DNA this trial, which would be, it's fine substantively, but that was just such a fun thing to come out in the first trial. What with the police misconduct and so forth, there were just too many jokes that wrote themselves with the pig DNA. So once again, yes, most likely a large dog, some overlap in the appearance of nails and claws versus teeth. They can be arranged similarly, but otherwise not necessarily a lot of specificity. And then when it comes to sort of the logistics of this line of questioning and how exactly are we going to question her about it, Alessi wants a sidebar. Bev says, we're just done. We're just done for today. We're just done. So that was that. That was the rest of what we got from Dr. Russell after lunch. So overnight, Hank will have the opportunity that it seems that he may need to be able to come back and actually have something in his binder that's actually helpful, that he actually needs for the examination. Her prior testimony, her written reports, exactly what statement you intend to confront her with. You should really be prepared with that statement. That's kind of trial practice 101, something you learn very, very early on in the process of conducting a trial. Be prepared, just a little thing. But seems he's not. So coming back to a lot of these things tomorrow. So before we get over to your comments and questions, just to take us back to right before lunch, there was a question about the missing witness instruction. What is that? What does that mean? Can they argue it? So I went ahead and found some stuff that I'm going to share with you guys. So first off, we do have a rule. Now, of course, it's Massachusetts, so is it a rule? Maybe not. It's from the Guide to Evidence, which is not really a rule, but it's a statement of what Massachusetts law is based on the common law. And so they've got lots of notes and things like that to it. So it's section 1111 of the Guide to Evidence on missing witnesses. So very clearly, what does it say? Argument by counsel. Counsel is not permitted. You cannot argue that you should draw any inference from somebody not testifying at trial without first obtaining judicial approval. If approval is granted, the court must give a missing witness instruction. So very clear. You don't get to make the argument without first bringing it up to the judge. It's going to be their burden to get prior approval. That's why they have filed the motion. It's not we make the argument and wait for the other side to object and then deal with it. You have to pre-clear it before you go down that road. When is the jury instruction called for? The court may instruct the jury that an adverse inference may be drawn from a party's failure to call a witness when, 1, the witness is shown to be available. They're not dead. They still live or work in the jurisdiction. They can be subpoenaed. Perhaps they even are subpoenaed. 2, the witness is friendly or at least not hostile to the party. This is an important one. The witness is friendly. Who's the witness affiliated with? Which side? 3, the witness is expected to give non-cumulative testimony of distinct importance to the case. Like what? I mean, like a prior accident reconstruction, like the kinds of things that a lead investigator did on the case. For example, the search that he did on his own, his handling of the evidence that somehow ended up without a chain of custody, et cetera, et cetera. And 4, there is no logical or tactical explanation for the failure to call the witness. Now, that's an interesting qualification. So I want to break down this rule a little bit. So first off, the witness is friendly, or at least not hostile. That is, I would consider this a pretty generous standard for giving a missing witness instruction. Many places it's going to be more stringent than this. Not just that they might be sympathetic to your side more than the other side, but that you have to have some special relationship or some specific control over them, that you have some kind of unique access to them that is not available to the other side. So, for example, in Washington, very difficult to get a missing witness instruction, because even if it's like a police officer, you have the power in Washington to go subpoena that person, because I get to do it myself. I don't have to ask the court to do it for me. So I have just as much ability to compel a law enforcement officer to come into court as the prosecutor does. That means the witnesses are not really uniquely available to the prosecution. It makes it very difficult to get a missing witness instruction. It's much more common when it's, somebody who's like, I don't know, maybe a confidential informant. We don't even know who they are. I don't have the ability to call them because I don't know their identity. I don't know their identity. Okay, but the police do, because the police have worked with that CI. So if there's like a CI in the case who you would expect to hear from and you don't hear from him, it could come up that way. But here in Massachusetts, very permissive, no requiring of a special relationship, just that they're friendly or at least not hostile to the party. So Proctor, Paul, friendly to the prosecution? I would think so. They were the prosecution's witnesses before. They are the lead investigator and the crash reconstructionist, respectively. Non-cumulative testimony of distinct importance to the case, kind of talked about that. It can't just be more of the same. And that's part of why I think Mr. Brennan was trying to turn Yuri Buchanek into the surrogate lead investigator, so that he can try to get everything out that Proctor would have to say. If Yuri can testify about it, then for Michael Proctor to come in and say the same thing, what day did you come, what time did you come in? When did you get the call? How was the handoff from the Canton Police Department? What did you do first? Who did you talk to? Et cetera, et cetera. He's trying to take as much off the table as possible so that if Proctor comes back in, whatever he has to say would be cumulative. Problem in this case, though, is that there's stuff that has Proctor's hands on it that he's the only one that knows. He's the only one that can answer. You booked the stuff into evidence, or you were the one who at least took responsibility for it. What happened to it? Where was it? Where did it sit in the meantime? Why did you make the decision to leave it unsecured? His search, his glass, or now I'm trying to remember the piece. He found a piece of glass, item 7-14. I think that was on the February the 18th. It might have been the February the 10th, though. I can't remember now off the top of my head. One of the times he's out there by himself, he finds this particular piece of evidence. He says it's non-cumulative. Nobody else can testify about that because nobody else was there. So I think that's what Hank was trying to do, but you just can't take it. You can't take it totally off the table. Not to mention, just to the extent he's the lead investigator, he makes the decisions about what gets followed up on, who does what, priorities, et cetera, et cetera. Can anybody else really answer questions then about how the decisions were made? Questionable. Then this last one, there is no logical or tactical explanation for the failure to call the witness. This is very intriguing to me. I don't think I've seen a rule like this before where there has to be no tactical explanation for the failure to call the witness. I mean, it's always going to be a tactical decision not to call them, isn't it? Why? Because the person would blow up my case. The person would say something that's not good to my case. Of course, that's the tactical reason why you wouldn't call them. In this particular case, because Proctor's a shit show. He got himself fired for all these different reasons. He's extremely impeachable. So it's a tactical reason not to call him so he doesn't get impeached. I have a hard time. I have a hard time with this rule because it's really not particularly clear. So I want to go into this this subsection B now. Of course, once again, whether to allow the argument and give a missing witness discretion is missing witness instruction is within the discretion of the trial judge, even when the foundation requirements are met. Okay, 1 through 4, you've established them. Still up to the judge whether that instruction is going to be given. Cannot be insisted on as a matter of right. So then the foundation for the instruction, it gets stated in different ways in the case law, doesn't it? So in this particular case, we look at, now this was a case where it was the defendant who didn't call a witness. So that will come up sometimes too. In fact, that might be even more common if the defense is like, oh yeah, well, I was with my brother on the day of the crime and it didn't happen. The jury's going to naturally wonder, well, where's your brother? Where's your alibi witness? Why isn't he backing you up? That's like the context where you most often see it. You usually see it used against the defense, not against the prosecution. But so to look at whether there's been a specific foundation, we look at one, whether the case against the defendant is so strong that faced with the evidence, the defendant would be likely to call the missing witness if innocent. 2, whether the evidence to be given by the missing witness is important, central to the case, or just collateral or cumulative. 3, whether the party who fails to call the witness has superior knowledge of the whereabouts of the witness. So now we have a little bit of a distinction. It's not just they're not hostile, but you have specific, better knowledge than the other side about where the person is. And 4, whether the party has a plausible reason for not producing the witness. So stated a little bit differently in the case law than they've articulated it here in the guide to evidence. So what do they look at? Availability does not require proof of actual physical whereabouts, but the court will look at whether the party made reasonable efforts to produce a witness under the circumstances. Did you subpoena this person? Did you try to serve the person? What sort of problems did you run into trying to get the person to appear? Did you at all? A missing witness instruction is not warranted where a witness is equally available to both sides. Okay, so here's kind of what I was thinking about. Here's a case where court ruled the instruction was not warranted because both sides had the same contact information for a witness who was not aligned with either side. The instruction may properly be given where the missing witness is more friendly to one side than the other, even if the witness was available to the party requesting the instruction. So we got a lot of inconsistency and sort of ambivalence about whether this instruction is going to be given or not and under what circumstances. Equally available to both sides, shouldn't get the instruction, but if he's more friendly to you, then I get it. I don't know. Very, very bizarre. Very bizarre. A lot of these kind of breakdowns of what some of these standards actually mean. Would they be expected to give testimony of distinct importance to the case? He's the lead investigator, right? He's the original crash reconstructionist, whether we're talking about Trooper Paul, whether we're talking about Michael Proctor. Would he have something material to say? Let's go back, Seraph and Good. Seraph and Good and Mulaney and all the other first responders who were at the scene who did not hear Karen say, I hit him, I hit him, I hit him. When the first responder at the scene, the very first guy who's there, who's dash cam we're watching, Officer Seraph. So important that you'd expect them to call him? Well, I don't know. Maybe not. Maybe not. But I think it just does kind of raise the question. And then is there an explanation for the failure to call them? So if the circumstances suggest a plausible reason for non-production of the witness, the jury should not be advised of the inference. Thus, it is not error to refuse the instruction where it appears the witness may have been withheld because of a prior criminal record. Strategic. That's the strategic reason this witness is going to get impeached with their past. I don't know how that isn't going to be really analogous to Proctor. We're not going to call Proctor because he's been fired. He's a shit show. He's going to get impeached with his previous misconduct. That seems real similar. So then we get into criminal cases. They must not draw an adverse inference from the defendant's failure to call a witness unless and until they find beyond a reasonable doubt that the witness, if called, would have given testimony unfavorable to the defendant. So basically, this is, it looks like a special kind of qualification for dealing with the situation when the Commonwealth is trying to get a missing witness instruction against the defendant, because of course the defendant has no burden of production, no burden of proof. They don't have to present any witnesses at all. So the jury in that case, to draw the negative inference, has to find beyond a reasonable doubt that person would have said something. You don't get to reverse that and be like, because they're not here, we can infer that they would have said something negative. You have to start from the standpoint that this person was going to testify unfavorably to the defendant. And then you get to make what's the inference? The inference is that they were going to testify negatively. So a little confusing there. The witness, its instruction itself, we do also have that form. Let me blow it up here so that we can see it. Have I not been showing any of this the whole time I've been looking at it? Oh boy. Here is the absent witness instruction. You guys see that? This is if the defendant doesn't call a witness, but you go down and you get if the Commonwealth doesn't call a witness. So here's what the defense is asking for. If the Commonwealth did not call a potential witness to testify and 4 conditions are met, you may infer that the witness's testimony would not be favorable to the Commonwealth. The conditions are, first, that the Commonwealth's case against the defendant is sufficiently weak that it would normally be expected to call that witness to testify. So once again, this is wording that comes out of that case law. It's not exactly what they said in the evidence guide. In the evidence guide, it's just shown to be available. But here, the case against the defendant is sufficiently weak that it would normally be expected to call that witness to testify. Second, that the absent witness would be expected to offer important testimony that would support the Commonwealth's case. Third, that the absent witness is available to testify for the Commonwealth. And fourth, that the witness's absence is not explained by any of the other circumstances in the case. That's what they'd be told. That's what they'd be told. So does that make sense for Trooper Proctor, Trooper Paul, to make these kind of findings? Sufficiently weak that you'd be expected to call the Massachusetts State Police accident reconstructionist, the lead investigator. If any of these four conditions has not been met, then you may not draw any inference from the witness's absence. If all four conditions have been met, you may infer that the witness's testimony would not be favorable to the Commonwealth if that is a reasonable conclusion in the circumstances of the case. So a lot of throat clearing with this inference. You can, but you don't have to, but you can if it's reasonable, but only if. This rule is based on common sense. First, you may not draw such an inference unless the Commonwealth's case was sufficiently weak that it would be expected to bring in the absent witness. Second, you may not draw such an inference. We're just restating the foundational elements again now. Second, you may not draw such an inference unless the absent witness's testimony would be relevant to the defendant's guilt or innocence in some significant way. Normally, the Commonwealth would have no reason to bring in a witness who would only testify about minor details or who would only repeat what has already been said by other witnesses. Is that what we would expect from Trooper Proctor, former Trooper Proctor, Trooper Paul, Officer Seraph, any of these other people? Third, you may not draw such an inference unless there is evidence that the Commonwealth was able to bring the absent witness into court. Any proof that they couldn't get Michael Proctor served? Any reason why we suspect Michael Proctor would be taking the fifth? Any reason to think any of those things? Otherwise, seems like you could subpoena him. Trooper Paul, as far as we know, still employed by MSP. Any reason you can't get to him? And fourth, you may not draw such an inference if the evidence suggests another reasonable explanation for the witness's absence. So they have this, this cautionary, like if somebody slips out and makes an argument about missing witness, there's a cautionary instruction they provide. So ultimately, this is what the defense is asking be given to the jury, this instruction. Under these circumstances, you can just infer that the reason why the Commonwealth didn't call Michael Proctor, didn't call Joseph Paul, didn't call Stephen Seraph, anybody else that falls into this, didn't call Good. If these foundational requirements are met, you can infer the reason why is because it would be bad for them. That's why they didn't bring it up. Because it would be bad for their case. I honestly don't know that I love this in this particular case. I'm not sure that I love it in this particular case because we don't have to infer that it would be bad for the Commonwealth. We already know that it would be bad for the Commonwealth. And the reason why we know that is because we've heard from these people before. And so we can also just call them and put them on the stand knowing that it's bad for the Commonwealth, what they have to say. So we don't necessarily have to rely on an inference and whether the jury decides that or not. We could actually, get the witness testimony and put it out there and show that it's unfavorable. Where the missing witness instruction, I think, typically works the best is when it's a situation where somebody has absconded or you have a confidential informant that they don't want to identify. There's some actual, impediment to being able to call somebody as a witness so that you can't show it's bad for the Commonwealth because here I am putting them on the stand and eliciting the stuff that's bad for the Commonwealth. You're prevented from doing that in some way. And I feel like that's really what this rule is intended to highlight, is that circumstance. So if they're not really prevented from calling these people themselves, honestly, I'm not 100% convinced it's like the best scenario for a missing witness instruction. But it has been the Commonwealth's case. I think with Proctor, it's the most, it stands out the most because of the fact he's the lead investigator. How do you not call the lead investigator in your own case? So I understand, because he's impeachable AF. So seems like that might be a way to get him out of giving it in this particular circumstance. I don't know. So I haven't seen that any of the motions themselves have come out yet. Maybe they have, but I'm going to be interested to see what exactly is the reasoning behind this and what's sort of the justification for why it's appropriate in this situation. Who are we focusing on, and why? Why do we want it? As far as death, Berkowitz, he's equally unavailable to both parties. You wouldn't get a missing witness instruction for failing to call Chief Berkowitz because there's no opportunity. He's not available. That one they can pretty well show. So, guys, what have y'all been thinking? What have y'all been thinking? A desire for civil discourse? I thought the original story was that there was video showing her back into him, slam dunk. Keep wondering who leaked that lie. Back in the very early press coverage of the case, several outlets reported that police had recovered ring camera video, and they never explicitly came out and said police have ring camera video that depicts the incident, that shows Karen Reed hitting John O'Keefe with the car. But it certainly was implied by the context, wasn't it? And I think that really screams everything about what the source of the leak was. Because as it turns out, yeah, they did have ring camera video. It's just that it was from John's house. It was from John's house. It wasn't from the scene at all. So it's one of these things where the report is technically correct. Police had recovered ring camera video in the course of the investigation. It's just contextually enormously misleading because it's being reported when they're talking about the strength of the case against Karen Reed, and the video from John O'Keefe's house really doesn't add, certainly doesn't add anything inculpatory. If anything, it's just exculpatory. The fact that they have the ring camera that shows her hitting John's car at 5 something in the morning. So, I think that says a lot, that there's this information out there that just happens to be technically true, but reported in a context that makes it incredibly misleading. Who would have an interest to do that? Who would benefit? Who would benefit from that type of information being out there, that kind of pressure being put on a defendant to just go ahead and plead guilty? Guys, they got you on video. You got nothing to work with. You're done. You're done. You're cooked. Maybe somebody who thinks she's fucked. Maybe. Let me, I realize my banner is still up and it shouldn't be. Miranda Bauman, FBI involvement reveal a double-edged sword. On the one hand, it suggests something fishy with state local PD. But maybe to jury, it's a nothing burger if no expert FBI called about the bad investigation. Yeah, the jury isn't going to know that the supremacy clause poses a major hurdle to being able to subpoena a federal law enforcement officer into state court. They're not going to know that. So there's a lot of trade-offs with bringing in this particular piece of information. I've suggested before, and I still kind of suggest that it may not be great to have the FBI involved, because doesn't it make it sound like the FBI then was involved in investigating John O'Keefe's death? that they were involved in investigating Karen. Like, you're not going to automatically think, oh, they're investigating something related but different. If you hear that they have a grand jury and they're talking to the witnesses about John O'Keefe and the last day and all the same kind of stuff that we've heard about over the course of this trial, aren't you just going to assume they were investigating John O'Keefe's death? And lo and behold, we're sitting in court with Karen Reed being tried related to John O'Keefe's death. It almost kind of bolsters the investigation, and it almost gives a hint, if that's the impression that you have, well, even if the state did all of these ridiculous and crazy things and bad decisions and stop and shop bags and solo cups and no chain of custody and bias and all this stuff, but the feds were involved in the investigation, and now here we are in court prosecuting Karen Reed, you're potentially undermining the strength of all that evidence of the weakness of the investigation, because they might just infer, well, but the FBI was involved, so they got all that straight. They worked through all that. They sorted all that out, you know? So yeah, I think there's a potential for it to be a mixed bag, having the FBI involvement known. I just don't know that anybody on the jury can be expected to have the type of sophistication of the system to understand. We're not going to hear from a federal law enforcement officer because of TUI and the supremacy clause. The FBI is investigating not John O'Keefe's death. They have no jurisdiction independently to investigate John O'Keefe's death, so they're investigating something else. They don't have jurisdiction to prosecute Karen in state court, or have really any involvement in Karen Reed's prosecution in state court, unless the state folks want them to. The jury's not going to know these things. So, yeah, I think that is a potential risk, potential downside. They could think, oh yeah, this is a trashy local investigation. Thank God those FBI folks came in and got involved and double checked everything so that we can be sitting here prosecuting Karen Reed. I think that's a real risk. Joshua Frost, I fell and caught myself with my knuckles. There's a little throwback to something we're not going to hear this trial. Old Colin Albert doing that catching himself by his knuckles maneuver that nobody on the planet has ever done before or since. Literally nobody slips on a frozen driveway and catches themselves by the knuckles. The Marilyn Manson cases. Why do you think Yanetti had Proctor's friend authenticate the text? He doesn't want to call Proctor. He doesn't want to call Proctor. He wants the text to come in without having to call Michael Proctor and talk to them about it. And he doesn't want to call Michael Proctor because he doesn't want Mr. Brennan to be able to walk Proctor through a rehabilitation case by the nose on cross-examination, which he would be able to do. Ask him the leading questions, just put words into his mouth. Hank gets to make up every explanation, every excuse, every justification, whatever that he wants to, and just put it in Michael Proctor's mouth, and Michael Proctor just needs to sit there and nod, yes, sir. Yes, sir, that's exactly right. You don't want to give him that opportunity. Greg S., when the Commonwealth says objection to what? We'd all love to know. We would all love to know. It would be so much simpler if, like in every other court in the country, you simply stated in one or two words, very briefly, the basis for your objection. Foundation, personal knowledge, assumes facts not in evidence, argumentative, whatever. But Judge Cannone very specifically doesn't want us to do that. We didn't do it in the first trial. She instructed them on the record, I just want you to say objection and not say the basis for it. This trial, they brought a motion. The defense brought a motion to be allowed to state the basis for their objection. And she said no. She said no. So we'd all love to know, but we are expected to read her mind. That has been communicated very loudly and clearly. We should already know, at least the lawyers. The lawyers should already know what the objection is. You public, you peons, you don't matter. You don't get to know one way or the other, but the lawyers, they should already know. They don't need explanation from her. That's her justification. On the record. Ty, dog reversed Lexus into him, then bit him? Maybe. Maybe this is like a Transformers Lexus, but instead of turning into like a cool robot and anthropomorphic type of thing, it's a dog. I don't know. Netosphere, wasn't there footage of a female cop in the Sallyport entering, then quickly ducking out in the first trial? Kelly Dever. I vaguely remember this as well, that there was a female at one point, and I thought they thought it was Chief Rafferty. That's what I remember. But I don't recall that the person was ever definitively identified, because this was during Yuri Buchanan's testimony in the first trial. And, when he first looked at the video, when he's on direct, he's very clear. Here's who everybody is. He can identify everybody. Then he gets on cross and suddenly nobody is familiar. Never seen any of these people before ever. So my recollection, this came up on cross. It was part of the video. They showed him. I don't recall that he identified the person specifically, but I think they asked him, is that Chief Rafferty? So I don't know. I don't recall that Kelly Dever came up the first time. Possible. TCP, at least one of the experts keeps their CV up to date. Yeah, good job, Dr. Russell. Keep it up to date. You did testify last year, and you should get all the credit that you deserve for that. The Sally Portal. Did ME at the time have evidence that there was no blood or tissue on taillight pieces? I don't know when she would have got that information. We heard from Maureen Hartnett, who is the one who did all that analysis, but I don't think we got dates from her about when she did, each specific part of her examination or whatever. We know that Dr. Scordi-Bello did the autopsy, left the case open for the 90 days before she finalized the inconclusive determination and submitted it. It's not a hard and fast, it's not a law or anything that they have to do that, but just the policy of the office to try to get it out within 90 days. So she followed that. And that would mean by no later than the beginning of May of 2022, she had already made that decision. So had Maureen Hartnett started working on the swabbing and so forth and providing any of that evidence back to law enforcement? I don't know. Don't know how the time frame of that works. I would suspect no. If I were just kind of guessing in a vacuum, I would suspect no. She probably hadn't started doing that yet, but we don't know. Alyssa Ramirez, this needs to be an Andrea Burkhart boxing play-by-play video, Brennan versus Dr. Russell. She's got some good counter punches in there. She's finding ways that he opens himself up. So maybe we'll come back to this tomorrow with a little bit more of a boxing eye to what it is that we're watching. Mr. Brennan is by and large a pressure fighter. He likes to move forward. He likes to be on the front foot. He likes his witnesses being defensive. But you can really overextend that way. You can get yourself caught in a bad position. And so we've already had a couple little jabs, couple little counters from Dr. Russell when he came forward, and his attack was maybe not what he thought it would be. Oh yeah, La Posada, she's nationally renowned. I'd heard about her for years. I couldn't wait to hear what she was going to have to say. Get out ahead of yourself a little bit and you might get something like that. Then that Dr. Sheridan from the last trial, he also thought it was consistent. Got to be careful if you're going to go rushing forward. You might get caught. Why? Because you can get timed. You start to become predictable. Somebody does the same thing over and over again. Okay, they're in their guard. And one of the things you're always doing, you're looking for tells. You're looking for, how does this person move before they do whatever? So real common thing, for example, see it a lot with rookies. You drop your hand before you throw it. It's just real slight, but you don't shoot it straight out from the guard. You just drop it a little bit and then throw it. And so people start to be able to spot these things. And so then as soon as they see the hand drops, we already know it's coming. The counter is already coming out. I already know what you're going to do because you've made yourself predictable, doing the same thing over and over again. People do the hand washing, they call it. You got your gloves up, but you kind of like shimmy them a little bit. Hand washing, another very common motion that gets very easy to read if you don't cut it out. So what the good boxers do at the high level, you don't necessarily just eliminate all of these things. What you do is you eliminate these things mindlessly. If you drop your hands, you're doing it on purpose. Okay. It's not something that you're just doing and you're not aware of. You're doing it on purpose. So they know. Okay. Now we've got the meta, the meta thing going on where you know that I'm dropped, but I know that you know that I dropped my hands. Okay. So now I am foreseeing that you are going to be anticipating this. I'm setting you up by getting you to expect something. So then you respond. I already know you're going to respond, and I'm prepared for that. So if he were doing that on purpose, we might be seeing Dr. Russell be set up for some kind of counterattack she's not expecting. We'll have to see how all this plays out. Thanks for the suggestion, Alyssa. That does sound kind of fun. It does sound kind of fun to look at this in a boxing kind of framework. Gray space. Hank's trying to be polite, but clearly is so mad. Was he trying to be polite? Sorry, I didn't mean to be sharp. Yeah, you did, Hank. We've all been here with you for this entire trial so far. We saw how you talked to Mr. DeSogra the other day, who did nothing but read your client's reports, your experts' reports, and critique them and have opinions about them. And we saw how you talked to that guy. We know perfectly well if you were sharp, you intended to be sharp. What you didn't intend is to be caught doing that to this witness. Because yeah, she's extremely likable. Very likable, very qualified. You got to be cautious coming at somebody like Dr. Russell with your criticisms. Very mad, fuming. Law and order. Hank trying to use superficial colloquially. Yeah, we both caught that. He likes to equivocate. So if a word has multiple meanings, we'll just use them interchangeably. So superficial might mean it's not really that important, or it could mean what Dr. Russell told us it means, which is it didn't puncture all the way through the skin. It didn't reach the underlying soft tissue. Covia 43. If people want to see a professional trial, watch the Anderson Maxwell case. PD, lawyers, and witnesses act professional. It's a breath of fresh air. It is kind of nice to check in on another proceeding from time to time and just get the reality check, get a little bit of a reminder that what we are seeing here in this courtroom is not necessarily the norm. Now, it happens far more often than we'd like to think it does, that there are prosecutors who go out on a limb with cases that they shouldn't bring, that there are police that are dishonest, that there are judges who are just reflexively pro-prosecution, et cetera, et cetera. Okay, all this stuff is pretty common, but it's not universal. There are exceptions to that. And if you are finding yourself in a situation where you are perhaps losing faith in the system based on what you're seeing here in this courtroom, good to temper that, weigh that against the times that it is in fact done well. So I haven't been watching any of the Anderson Maxwell case. It's in Wisconsin, right? If I remember right, this one is in Wisconsin. It's a guy that's being prosecuted for rather gruesome murder of, I think, his ex-girlfriend, if I have the right one in mind. So, different view of how things can be done. I'll take your recommendation as that. John Bonamolo sounds like he's trying to gaslight the witness into uncertainty. Well, that would be par for the course, wouldn't it? Are you sure you're not uncertain? I'm just gonna ask you the question, Bilton. Before you became uncertain about your opinion, were you? I mean, he does. He's got his own interpretation, and he's bound and determined to force that onto the witness, whether the witness accepts that or not, which is, of course, improper. It's assuming stuff that's not in evidence. But it's one way to do it, I guess. If you aren't prepared with what is actually inconsistent between what you said before on this, unidentified occasion and what you are saying today, then you are not, in fact, prepared to establish any kind of uncertainty. You're going to have to assume it because you didn't do your job. Come in prepared to be able to address it. But that's why he needed overnight. He's gotta run and get those transcripts available, I guess. Why was that not done ahead of time? No answer for me. I have no idea why he wasn't prepared today. Jennifer King, I thought gut superficial was due to they weren't his cause of death. The blunt force trauma to the head was the reason. I don't think that's what it means in the medical context. The superficial just means that it wasn't deep. And so, like the head wound might be superficial too. I'm not totally sure on that one. But like, can you see the skull underneath? If you can see the skull underneath, it's probably not so superficial. There's not a whole lot else in your head. You don't have like musculature and stuff in your head, on the like the backside of your skull that you're going to have to, work through to get to the underlying structure. So you split the skin. What do you see? What do you see? You see skull. Is there skull there? Probably not superficial. No skull. It's probably superficial. That's maybe a rough hand distinction, as I understand it medically. Dumpster Juice. This jackhole is still talking about Dr. Russell saying punctate as her evolving testimony. He still think it means puncture. Well, he might, and maybe she'll be prepared to hand his backside to him. If he's going in with that being his line of attack, and he's got a bad assumption built into it that punctate equals puncture, then he's not going to get what he wants from the witness. And the only question is going to be, how badly does he get countered? Does he get countered? And you could just neutralize this by pointing out punctate is not the same thing as there being a puncture wound. But is there an opportunity for a counter in that on top of it that could damage him? That's really, I think, the question in all of this. Thankful Q, thankful K, thankful. I'm going to go with thankful K because that's what it looks like. He sounded like Elaine in 15 Minutes of Fame. Too bad she didn't know Spicy Draco's response. Yeah. Sounds like you too would be looking for your 5 minutes of fame, kind of like you did with Whitey Bulger. How long have you been dining off of that particular representation? Where did Whitey Bulger's dead, right? Where did he die, by the way? Where did Whitey Bulger die? Oh, yeah. Why did he get beaten to death in prison? What was he doing there? I read a little bit more. I've been saying for a while, I want to see what I can find that's out there about the Whitey Bulger case. Just know a little bit more about it. I have only ever had like the 10,000 foot view of Whitey Bulger. In fact, one of the reasons why, just a kind of side story, that I even knew who Whitey Bulger was because when I was had my private office for a while, I was in the Rotary Club, and there was another person, this guy who was in the Rotary Club, and he would tell stories. This is back probably 2010, 2011, like early on. He would tell stories that apparently when he would travel, people like the TSA people and stuff like that, they thought he was Whitey Bulger. I guess he apparently looked a lot like Whitey Bulger. He's a kind of smaller guy, you know, fairly thin, had blonde hair, kind of longish blonde hair, mustache. He was a musician. He would like play jazz and stuff like that. But he would apparently tell stories. I remember he would tell stories about how he apparently could not like fly anywhere without some TSA agent wanting to pull him in a room and find out if he's Whitey Bulger. So he was thrilled when Whitey was caught, because now he can travel and he can like write that off of his time it's going to take to get from point A to point B. Rule out that part where I have to spend an hour explaining that I'm not Whitey Bulger. You can just take that off the table. So anyway, that was one of the first times I remember Whitey Bulger really being, in anything that I paid attention to. I do remember hearing about when the FBI officer was prosecuted, his handler, John Connolly, didn't remember his name at the time, but I remember when he was prosecuted, because then I remember when all of that was coming out about, all the stuff that the FBI covered up for him while he was working for them as an informant, and apparently not even a particularly good one. Ooh, yikes. Bad slurp there. Sorry about that. So anyway, that was like the 10,000 foot that I knew really about the case. That was it. So I want to learn more. I went in and read some about the prosecution, the manhunt, all at least some of those details. But I'm still hoping to see if I can hunt down maybe some transcripts, stuff like that. I gotta dig a little bit, try to find some more detail about exactly what Hank Brennan did over the course of that trial. Sure would love to be able to read some of that. Seen stuff that he said, some public statements that he's made after the fact. Continues to defend Whitey. Whitey was a valuable member of the community, very generous, gave back. Created this whole mythology of Whitey Bulger as being this sort of Robin Hood-esque figure. And I bet he's been dining on that pretty much ever since. That Whitey Bulger connection. Yeah, a little spicy Draco might have been appropriate for the situation, but maybe not. If you're not already ready at hand with something like that, then might slip a little on the delivery. So Carolyn Smith, I'm so sorry, just catching up. I'm sure you've addressed this, but does Dever bringing up the FBI open the door? Thanks. Dever. It's very important, guys. She matters critically. So we got to get that pronunciation just right. Dever. I don't think it opens up the door because, one, it was the defense's witness. They can't open up their own door. They're responsible for making sure she knows the limits on the testimony. So if she doesn't know that and she slips out through her, they don't get to rely on that. It was their obligation to make sure she knew not to say that. So I don't think this is going to broadly open the door, even generally if bringing it up was meant we get to bring it up now. I don't think so. Bev is going to continue to keep a lid on that. Okay, it slipped through, but we're not going to draw attention to it. She didn't give any kind of cautionary instruction. Disregard that. She didn't strike it. Nothing. It's just we're going to let it slide, pretend it never happened, but don't repeat it. That's what I'm assuming the treatment of that is going to be. Carrie Mache, what's your remedy for educating the jury about the FBI investigation? I don't know that there is a remedy. I really don't know that there is, because they're not supposed to know it's an FBI investigation at all. I mean, your remedy, in theory, if it had been on the table and we're allowed to talk about the fact that the FBI investigated something that overlapped with the death investigation of John O'Keefe, if we were allowed to talk about the FBI being the source of a lot of this different information, then I would expect something like a witness who would testify about some of these issues. How do you get a federal law enforcement agency in court? What's the differences in their jurisdiction? What's the differences in their scope? And part of that, I think, is it illustrates why we don't get to hear about it in this case at all, because then you end up having to have a lot of collateral testimony about something that is really not the central issue in the case at all. Who the FBI is, how they work, what they get to do, how they interact with local law enforcement. It's getting you afield. So I don't know that there really is a remedy. It is a little bit of a risk, I think. Now, that said, the context, I think, has made it pretty clear that what the FBI has come up with is pretty different from what the state has come up with. I mean, the other agents that Jen McCabe lied to had to call back and correct that statement she gave them about who she'd been on the phone with in the 10 minutes before they came into her house to interview her. That sure gives a real different impression than the Commonwealth here right now calling her and putting her on the stand as their witness. Doesn't that maybe contextually make it clear the Commonwealth and the FBI are not on the same side? It seems to be implied in a lot of what the jury has already heard. It's just, is that implication going to be loud enough now that it's slipped out? It's the FBI. That's who we're talking about here. I don't know. I really don't know. I think that's always been part of the risk of that particular piece of information being part of the trial. Bubbles. Last trial, the Commonwealth defense were criticized for making things too complicated. Do you think that Commonwealth and defense are oversimplifying their case? The balance can be hard. The balance can be hard. I would be the first person to say that, yes, Mr. Lally's case needed editing. It very much needed editing. We did not need to hear from every single person ever, even just as a practical matter. And before you get into strategy, the strategy of why you might call some versus why you might not call them, Commonwealth, probably could have benefited from a little bit more of that as well. So we're definitely seeing more editing in their case this time around. I think with mixed results. Decision not to call Proctor is a real big one. Big difference from the last time. On the one side, you haven't really been able to, I guess, impeach, but they have. They've been able to impeach him anyway, even though he's not here. And so all the Commonwealth not calling Proctor has really served to accomplish is to allow all of these accusations to be hung on a ghost, on somebody that the jury can protect. They can project all of their fears, all of their prejudices about bad cops, what that would look like, who that is. They can project all of that onto this person that is just in their imagination because the Commonwealth chose to make that edit to the case. I don't know that that's a benefit to them. I really don't. On the defense side, their editing has been more from shifting more about shifting away from the Karen Reed was framed, we're making an affirmative assertion about what happened here, and much more towards the reasonable doubt. We don't know what happened here other than we know Karen didn't hit him with a car, because there's too much that got messed up by the law enforcement investigation because they were too eager to protect the people in the house. So they didn't look any closer. But we can't rule out that something happened in the house. It's quite a different approach from something happened in the house and the law enforcement is covering it up, to law enforcement just spiked this investigation so badly that we'll never be able to definitively say, other than we can say based on the data, the car data, the phone data, John's injuries, etc., that there was no collision here. Is it going to be too complicated? I think it's going to be hard to say, for the defense anyway, until we get to the end of their case and see what exactly they focus on. With Kelly Dever, for example, all of that was just so that we could hear that Higgins and Berkowitz were alone in the Sallyport with the car at some point in time, and that may or may not be true, may or may not be a real memory that this witness reported to the FBI. Is that kind of overcomplicating things and all of this in terms of like providing a little, maybe too much specificity about the who, what, when, where, how of the taillight being planted? Or is it just going to a sort of general bias, doesn't look good, shouldn't have been in that type of situation, chief of police should know better, just to kind of add on to what we've already heard about all of the interest that the local law enforcement officers had and the MSP had in protecting one of their own? I don't know. I think it's going to be hard to gauge some of these things until we have it all in perspective. So far, it seems like a simpler case, at least in some respects, in terms of what they've led the jury to expect them to present. We're not going to prove Karen Reed was framed. We're not going to prove who did what. We're not going to prove who threw the lethal punch or whatever. We're just going to point out that there's a lot of circumstances here that suggest the investigators should have been asking who punched John and knocked him down, causing him to crack his skull and die. Where did that happen? Because it doesn't seem like that happened out on the front lawn. How did John end up on the front lawn? These are the questions law enforcement should have been asking, but they didn't. Why? Because they were too busy to protecting the homeowner because he was one of them. That's a pretty simple case. So are they going to oversimplify it or overcomplicate it? I don't know. We got to wait and see. On the Commonwealth side, did they oversimplify it? I mean, the Commonwealth has the basic problem of, John doesn't pass the eye test. He doesn't pass the eye test. He doesn't look to anybody like the guy that got hit by a car accident. Guy that got hit in a car accident, with the possible exception of Judd Welcher, who doesn't rule out that the SUV also flew up into space. To everybody else, he doesn't pass the eye test. So you've already got a huge problem as the Commonwealth with trying to prove that there was an accident here. The only way you can get there is by a sort of complicated hocus pocus to try to, conjure up some objective data that would support your version of events. And so we saw a lot of obfuscation and stuff like that around the data because it's got to be hocus pocus. If we look at the data too closely, it doesn't help our position. You look at it too closely, you realize, oh, he locked the phone after supposedly this stuff happened. Doesn't make a lot of sense. So they have to overcomplicate it with data just to argue that they have data. But in many ways, their case is very simple one. It's just, I hit him 2.0. That's really the case again. Karen said so, therefore. Ninny, objection. Last year's didn't allow her to say dog. I kind of remember that. She wasn't, I think she did though. I mean, she did. Like he described it accurately. They were caused by an animal, possibly a large dog. Pretty sure was how she phrased that. She wasn't allowed to testify last year that they weren't consistent with a motor vehicle collision. She did get to say that this year. Not the injuries that you see with a motor vehicle collision. I don't remember specifically that she wasn't allowed to say dog because she did ultimately say dog. So I'd have to go and double check that. Joy Daly, pig DNA, dog traits. Certainly an inference, isn't it? And so that's the question. Is that in and of itself enough to justify? Do you want to bring that in? Do you want to spend the time, get the witness out there, testify it was pig DNA that they found on the swabs that were taken from the holes on the outside of the hoodie sleeve? Maybe. Does make sense, doesn't it? Dog ate a dog treat. Dog's got pig goo all over its teeth and mouth. Bites something. Yeah, I could see that being a transfer scenario. Just leave that pig DNA and perhaps a small amount of keratinized tissue, perhaps. Edward Kirkpatrick, do the right thing versus tell the truth, not the same. Yeah, that is a good point. This instruction that she got from the commissioner of the Boston Police Department. Either one of these things are not things that you should have to tell. You shouldn't have to tell a line officer. It should raise questions why you were telling the line officer this anyway. And then further, why are we saying that in this particular case? What drove that in this particular case? Really, these things should both go without saying, shouldn't they? We should be able to take it on faith that the officers are both doing the right thing and telling the truth. But since we had this specific conversation, yeah, there is a difference between tell the truth and do the right thing, isn't there? Do the right thing. Do the right thing. Doesn't that sound like the kind of thing you say when you want somebody to do the wrong thing, but to justify it to themselves as they're doing it for the right reasons? Do the right thing. Sounds a lot like do the wrong thing, but tell yourself you've got a really good reason to do it. Getting back into those Aristotelian virtue ethics, right? Aren't you the good guy? You're the good guy. So go ahead and do the wrong thing because you're the good guy. You'd be doing it for the right reason. Not quite the same thing, is it? The right thing is a little bit more subjective and context dependent than the truth. Good observation there. Well, not bad for the second full day of the defense case. Monday, full day, not a bad day. I think we had some fun. I think we had some fun with some of that. I had some fun with some of that. God, I learned a new word. Pathognomonic. And it's pathognomonic. That G-N-O, pathognomonic. Great word, man. Alessi, he's got the best words. I'm gonna have to write that one down. I'm keeping a little short list of Alessi-isms, the things that he brings up. He uses that vocabulary to build rapport with the witnesses, but also then to kind of call them out sometimes. You familiar with the term confirmation bias? You heard the term mendacity? Doctor, has it occurred to you that these injuries that you're looking at on Exhibit 1 are pathognomonic? Just a way of having that communication that we're on the same page, we speak the same language. It's fun. I learned stuff from him. But we are only just getting started with the showdown between Dr. Russell and Mr. Brennan. And if we go by the pretrial Daubert hearing that Dr. Russell had to endure December and January, December last year, January this year, then there's still quite a lot to come. There is quite a lot to tangle on. But a very different demeanor, huh? He was happy to be mean and rude and snippy with Matt DeSogra. Some reason thought that was an appropriate way to handle that particular witness. But Dr. Russell, why is it? Is it because she's a lady? Is it because she's... Forgive me, Dr. Russell. Is it because she's older? Is it because she's so highly qualified, experienced? I'm not sure, but we can definitely see that at least today, very, very hesitant to be all confrontational, accusatory with Dr. Russell in front of the jury, the way he was happy to be in front of the judge. Happy in front of the judge to imply that she, made stuff up to tailor what the defense wanted. Remember that accusation came out? She was like shocked. Yeah. He would do it not in front of the jury, but in front of the jury, he knows he's got to mind his P's and Q's. You can't just go in and try to beat up on this nice old lady. Sorry again, Dr. Russell. These are just descriptive terms. Trust me, I'm no spring chicken myself. But you can't just go beat up on an old lady in front of the world and think that that's going to go over well in front of a jury. So it seems like even Hank knows that, but maybe we'll get a different mood tomorrow. I don't know. Melissa Garcia was bringing What's Her Name Worth the Risk. It seemed she pissed off Jackson. Dr. Russell was great, and Hank having to apologize was gold. Love you mucho. Yeah, it was fun, wasn't it? Sorry, I didn't mean to be sharp. Yeah, you did. We saw you do that with DeSogra. You just slipped. Your mask slipped a little bit, didn't it, Hank? It's not a very good mask. We can see it. It's like he can't get rid of it. He can't get rid of the smarmy and snarky and self-righteous, bombastic. He can't get rid of it. He's got to build it into his questions if he can't lean all the way into it. Then we're just gonna build in, as your opinion evolved over time, let's talk about XYZ. As far as Dever being worth the risk, I don't know that it is. I don't know that it is to me. I don't know how all this is going to fit together. This may be a question of how do they use it in closing? Because in and of itself, Berkowitz, Higgins, alone in the Sallyport with the SUV, what does that raise for us? Well, it doesn't look good. It's kind of more just in terms of the investigation being improper. Doesn't look very good. Does kind of tend to substantiate the, Higgins and Berkowitz were friends, which was hinted at before in previous testimony, I think with Yuri, but Yuri didn't really know, doesn't really know one way or the other. Well, this witness certainly, not only are they friends, that's why Higgins has an office there. But we already kind of know the investigation was biased. We already kind of know there's issues with connections between the participants. That's what's lurking in the background of the decisions that they made. Was that super valuable in light of how she's getting up there and accusing them of threatening her and accusing her of perjury, and it's just a false memory, and the FBI agreed it was in good faith, and yada yada. I don't know. An easy way to answer this question would be, did I hear about this fact that she was here to elicit? This fact that Higgins and Berkowitz were in the Sallyport with Karen's car for a wildly long time, and it seemed weird. Did I hear that fact in opening? If it's an important fact, I should have heard it in opening. And if I didn't hear it in opening, I'm questioning whether it's an important fact. I didn't hear that in opening. So that's an easy way, a shortcut kind of analysis you could do to say, I'm not sure that fact was really that important, because you were able to get through your opening, make your point without the jury having to know that particular fact. Doesn't mean it doesn't help, but there's a lot of facts that can be helpful that you can't raise everything in a case. You got to prioritize. You got to be selective. You got to remember that the jury has a limited capacity to remember stuff, to take it in, to piece it together. So the more you can simplify it for them, the better. Does this additional fact add to your case or not? I question that. I do. I'm not sure the fact in and of itself was helpful. In many ways, I think her demeanor might have been the most helpful thing that they got out of that. And in all likelihood, they potentially kind of just looked into that. I don't think they called her anticipating she was going to be quite like that. It just worked out in their favor that that's how it was. Well, maybe they did because they knew the phone call came to a hasty conclusion on both ends. So maybe they did expect it. I don't know. I think, what do you guys think? What do you guys think? Was that worth the risk? Was that enough upside to, justify the potential risk of the FBI is now out there, and what might the jury think of that? And defense has been accused of trying to threaten her, trying to get her to get on the stand and lie, and so on and so forth. I don't know. Oops. Joshua Frost, has Dr. Russell mentioned the keratinized tissue? She did not mention the keratinized tissue. The only person that, it hasn't come out in this trial at all. It just was, it was in the last trial for the report on the dog stuff. So I just happened to see it when I was going through my notes from the last trial. Oh, keratinized tissue. I wonder what that is. Look it up. Oh, who knew? It's gum tissue. It's so much gum tissue that apparently they do a lot of experiments about like implants, techniques, and things like that with dogs because the keratinized tissue is so similar. Wild the things that we've learned over the course of this case. But no, nobody's mentioned it. Just me. I'm the only one that's waving the keratinized tissue flag. It's not anybody involved in the case. Z, isn't it prejudicial to Karen that the defense can't mention FBI investigating witnesses, but Bev allows same witnesses to insinuate the opposite with no evidence? Did it get insinuated to the opposite? I mean, Jen said, well, I'd say I did a pretty good job because, as you know, they finished their investigation and didn't file any charges. Well, I'd say on the one hand, Jen McCabe's story is certainly it's very self-serving and may or may not be accurate, and should, in my opinion, open the door to, if the FBI concluded its investigation, how much more that was based on than Jen McCabe's, rather brief interview that she had with them in their kitchen after she made all those phone calls and so forth. So they heard that, but I'm not sure that's super damaging to the defense, because if the FBI didn't bring charges, Karen Reed is sitting here in court charged with a crime. Seems like we're kind of implicitly acknowledging the FBI didn't have anything to do with that. FBI is looking at different charges. So potentially maybe helps keep those a little bit distinct. This witness, I don't think she really made it clear at all what the FBI was investigating or why. She talked to them in August of 2023. Defense learned about it and contacted her later and wanted her to repeat it, but she'd already figured out by then it was a false memory. So it doesn't sound like, oh, they were, investigating the defense for soliciting perjury or something like that. It doesn't sound like that, because it doesn't fit the timeline. So I don't, I guess, think that these inferences are really strong enough to warrant like a major opening of the door to talk about the FBI and their role in the case overall. If anything had done that, I think it would have been, it should have been Jen McCabe's answer way back that, I did a good job telling the FBI my story because they closed their investigation. And so I convinced them I did a good job or whatever. That really should have opened the door to what they looked at and relied on and so forth, that did not relate to Jen McCabe's statement. In fact, a long time after that, well after her interview, they convene a grand jury. It's like they just barely get started. Them talking to her was pretty much the starting point. Not the ending point. But it is messy, once that door gets open, because it is really collateral, and it's not supposed to be a trial about what is the FBI investigating. I can sympathize with Bev to that extent. It's not supposed to be a trial about what is the FBI doing. That would be speculative anyway, because we don't know. We don't know. We don't know who they were investigating. We don't know who the target is. We don't know what criminal activity they were investigating. We might have an idea because we understand the context. We understand, oh, you're already looking at a bunch of these same players in the Sandra Birchmore case. Kind of makes sense. You might be interested in other situations where they've gone out of their way to protect law enforcement officers who are under suspicion of criminal activity. That might make some sense, but we don't actually know it. It's just a logical inference. So I can kind of sympathize with, we can't have a trial on the FBI's role in the case. I do get that. But it's tough, yeah, because now that it's out, what is that going to mean? What kind of inference does that create? I think it could really go a lot of different ways, just depending on what the jury's thinking. So tricky situation. Well, guys, hey, we got a full week ahead of us, so plenty of days still to come. Lots of stuff still to see and look at, analyze. A lot of questions to come up. A lot of conversations to still have. I'm going to keep an eye open for that missing witness briefing to see if that hits the internet, because if we get a chance to look at that, maybe talk about that tomorrow morning before we get back, I would like to do that if that's available. If not, so be it. But we'll see if anything else gets filed in the meantime, or if we get to learn anything else in the meantime. The impounded or the unimpounded motion for the missing witness stuff, we'll be interested to see as well. See if there's potentially redaction of grand jury stuff or whatever that would clue us into what are they talking about, who's at issue and stuff. Redaction should be minimal, right? These are public records, just the stuff that for whatever reason we legally aren't allowed to see. Rotorman Dan, Bev showed her true colors again. Biased Bev. Well, she is what she is, you know. And at some point, you can't hide the core of what you are. And I think the core of Bev Cannone has made itself very clear in this case. She doesn't want Karen Reed to have an easy time. She wants it to be hard. I mean, why that is, I think we still would have to speculate a little bit. Does she hate Karen? Does she hate Karen's lawyers? Does she think Karen's guilty? Does she think Alan Jackson is showboating? Does she hate them for suggesting that she's biased and has an improper contacts? We don't know. We don't know why she is the way she is, but the basic nature of what she is as somebody who bends over backwards to rule for the Commonwealth when she gets the opportunity, doesn't apply the same reasoning to both sides, doesn't give the same grace to both sides. It is what it is. We've seen it. We've seen it. We keep seeing it over and over and over. So Helen Jarrett. Helen Genist. Sending in a couple of super chats here. Thank you so much for that, Helen. Appreciate your support. Nora says, love your music. Can't find it on Shazam. Share, please. The music is on StreamYard. I assume that it is unique to StreamYard. And they just, license it to us to use for this purpose. So I have no idea who the composer is, what the source is, or anything like that. Just look into StreamYard, I guess. And maybe they'll be able to tell you who or what it is. But my expectation is it's unique to StreamYard so that they don't have to copyright clear it in order to let me use it. It's just easier that way. So it's something that they commissioned or something like that, but belongs to them as far as I can tell. I'm glad you like it. Hey, that's good to know. All right, guys. Well, we're gonna call it a Monday. Call it a Monday in the books. Not a bad day. Not a bad day. Plenty to come still with Dr. Russell tomorrow. Are they going to work out a full day across? I don't think so. In general, so far, Hank has not had quite the stamina for cross-exam or for, confrontation, I guess, that the defense has had. We're still very early in the defense case, of course, so they haven't had the opportunity to really try to cross very extensively. But seeing the demeanor shift between the voir dire, the Lanigan hearing with Dr. Russell and the way he's presenting to the jury right now, if that continues to hold, then I just don't think he's going to have nearly as much to work with. He's not going to have as much to go into. He's going to have to try to show her opinion changed. Not clear that it did. If it did, is it in some material way? He's gonna have to try to demonstrate that. So he's got to go home tonight, do his homework, get her prior statements up, show me exactly how these are inconsistent, and then let's revisit that. Maybe challenge her with some of what he expects his own doctor, Crosby, to come in and say, set up Crosby as the counter expert. He's written a book on it even. You hadn't even read his book, that kind of stuff. But just substantively, don't know that there's a massive amount to work with. So don't know if we'll see a full day cross of Dr. Russell. I'm not sure that she's that important a witness anyway. I mean, it helps. Obviously, dog bite is inconsistent with the Commonwealth theory. So if you can challenge her, it helps. But is she going to be, say, more important than Arca? I tend to doubt that. I would think he's going to want to save most of his ammo for dealing with Arca. But we'll just have to see, guys. Helen, thanks so much for another contribution. Really appreciate it. So we'll see what we get tomorrow, guys. And I think that's going to give us a little bit of a preview of the vibe that we can expect perhaps going forward. We'll just have to see, though. We'll have to see if he's comfortable being snarky and rude with Desogra, then I have to think he's going to be comfortable being snarky and rude like that with nice Dr. Wolf, maybe nice Dr. Rentschler, those guys from ARCA. I don't know. We'll see. No hurry it up from Bev today. We did not add to the counter, so we remain, since the defense case has started, with one question about how long you going to be, Mr. Alessi, to the defense, none to the Commonwealth. But we'll continue to keep track and monitor that, make sure that things are being moved forward in an efficient way now that we're into the defense case, and finish the Commonwealth's case ahead of time. More than not quite 6 weeks down the road. So cross of Dr. Russell concluding tomorrow, and then who knows? So guys, I'll be keeping an eye out for those new motions that got filed. See if those pop up. We'll have something to talk about before things get started tomorrow. But otherwise, it'll be another full day, and we're going to see what we get. Lots to look forward to with this defense case. Boy, she's talked up Dr. LaPosada so much now. I can't wait to hear from Dr. LaPosada. I wonder if that'll be soon. I don't know. All we can do is just show up and find out at this point. So the rest is in the defense team's hands. So with that, guys, I'm going to go ahead and check out for the day. Thank you very much for joining me. Appreciate all of you being here. Enjoy the conversation in the chat, all of the things that you guys observe, and your names that you come up with. It really never cease to amuse me. But also just the good knowledge, the good insights, the good questions, the things that you guys catch. It's a great, I don't want to say group mind, because it's not a single mind that we have here in the chat. It's much more of like a massive focus group. We get so many different angles on things that any one of us probably isn't going to consider all that on our own. And it's just one of the features of this chat that I really do appreciate. I feel like our chat is a chat that's here because we want answers. We're not watching the trial because we have our pom-poms out and we want to cheer for one side, or we want to cheer for the other side, or anything like that. Or even just because, there's drama and we want to watch a shit show, like some trials, like the Darrell Brooks trial is kind of like that. Like I didn't really bother to watch that trial because why would I? I mean, I know it's just gonna be watching drama. This chat, I feel like you guys want answers, and that's one of the things I value about the contributions that you have. We're just trying to figure out what happened here, trying to make sense out of what's been presented, what we're being told to believe. Why are we being told to believe that? Just a lot of reasons to be skeptical of the official narrative in this particular case. So really value all of the different perspectives that you guys bring. Thank you to the mods, keeping everything running smoothly, even random chaos, like getting kicked out of the stream, getting kicked out of the feed, having to get all that restarted. There are the mods, my bastion of calmness, keeping things smooth and orderly, while it takes me a couple seconds to get things put back together. Thank you for everything that you do to help keep things moving. Some of it doesn't always get visible, in front of the curtain, as you will. So appreciate you guys. Look forward to seeing you again tomorrow. We'll have a great time taking in what tomorrow brings in the case. So thank you. Enjoy your afternoons. And guys, we will be back bright and early tomorrow, 5:45 Pacific. and we'll get ready for day 3 of the defense case. Guys, take care of yourselves. Look out for yourselves. But if you're going to be here tomorrow morning, hey, I'll look forward to seeing you then. Bye, everybody.